So today we're going to talk about trees because why not? So Grandma Karen has a big piece of property up somewhere in the Tennessee hills. She has a bunch of trees and she wanted some of those trees cut down. So she hired Paul Bunyan. Well, no, she didn't really hire Paul Bunyan. She hired Paul Bunyan's agent. And that agent went and hired Paul Bunyan to come cut down her trees. So apparently this is a pretty profitable thing for some landowners when they want to clear their land. They actually hire a lumber specialist, there's a name for it, I can't remember what it is, who comes in and cuts down the trees and takes the ones that are actually worth something off to the mill to do whatever, and the other ones they do whatever with. There's a whole contract, it's a whole thing, it's a business. Well, Grandma Karen and her son Kenny did not like what happened. They didn't like the way it turned out, something along those lines. She's got some kind of hemp farm going on there, and she shut it down. Shut it down. Kicked Paul to the curb. Done. There's a whole breach of contract thing back and forth. This whole entire lawsuit over whether the trees were cut down properly or not. It, it's so bizarre. It's fascinating. And I guess this is probably normal in some areas, but for some of us, this is like, WTF, man. So let's learn about some trees. By the way, her name's not Karen. You guys will get mad at me for calling her that. I can't remember what her name is. She was acting wacky, and yeah. I know, but YouTube likes the word. It gets me ratings. So I sell my soul to the devil. What can I do?
All right, we have one case set for today. Ox Hardwood versus Diane Jackson. Plaintiff ready? Defense ready?
Yes, Your Honor.
My understanding is that I gave you a few more minutes to allow you to go ahead and mark all of the exhibits that have been stipulated to before we started. Has that been done?
Yes, Your Honor.
All right. Anybody wish to make an opening statement? I'll be glad to hear it. I have read through the file, so that helps you.
Good morning, Your Honor.
Good morning.
Michael Abelo of the Nashville Bar. Thank you for hearing us today. With me today is Tommy Fox, the owner of Fox Hardwood Company, Alex Carver, my colleague, and Sydney Franklin, our local counsel. Your Honor, I'll be brief since the court is already familiar with this case. This is a case where my client bought timberland from the defendant, Ms. Jackson, pursuant to an agreement in March of 2018. And under Tennessee law, what we bought was actually an ownership interest in the timber. It's a separate interest adherent to the land, but we owned it as of the date of the agreement. Ms. Jackson had a hemp crop that was on the field adjacent to the timberland, and she did not want us to log while the crop was planted and under harvest. So that was planted in July and harvested in late September. She was concerned about loggers stealing the hemp or otherwise damaging the crop. And we accommodated that request as a courtesy to Ms. Jackson. We did not have to under the contract, but we did. In the fall of 2018, the weather did not allow us to log. And we were dealing the entire time, the court will hear that Ms. Jackson is not an expert in timberland or forestry practices. She hired one. She hired Mr. Jonathan Boggs as her agent. And Boggs was vested with full authority.
I ask, is the rule requested? Normally that's requested before opening statements. Does either side wish the rule?
Yes, Your Honor.
All right, ladies and gentlemen, the rule has been requested. That means that anyone who's going to be a witness other than the parties should go outside of the courtroom, must go outside of the courtroom and remain outside of the courtroom pending your testimony, or not to discuss the testimony of any other witness with anyone pending your own testimony. Counsel, we're under a continuing duty to ensure that the rule is complied with. Did we make sure that they haven't turned the monitors on out in the hallway, have they, officer?
No, I don't think so.
No. You'll just step out to make sure that's not on. All right, go ahead, I'm sorry.
Your Honor, thank you. Mr. Boggs is a key witness in this case and will be the first witness that the court will hear from because he is an expert in the field of forestry and responsible for drafting the contract at issue as Ms. Jackson has the defendant's agent. So any ambiguities in that contract, and we don't think there are any, but if the court found there to be, that would be construed against the defendant. In the fall of 2018 and the winter of 2018, that sort of September, October, November, December, the proof will show was too wet to log, and that Mr. Boggs agreed it was too, on Ms. Jackson's behalf, agreed it was too wet to log. So then again, we waited for that conditions to be sufficient so that we could log without damaging Ms. Jackson's property. That's why you wait for the conditions to be proper. The proof will show that in June of 2019, Ms. Jackson agreed and Mr. Boggs agreed that we could come out and commence logging. A pre-harvest meeting was conducted and Ms. Jackson knew that the logging was going to begin and agreed and did not object to the logging beginning. And the proof will show that logging occurred on a Thursday and a Friday in June for 2 days without any objection from Ms. Jackson. On the third day, which was Monday, June 24th, 2019, at 10 a.m., Ms. Jackson observed the logging at that point and objected. And rather than call her expert, Mr. Boggs, her agent, to say, is there something wrong here? Here's what I'm seeing. This doesn't look right. She didn't do that. Instead, she called the sheriff's department and kicked our loggers off the property and has never since let them back on to fix any issues or remediate any alleged problems, even though we don't think there are any. And moreover, she's not returned our money. She's not allowed us to complete the processing of the timber. And so this is a case about conversion of our property, of the timber that we bought and paid for, and that she prevented us from removing based on a mistaken belief that there was something wrong with the logging. And you're going to hear about logging, you're going to see a video about logging. All the experts in this case, including Ms. Jackson's own agent, are going to say what you see there is proper logging practices. And to prove that, Ms. Jackson last week made a complaint to the Tennessee Department of Environment and Conservation that there was something wrong with her land. And the proof's going to show that the department came out and found no issues. And so logging is messy and it could look bad to a layman, but that's why we have experts. And that's why Ms. Jackson had an expert and she went off, and rather than rely on her expert, she stopped the logging, and that's why we're here today. Thank you, Your Honor.
Mr. Madison Gill.
Yes, Your Honor, this is a case that's going to turn on questions of law, compliance with the contract, and it's going to come down to the extent to which the plaintiff of this matter was complied with the agreement that was executed between the parties. The proof will show, Your Honor, that our client's in dispute about this hemp allegation, and furthermore, she disputes that the weather throughout the entire calendar year after the contract was executed, that prevented any kind of cutting, and that's going to be an issue that the proof will bear out. But beyond that, Your Honor, the various exhibits and evidence that the parties have stipulated to will show that this wasn't a simple agreement to buy this timber for X amount. There were conditions, there were requirements, there were procedures in place to make sure that the cutting was done properly. Those were not adhered to. There was damage caused, and then after these issues were brought up by my client, who admittedly is a layman, there was no offer of addressing these issues or remediation. They're simply told, you have to let it proceed. Beyond that, there's going to be other questions for the courts, whether the express terms of this contract, whether the failure to comply with them by sophisticated logging professionals is justifiable in ordinary practice, or if there's a lapse. That's going to be a key issue here, Your Honor. I think the proof will bear out that my client operated in good faith and worked and tried to work with the loggers and was hindered every step on the way.
Madam Lawyer, you may call your first witness.
Yes, Your Honor, we call Jonathan Boggs to the stand.
And we only have the one bailiff, so you may have to step
Right,
out
go
there
ahead,
and just
thank you.
call your. Well, if you'll step right up here, please, and come around to our witness stand.
Good morning. Could you state your name for the record, sir?
Jonathan Boggs.
What do you do for a living?
I'm the owner of Arbor Springs Forestry, consulting forestry firm.
What does Arbor Springs Forestry do?
We're a consulting firm that does a variety of different forest management activities such as timber sale administration, herbicide work, that type of stuff.
Mr. Boggs, I'm gonna go ahead and ask you to scoot just a little bit closer to that microphone, please.
Yes, sir.
Thank you. We're recording everything that being said.
Okay.
How long have you worked in the forestry industry?
Worked in the industry for 22 years and I've owned Arbor Springs for 12 years.
Who are your typical clients?
Mostly private landowners here in Middle Tennessee.
What do they hire you to do?
So mainly what we do is what I call timber sale administration. So we act as the agent for landowners in the sale of their mostly hardwood timber.
How do you approach that job? How do you do your work?
So I'm usually contacted by a landowner, and then we go out, visit the site, understand what their objectives are, and we, put their timber sale together based on their goals and objectives for the property, and then we market it out through the sealed bid process and send it to all reputable timber buyers within the area that might be interested in bidding on the timber.
Do you have any training or credentials in the fields of forestry and logging?
Yes, sir. I've got a Bachelor of Science degree in Forest Resource Management from West Virginia University.
Do you regularly supervise logging operations?
Yes, sir.
How often do you do that?
5 days a week, somebody from my company is supervising logging jobs.
And when you are supervising logging operations, what are you looking for?
Just make sure that we're basically enforcing the contract for, that was put on that tract of timber. We're out there just supervising the logging, make sure the BMPs are being followed, all the contract terms are being followed.
Use the phrase BMPs. What does that mean?
BMPs is best management practices. It's a term used to deal with water quality issues that may occur during logging operations.
Your Honor, at this time, I move to qualify Mr. Boggs as an expert in forestry and logging practices.
No objection.
All right, he'll be qualified as an expert witness on forestry and logging practices.
Mr. Boggs, turning now to Ms. Diane Jackson. How did you come to know Ms. Jackson?
Ms. Jackson called me in the sense that she had a tract of timber that she was looking to sell. So I went out and met with her and went through the process of talking to her about, acting as her agent through the timber sale administration process.
What discussion did you have with Ms. Jackson at that time?
She just stated that, she had this block of woods behind her house and she wanted to, selectively harvest the timber. And then there was a certain area along their fields that they were wanting to clear cut to expand the areas of their fields. And the day I went out and met with her and talked to her about it, I took a walk through the woods and kind of just see if it was a job I was willing to take. And after that walk, I went back and talked to her again, and we made an agreement that we would go through the process.
Did you talk with her about what the actual timber cutting process would look like?
Yes, I tried very hard to set her expectations of what logging and what timber harvesting was.
How did you do that?
Just explaining to her the process of, there's, I tell people there's 50,000 pound machines taking down 2,000 and 3,000 pound trees. And, as a professor told me in college, there's ugly logging and there's real ugly logging, and you want to keep it to ugly. So I have that conversation with every client I have just to ensure that I'm trying to set their expectations of what harvesting is.
Why do you do that? Why are you wanting to set their expectations?
Just so there's no surprises when the actual logging does start to occur.
What were Ms. Jackson's objectives in conducting this logging?
I mean, she wanted to select cut the property, and a lot of landowners have the same objective. I mean, their income is obviously was a factor into it, but she didn't want the aesthetical value around her house to be jeopardized either. So we tried to walk that line and make them two objectives happen.
Use the phrase select cut. What does that mean?
In terms of select cut, what we do is we go select individual trees throughout a forested area, and we paint them with timber marking paint. And when we bid off those trees, only those trees that are marked with blue paint are eligible for harvest in this case.
Your Honor, I don't know if it would be helpful to the court. I have a list of the exhibits as they're admitted that the court could follow along with, or if that would be helpful, I'd be happy to hand that up. I just have an index.
I had the stack of exhibits being handed to me, so if you want to take it, doesn't matter how you want to proceed, but if you want to start with exhibit 1 and go forward, I have them right here in front of me.
That's what we're gonna do. I have an extra copy of the index if the court wants it.
All right.
Mr. Boggs, I'm gonna have the bailiff hand you a copy of what's previously been admitted as exhibit number 1. You recognize exhibit number 1?
Yes, sir.
What is it?
This is my service agreement when I go into a contract, a timber sale administration contract with the landowner.
Is this your standard agreement?
Yes,
with the
sir.
landlord? And is this your agreement with Ms. Jackson?
It is.
And we, just for time orientation purposes, we've got, what is the date of the agreement?
February 8th, 2018.
And can you relate that to the conversation that you just told the court about?
We previously had this conversation. This came at a little later date, but I mean we got this signed before we went into the full blown contract of getting the timber sold and prospectus out.
So, do you know when you had the conversation with Ms. Jackson that you told the court about?
I mean, I don't know that exactly. I would guess it was a couple 2 to 3 weeks before this agreement was signed.
Did you then go back out and have her sign the agreement?
Yes.
If you'll look at the top of the first page, there's an address listed for landowner Ms. Jackson. Do you see that?
Yes.
Do you recognize that address?
Yes.
What is that address?
That's I believe that's her physical resident, and also where the tract of timber was located.
If you look at Roman numeral 1 on the first page,
Mm-hmm.
it says consultant agrees to perform the following, and the consultant is who?
It's myself, Arbor Springs Forestry.
You have a company called Arbor Springs Forestry?
Yes.
And under Roman 1, it lists 6 responsibilities. Does that summarize what you were doing for Ms. Jackson?
Yes.
If you look at Roman numeral 1D, what does that mean?
That means that Arbor Springs Forestry puts together, once a bid is accepted from described in 1C, we help put together the timber sale contract between the purchaser and the seller of the timber.
And 1D talks about incorporating sound timber management provisions.
Yes,
What
sir.
does that mean?
That's just, everything that goes along with good logging practices is in the timber sale contract. Talks in detail about the restoration of the site, and the best management practices need to be abided by, and just that type of stuff is in the sale contract.
If you look at 1F, it
Yes.
says inspect logging on progress and at the closing of the job. What does that mean?
It means that we're out there being the enforcers of that contract, inspecting what the logger is doing, and we do it while it's in progress, and then do a final inspection, usually a walkthrough final inspection with the landowner.
How do you do it while it's in progress?
We're just out there, once a week at a minimum to check on the loggers, see how things are going, make sure they're doing what they're supposed to be doing.
All right, if you'll turn to the second page of Exhibit 1, did you sign this agreement?
Yes, I did.
And did Ms. Jackson?
Yes.
Do you know if Ms. Jackson had ever worked with a forester before you?
I'm not aware of it.
Was there a survey done on Ms. Jackson's property?
There was a surveyor on the property, yes.
Why was that done?
There was the first initial walkthrough of the property. There was some questioning. There was some questioning in my mind of where the I believe it. I'd have to look at a map, but I believe the north property line. I didn't find evidence that matched up with what I had. So I felt it was a really good idea to have that back line surveyed before we harvested any timber.
Did you arrange for that to be done?
I did. I contacted 2 surveyors and got bids on it, and the one with the lowest bid that I knew and trusted did the survey.
Who paid for the survey?
I initially paid for the survey and was reimbursed at the closing of the contract for it.
All right. Boggs, I'm going to hand you what's previously been admitted as Exhibit 2. And I'll represent you. This came from Ms. Jackson's email. So the first page is the full email, and on the second page we blew it up. So I want to turn your attention to the second page.
Okay.
Are you able to read that?
Yes, I can read through it.
And what is Exhibit 2?
This is an email that I sent it's when we had the timber ready, ready to go out to market. This is the draft timber sale notice or timber sale prospectus that I wanted to send Ms. Jackson for her review before I sent it out to put it on the market.
And we just looked at Exhibit 1, which was your agreement with Ms. Jackson dated February 8th. And what were you doing then on February 10th?
We were getting the draft sale notice ready to go at that time.
Is that a relatively quick turnaround?
I mean, it is, and we had done some work previously to signing this professional service agreement on the track, and it was just one of those things where it didn't just our schedules didn't work out to meet to get that professional service agreement signed. So it was signed before the timber was sent out to market.
If you'll look at that second paragraph of Exhibit 2 and take a minute to read it, and then I want to ask you a question about it.
Okay.
What are you talking about here in terms of the clear cut?
I'm just explaining to her that, basically what a clear cut is. I mean, first of all, and then that I was just breaking down the number of acres of the select cut versus the clear cut. And then I was breaking down the number of saw timber trees that was inside that clear cut unit. And it was basically a third of the number of trees on the entire sale. And I just explained that, those trees are averaging 130 board foot per tree, which is, in terms of that, it's smaller timber. I mean, it was mostly sweet gum. It was a growed up field area that had been let go and growed back into timber over a 40, 50-year period. And that's basically what I was telling her, and then just explaining that to her.
What had she told you about why she wanted the clear cut done?
Just the expansion of the fields.
For what purpose?
To grow hemp.
Mr. Boggs, I've handed you what's been previously admitted as exhibit number 3. What is that document?
This is the sale prospectus or timber sale notice that advertises the timber on the market.
And what is the date of that document?
February 12th, 2018.
Who prepared this document?
I prepared it.
And what is the purpose of this document?
This is just the detail out to the prospective timber buyers that here's what's for sale. Everybody's bidding apples to apples on this. Here's the terms and conditions of the sale, and here's the numbers of the sale. And it's just advertising the timber and the terms and the conditions that go along with the sale.
And is this the document that was attached to your email that we just previously looked at as exhibit number 2?
It is.
And Ms. Jackson received a copy of this document.
Yes.
Did you have any comments on it?
Just that it was okay to get it put on the market.
Was Ms. Jackson in any kind of hurry to go to the market?
Somewhat. I think she was going out of town and wanted to try to get all this squared away before she went out of town for an extended period of time.
You'll look at the first page after attention buyers of standing timber. It says, Ms. Diane Jackson has authorized Arbor Springs Forestry to serve as her agent in the sale of said hardwood timber. Do you see that?
Yes,
Is that a true statement?
that is.
If you'll turn to the bottom of the first page, there's a sale description.
Yes.
What is the purpose of this section of the prospectus?
That's just explaining, how the sales is laid out. It's saying that there's 31 total acres, but there's a select cut unit along with a clear cut unit, and just how the trees are marked, and just the pulpwood trees can be cut and removed at the option of the buyer. It's just explaining, how the trees are marked and how they need to be logged out.
If you'll turn to the 5th page of this document, there's a map there with a color map.
Yes.
And what does the area in blue, shaded in blue, indicate?
That is the select cut unit.
And I think you told the court you would actually go through and mark the trees that were to be cut.
Yes, sir.
And how did you do that?
We use what we call Panama packs, paint guns that squirt, long lasting paint on the trees.
And there's a blue X on that map. What is that?
That's just showing the timber buyers where her home site is.
There are 2 green squares. What are those?
Those are proposed haul roads, meaning roads that to get tractor trailer access to get the logs out.
So the what is indicated by that green dotted line then?
That is a proposed logging deck.
What is a logging deck?
It's an area that could vary in size from a quarter an acre to an acre in which the logs are skidded to, processed with the knuckle boom and loaded on tractor trailers for removal from the site.
And then, so you've got a green square where the logging deck is, and then that, what does that green dash line then indicate from the logging deck?
That's the haul road to get to the logging deck.
You said skid, what does that mean?
It means like a piece of equipment in a standard logging operation is called a skidder, and it gets the tree from point A to point B, being the logging deck being point B,
Point A being where you cut it.
where the tree is standing. Yes.
If you look at that map, there's an area that's indicated in a purple, or I think you said pink on the, to me it looks like purple.
Yeah.
What does it look like to you?
Pink, it
Okay.
looked purplish pink.
Purplish pink, all right.
Yeah.
What is that area?
That is the clear cut area.
And what is that indicating then?
In this case, it was called it was called to cut every stem standing in that area was to be cut and harvested.
If you look back at the sale description on the first page,
Yes.
it's let's see, fourth sentence that starts within the clear cut unit. Do you see that?
Yes.
Can you read that?
Within the clear cut unit, all trees are eligible harvest, but not required to cut. Within this unit, all saw temperature size trees were marked and tallied. Pulpwood size trees can be cut and removed at the option of the buyer.
What does that mean?
That just means, so there's two types of clear cut. There's a commercial clear cut and a silvicultural clear cut. And if you're not familiar with the term silviculture, that's a forestry term. And when you talk about a silvicultural clear cut, you are required to sever every stem for regeneration purposes. This was not a silvicultural clear cut. It was a commercial clear cut, meaning that it was basically the logger's choice to what he wanted to cut out of that clear cut.
At the top of the second page of this exhibit 3, there's a statement towards the end of the first paragraph there that BMPs must be applied throughout the sale. Do you see that?
Yes.
What does that mean?
That just means, there's an entire booklet, a best management practice booklet put together by the Department of Agriculture, Division of Forestry, and if you're familiar with logging and you're a master logger, you understand what those BMPs are, and it's a voluntary thing in the state of Tennessee, but on my contracts, it's mandatory to follow those.
Did Ms. Jackson ask you any questions about what BMPs meant for her?
No.
Did she have the opportunity to do that?
When I sent this document, yes, I would think.
The sentence right above that says the location of all roads, skid trails, and logging decks must be approved in advance by the owner or agent. You see that? Was that done in this case?
Yes. We talked about where they were going to bring the trucks and everything in before they did.
All right. Bailiff just handed you what's previously been admitted as exhibit number 4. What is this document?
That is the best management practice guideline in Tennessee.
Is this the BMPs that were referred to in the prospectus?
Yes, sir.
I'm going to turn your attention to page 22 of this document. What is this page discussing?
This is titled "The Debris and Hazardous Material in Streams and Lakes."
And then it's got a set of guidelines for limiting debris.
Yes.
What is the purpose of those guidelines?
I mean, it's just basically these guidelines are to protect, the integrity of the water quality on a piece of property. And I mean, it's saying but just to put it, just to summarize it, it's saying you can't impede the water flow in a stream by putting logging debris in it.
Are there times in logging when you would put things in the streams?
There are times that, when you're skidding across a creek or a stream, you can put debris in there, skid across it, then it's required to pull it back out after the operation is completed.
Why is that done?
That is done just to keep like mud and silt from directly coming into the flow of water.
So you intentionally put something into the water?
You do, yes, sir.
For what purpose?
To skid across it.
Do you know if that was done here?
It was done in the ditch down there, yes.
Was that proper in your view?
It was proper BNP compliant, yes.
Why?
Because it was a ditch. It was not deemed a perennial stream, but we just thought we would, follow protocol and put it down there, skid across it, pull it back out when we're done, water bar the road, be done with it.
Was there an opportunity to remove the tops that were put in the stream?
No.
In this case?
No.
Why not?
Because the logger was only in there 2 days and did not have time to do any restoration type work.
This document refers to treetops. I've heard those called tops as well. What does that mean, the term tops or treetops?
I mean, the tops are basically the tops of the trees that, are not marketable, will be left in the woods.
And what happens to the tops over time?
They rot back into and become new topsoil.
Is that beneficial to the property?
It is.
How so?
I mean, it serves a few purposes. I mean, it like I just said, it creates new topsoil, and it does help with erosion issues that if you're trying to yank all those tops out, you're going to create more erosion problems.
Mr. Boggs, the bailiff has just handed you what's previously been admitted as exhibit number 5. What is this document?
This is an email that was sent to Miss Jackson and Jordan Beasley, the procurement forester for Fox Lumber Company, just describing, the draft contract being attached, giving both parties time to get this contract reviewed, and then it explains, that when everybody has a chance to review this, we'll set up a date for closing, and at the bottom there, it has the check amounts and how payment terms was going to be addressed when we do meet the close.
We previously saw from exhibit 3 that the bids were open on March 2nd. Is that right?
That's right.
And who was the winning bidder at the auction?
Fox Hardwoods.
And who is Mr. Beasley?
He's the procurement forester for Fox Hardwoods.
What is procurement forester?
His job is to procure wood to get it into the mill to process lumber, essentially.
Have you worked with Fox Hardwood before?
Many times.
Have you ever had any problems with them?
No, sir.
What is your opinion of that company's reputation?
Very reputable companies, been around a long time.
All right, so on March 3rd, you sent a draft of the contract to Fox Hardwood and to Ms. Jackson.
Yes.
And if on this email, it talks about Mr. Beasley cutting checks.
Yes.
Did Ms. Jackson indicate she was in any kind of hurry to get her money?
I believe she was leaving town later in that next week, and she wanted to get it done before she left town.
The second check that's listed is $7,812.40. What is that made up of?
So if you go back to my service agreement, my commission on the sale of this timber was 10% of the gross settlement, and plus the $1,500 survey reimbursement.
That's what we talked about earlier, that you had done the survey and paid for
Yes.
it.
Yes.
And then there's a third item of $2,500, Harbor Springs escrow. What is that?
On my contracts, I always hold what I call a performance bond, in the manner that if a logger pulls the last load of logs out and does not restore the site, we use that money to hire our own dozer operator to get the site restored.
And were these 3 checks cut by Fox Hardwood?
They were.
And the third check, the escrow funds, what has happened to those escrow funds?
It's still sitting in my business escrow account at First Federal Bank.
Mr. Boggs, the bailiff has handed you what's previously been admitted as Exhibit 6. It's a little hard to read, but are you able to review the top of that and tell me what that is?
Yes, that was just Miss Jackson's reply to that email saying contract looks fine. See you tomorrow at 1 p.m.
Ms. Jackson have any questions or comments for you on the contract?
No, sir.
The bailiff has handed you what's been marked as admitted as Exhibit number 7. What is this?
This is the standing timber sale agreement between Fox Hardwood Lumber Company and Miss Jackson.
Is this the same document that you had sent to Ms. Jackson as a draft for her review?
Yes, sir.
And who prepared this document?
I prepared it.
How did you prepare it? Is it based on some form or document you have in your files?
Yeah, I mean, I have a standard timber sale contract that I use for most sales. Some terms and conditions change, but yes, I prepared this as a template.
And if you'll turn to the very last page, there's a signature by Ms. Jackson.
Yes,
Were you present when she signed the agreement?
I was.
Where did that occur?
It occurred in I believe the bank parking lot at First Federal Bank in Burns.
If you'll look at the first page, section 1, entitled Sale of Standing Timber,
Yes.
it says the third sentence says the timber being sold was advertised with the prospectus dated February 12th, 2018, which is attached here too. Do you see that?
Yes.
Do you know whether the prospectus was actually attached when she signed it?
I'm certain that there was a copy there. Yes.
And the prospectus, is that the same document that was previously admitted as Exhibit number 3?
Yes.
That's also dated February 12th, 2018.
Yes.
Looking at section 3, the purchase price, it says the purchaser agrees to make payment to the seller in the amount of $63,124.00. Do you see that?
Yes.
Did Fox make that payment?
Yes.
All right. After this agreement was signed in March of 2018, did Ms. Jackson make any requests of you as to when logging should begin?
Not until we, I called her one time that we were going to go out there and look at it, and she explained that the hemp was in the fields, and so I, talked with Jordan, and we just said, well, we'll get it this fall after the hemp crop is. So that request was sort of made over the phone.
And you said Jordan, is that Mr. Beasley?
Yeah, Mr. Beasley.
Okay. So let me break that down a little bit. You said you called Ms. Jackson.
Yeah, Jordan had called me and said, hey, we've got a contract logger that I'd like to show this track to. So I called Miss Jackson and told her that we was going to come out and show this to a logger. And then that's when we talked about the hemp in the fields. And Jordan said, well, we'll just wait till this fall. So we never made that visit. And I called her back and said, we're going to wait until this fall.
What year did this conversation occur?
What year?
Yes.
2018.
So the first year of the contract?
Yes.
And just to break it down, Mr. Beasley had called you and said, we'd like to bring a contract logger to look at the property.
Yeah, he was just explaining that one of their loggers was about to finish up a job, and they may look at moving him over here to this job.
And you then called Ms. Jackson?
Yeah.
And what did she say?
I just remember saying, the hemp's in the fields. We need to know where they're coming out. And so after that conversation, I just told Jordan, I said, we got to be real careful with the hemp, and she really don't want us coming in them fields right now. And, we just decided that, hey, we'll just wait. She told me, I can't remember the date. I don't know nothing about hemp growing, but she told me the date that the crops were going to come off. And Jordan said, that's no big deal. We'll get it after the crops are off.
So Mr. Beasley said he would come back out in the fall of 2018.
Yes.
And what happened at that point?
We did go out and look at it in I think September. I met with one contract logger out there to look at it, and and it was raining the day we went out there, and he said it's too wet to get in here right now.
Did you communicate that to Ms. Jackson?
Yeah, I told her we were coming to look at it again. I mean, the best way to communicate with her was via phone. A lot of times we just had phone conversations.
Was there any further attempts to log in the fall or winter of 2018?
Not in 2018, no.
Why not?
Just because it rained. I mean, it rained in September. Typically September, October, November are our driest months to perform logging operations, and it was a wet winter. I mean, it was just a wet fall, wet winter through the whole months.
Why would you not want to log when it was rainy and wet?
Because you would just rut up a property and destroy I mean, it would just, you rut it up so bad when it's wet that it's hard to fix it.
So you can accomplish the logging, it just damages the owner's property.
You could accomplish it, but it would not adhere to the contract.
So you would not have allowed logging to occur in September, October, November 2018?
No.
And why not?
Because of the weather.
All right, take me then to 2019.
Okay.
Was logging possible? When was logging first possible?
Well, I went and met a different contract logger in February, and it was wet then, and it's still, I mean, and it was Mr. Jarman this time that I met, and he said, we'll get this timber, we just got to let it dry out.
Did you agree with that?
Yes.
Why did you agree with that?
I just, I said, well, we got to get it out, but I said, we can't do it right now. And when loggers like to go look at tracks that they are going to log on rainy days because they're not in the woods logging. So you go look at the next job on rainy days. And that's when we was out there another rainy day.
You went out in February of 2019 with Mr.
Yeah, I don't know the exact day, but it was in February.
Looking back at the agreement, exhibit number 7. Section 4 on the second page. It says, should restoration work or timber removal not be completed prior to contract expiration due to inclement weather conditions, the purchaser shall be granted an additional period for such restoration equal to the time of the suspension. Did I read that correctly?
Yes, I look.
And,
Yes.
and what's your opinion about whether there were inclement weather conditions that prevented timber removal?
I mean, there were inclement weather conditions.
And did they prevent timber removal?
Yes.
This is your form of agreement that you drafted. You've talked about that, right?
Yes.
On Ms. Jackson's behalf.
Yes.
Does this extension require anything in writing? This extension for inclement weather, does that require anything in writing to extend the term?
Not in the terms of inclement weather conditions.
There's another extension at the top, or another way to extend at the top of that, section 4. It says an additional 6 months may be granted if seller's agent is notified in writing within 30 days of the expiration date. Do you see that?
Yes.
So that would have been within 30 days of March 6th, 2019. All right.
Yes.
Was there any agreement in writing to extend an additional 6 months?
There was no written agreement, no.
Was there any oral agreement?
Yes, I talked to Ms. Jackson about it.
Tell me about that, please.
I mean, just, we just talked, I mean, and it was brief, pleasant conversations that, hey, we're not gonna get in there and tear your fields up. She was like, that's fine, no problem. We don't, and it got to the point where the next hemp crop was going to be planted and she needed to get the timber out before then. That was the next conversation we had about it.
So did you agree to an extension of the term of the agreement?
With who? With Fox?
Yes.
I mean, yeah, verbally we did, yes.
And did you tell Ms. Jackson about that?
Yes, we talked about it.
And did she agree with you about the
Yes.
extension?
Yes, she did not want them in there either when it was wet.
You mentioned the hemp crop was coming in. I assume that's the 2019 hemp crop.
Yes.
And when did she tell you when that hemp crop would be planted?
Like mid-June, I don't know. I mean, the end of June, sometime around that date.
And how did that then impact the timing of when the timber needed to be removed?
We needed to get it out before then, so they could prepare the fields and get the crop in.
That would then indicate a harvest sometime before the end of June 2019.
Yes.
And did that in fact at least start to occur?
Yes, it started to occur.
When it came time for that harvest, was there a pre-harvest meeting on the property?
There was, with myself and the contract logger, and I think Mr. Beasley was there that first initial meeting too.
So that, if you look at section 6 of the agreement, there's a provision about an intention to begin logging operation in a pre-harvest meeting. Did that occur?
Yes.
Was Ms. Jackson aware of that?
Yes, she was.
How was she aware of that?
I believe she was out of town when we first started that initial visit, and then she was not there present for it, but she was aware of it.
Did you make her aware of it?
Yes.
How did you do that?
Phone call.
Did she object to it?
No.
Did she say that the contract has expired, they can't be out there?
No, she agreed to let him out there.
Just handed you what's been admitted previously as exhibit number 8. What is this document?
This looks like an email sent on May 31st,
What year?
2019. And it's just explaining to Ms. Jackson, that this is right before I believe the logging occurred, like when we were fixing to set up the pre-harvest meeting.
You said she, in the third sentence, it says, I understand your concerns about the extension and not wanting to get in there while your crops are planted, as we discussed earlier this week. Does that help orient you as to when you had your discussion with Ms. Jackson?
Yes.
And what the concerns about the crops being planted, what has she told you about those concerns?
I mean, basically, she was, two things were, obviously the equipment tearing up the crops, and then she was thinking that someone that was going to be on that property would steal crops.
Steal the hemp.
Yeah.
Did she tell you that?
She mentioned that, yes.
Did you get a response to this email?
I don't recall.
And you testified earlier, she agreed to the extension reference in this email.
Oh yeah, and we told her that we would, Shannon said he was going to work, long hours to get the job done quickly, and she agreed to let us do that.
Turning back to Exhibit 7, which is the agreement, the standing timber sale agreement, I want to turn your attention to Section 7 of that agreement.
Section 7.
Yes, on page 2. Tell right to suspend logging operations.
Yes.
Who under the agreement had the right to suspend logging activities?
The seller's agent, being Arbor Springs Forestry.
That's you.
Yes.
Did you ever, in your judgment, believe that logging should be suspended?
Yes.
When did you did believe that?
Well, I mean, I believe the start of the logging was suspended, especially when Shannon and I met in February. I said, we can't get in here right now. But after the logging started, no.
If you look at this provision, it says you can suspend due to inclement weather conditions. So that's what you just talked about.
Yeah, that's what I
couldn't
was.
even start.
Yes.
And then it also says you can suspend due to poor logging practices. You see that? Did you ever determine that there were poor logging practices done by Fox or Jarman?
No.
Do you believe there were poor logging practices done by Fox or Jarman?
Absolutely not.
Why do you say that?
I mean, it was just a typical logging operation. Shannon was doing a great job out there. He was right on track to finish it in like a week, and everything was going as the contract specified.
You've mentioned Shannon and Jarman. Who is Shannon?
Shannon Jarman was the contract logger at Jarman Logging.
Have you worked with Jarman Logging before?
Many times.
What is your opinion of Jarman Logging?
He's very professional, very good logger.
He did a good job on this job as well.
Yes.
Looking at paragraph 8 of the agreement, the restoration of the site upon completion of logging operations. When is the site supposed to be restored?
Towards the end of the operation.
And was there an opportunity to restore the site in this case?
No, sir.
Why not?
He only logged 2 days.
And why was logging stopped?
Ms. Jackson, I believe, filed a restraining order against Mr. Jarman to move his equipment off the property.
Turning to the third page, section 9. 9A says only trees under the terms of this agreement shall be cut. Do you see that?
Yes.
Did Fox or Jarman violate that provision of the agreement?
No, sir.
Did they comply with it?
They complied with it.
The next sentence says due care must be taken to protect the leaf trees. Do you see that?
Yes.
Did Fox and Jarman comply with that?
Yes.
Section 9B says trees not designated for sale in this agreement shall be protected against unnecessary injury. Did Fox and Jarman comply with that provision?
Yes.
Section 9C talks about the roads be used to the fullest extent before new roads are created. Did Fox and Jarman comply with that condition?
Yes.
9D talks about trees cut being felled on the premises of the seller only. Did Fox and Jarman comply with that condition?
Yes.
10 talks about fires. Was that complied with?
Yes.
11 talks about litter. Was that complied with?
Yes.
Number 12 talks about insurance. Were you provided with a certificate of insurance from Fox?
I had copies on file. Yes.
13 talks about a performance bond. I think we've already talked about that. You were provided with a check for the performance bond.
Yes.
Are you still holding those funds?
Yes.
Just handed you. It's been previously admitted as exhibit number 9. What is this document?
This looks like an email that I sent to Miss Jackson to make arrangements. She wanted her son to be with us when we went back out to inventory the standing trees.
What was the purpose of that inventory?
We was trying to make, I was trying to make this thing not end up here today and make it work. And I was just going out of my way, I thought, to go back out there and inventory the trees that were still left on the property and come up with an agreement of an agreed upon price that, the Fox Hardwoods agreed that, they would give the money back for the remaining standing, or if she would give the money back for the remaining standing trees. And I was, in this case, I was sort of a third party bias opinion to inventory these trees and come up with a fair market value.
This was after the logging had been stopped by Miss Jackson.
Yeah, a couple months after, I think. Yeah.
And it would then inventory what was left that Fox has already paid for but not been able to retrieve.
Yeah, the remaining trees with blue paint on them that were standing.
And did you at some point go out with her son Jeff to do that inventory?
Yes.
Your Honor, at this point, we're going to play the video, which has been previously admitted as Exhibit 10.
Just the same you're gonna play, but we have the video here as an exhibit.
Yes.
You're gonna play a copy of.
Yes, Your Honor. And I may ask Ms. Franklin to stop. Yes, please. At certain points.
This is the access road that they.
Can you recognize the voice of the person on that video?
I believe that's her son, Jeff.
And from the video, can you tell what time of year the video was taken?
It appears to be fall time with the leaves changing colors, and so I would guess October, November.
To get down to, I guess, back into the woods that, so, instead of what we agreed on, it went down from both sides. They decided to cut a trail to go straight around all the way through the property. And actually had to clog up this creek down here so they could get over it. You can see they just cut wherever the hell they wanted and left everything. There was one tree in there they wanted, they cut everything around it to get to it.
Mr. Boggs, based on this video, do you have any opinions or observations?
Well, the observation when the video started, that was up there in the commercial clear cut area. and that's where the logging deck was as well. It was up on top of the ridge, and this road that he's walking down, you begin to get into the select cut area there.
He said on there that they took anything that they wanted. Do you agree with that?
No, not at all.
Why do you say that?
I mean, they took the trees that were eligible for harvest is what they took.
There's trees down everywhere. That's actually the back of our house up there on the hill. That's how close they got. And this was supposed to be just a select cut, just picking out the old ones. And this is the creek they dammed up, completely dammed this creek up. It's a natural.
He talks about the creek being dammed up. Do you agree with his observation there?
No,
Tell me why.
that's not even a creek. It's not considered a perennial drainage in this case. So,
And we talked earlier about putting tops in the water bodies. Did that occur here?
it did occur there.
And if Fox and Jarman had been allowed to finish the job, what would have happened with those tops?
Those tops would have been pulled off to the side and further up on the ridge
And why were those tops put in there in the first place?
to skid across that drainage.
Rain all the way up, goes all the way up to the top. You can see now it's just jammed up. This is what they bulldozed and filled in.
Pause there. Did you walk the creek with her son Jeff?
Yeah, we combed over the whole property, finding the standing trees.
And it looks like there's some sort of debris or can of some sort in the creek. Did you observe that when you walked the property?
I don't recall seeing that. No.
Nice oil cans they left in here. From the workers, I guess. Look at that dumping out. Nice. From the machine.
If you had seen something like that when you walked the property with Jeff, what would you have done?
I mean, if I see that on any of my logging sites, I would have immediately picked it up or went and told the logger, hey, you need to get down there and get your trash picked up. And I would have, if I'd have seen that day, I would have picked it up, just knowing that when we were out there looking at the additional standing trees.
But they filled this in so they could come down this path and traverse this to get over the creek. And now the water was so nasty afterwards. It was just cloudy and tons of algae, just really messed up.
Do you agree with that the water was nasty and full of algae?
I didn't see any algae out there.
And we've established that the logging occurred in June, and Ms. Jackson stopped it. The day it stopped, did you go out to the property?
Yes.
When did you go out?
It was mid-morning. I know it was a Monday morning. I'm not sure the exact date, but it was a Monday morning.
And what did you do when you got there that Monday morning?
I pulled in, and there was Miss Jackson, Jeff, and Shannon was still there, and a sheriff's deputy was there, and I went over to see what was going on.
And what did you observe about how the logging was going?
At that point, the logging was going fine. They started on a Thursday, I believe, and logged a Thursday and Friday. And I'm assuming that's, Miss Jackson and her son got back from out of town, and Monday's when all this took place, and I was called and told that I need to get out there immediately.
Did you observe any improper logging practices when you were out there that Monday?
No, I didn't go down there at that point.
You went back in August?
Yes.
And you didn't see any of this debris that
No.
is shown in this video?
You can see how they filled that creek in right there too. See how that creek slipped over? We'll walk over there. Now we have erosion issues from where they filled that in. And now you can see it just runs, it's completely diverted and really messed up our creek. It's a natural spring that feeds it. And you can see they just fill in, cut, and block anything they want so that they have a path. And it goes all the way through wherever they went. They just bulldozed everything to get to. We weren't even supposed to be able to see what they cut. They were going to cut and then drag what they cut out. None of this, look. None of this where it's just stripped. Left trees where they cut everything, just mauled everything down to get to whatever 2, 3, 4, 5 trees they needed to get, and just demolished everything around them.
We can turn that off. Mr. Boggs, based on that video, what are your observations as a professional in this field?
I mean, what he's saying is they're mauled everything down. I mean, what I'm seeing there is there's still marketable log trees left standing for the next cycle of harvesting. And I can also see, I mean, this has been several months after the logging occurred. There's already natural regeneration starting for the next, the next stand of trees and that's what you want from a logging standpoint.
When you look at this, what is your overall opinion?
I mean, it's a good logging site. I mean, the regeneration is already occurring, and Mother Nature's taking care of it.
Obviously, her son Jeff looks at it and sees it differently.
It's in the eye of the beholder, yes.
And as far as you know, does Jeff have any training in logging?
Not that I know of.
All right, we can put the lights back up. Hand you what's been previously admitted as Exhibit 11. What is Exhibit 11, Mr. Boggs?
I believe this is an email I sent to Ms. Jackson explaining, the standing trees that I found remaining on the property after the second visit when Jeff was present with me.
So your visit with Jeff would have occurred before September 12th, 2019?
Yes.
And what methodology did you use to determine which trees were remaining?
I mean, we found the trees that still were standing with the paint on them and re-inventoried every single tree and then come up, use the same dollar amount that when the trees were purchased and come up with a fair market value of those standing trees.
All right, I'm going to hand you what's previously been admitted as Exhibit 12, 12. Is this Exhibit 12 a letter that was attached to email we just looked at it as Exhibit 11?
Yes.
And if you'll turn your attention to the second page, what is that? Second page there.
That is, the second page is the original number of, the original volume summary from the timber sale.
And then what is the third page?
Third page is the remaining standing trees that were on the property. The volume summary of those.
And what did you determine the remaining value of those trees was?
$39,821.59.
And had Fox Hardwood paid for these trees?
Yes, they have.
And had they been able to harvest these trees?
No.
You made a proposal that on the first page that Ms. Jackson buy the trees back for $42,779. Do you see that?
Yes.
How did Ms. Jackson respond to that?
She didn't feel that was a fair. She didn't feel like she had to pay anything back.
Your Honor, I have no further questions for this witness.
Before we begin cross-examination, let's take our morning recess. We'll stand in recess for 15 minutes.
All rise.
Some documents to pull up on the screen from time to time. With the court's permission, I was wondering if I could cross-examine from the table here.
If he can see you, that's fine with me. I don't really have a problem with it. Can you see him from where you are?
Yeah, I can see him.
And if
Is
you
that
need me,
microphone on?
hello? There we go.
All right.
Yeah. All right. So good afternoon, Mr. Boggs. My name is Philip Massengale. I represent Ms. Jackson this matter. How are you doing?
Good.
Good deal. We've heard your testimony today, so I got a few questions, see if you could clear up for me. Firstly, you testified earlier that your normal practice when you represent people, landowners, and you work with logging companies, is you come out to the site about once a week to make sure that the best management practices are being followed, right?
Yes.
So it's about once a week that you come out to investigate, to see what's happening and all that.
Yes.
Okay. And out of that, let's see, and you also mentioned, best management practices are promulgated by the Department of Agriculture and the Forestry Division.
That's correct.
Familiar with them. Good deal. So now we talked a little bit earlier. We talked about page 22 with the, before we move on to that, let me slide over. I'll pull these up so you can see them. I just wanted to shift back for a second to the timber sale notice, and I've got it pulled up here. Previously admitted to evidence. You recognize this document?
Yes,
And do you have a copy there that you can look at?
I do.
Good deal. It's great. Let you pull one up just in case that's easier. All right. So now I scroll down here to the map right here. You see that, sir?
Yep,
Now, who prepared this map?
I did.
You prepared it, and you explained earlier the blue is a selective harvest area, and the pink teal is supposed to be the clear cut.
Yes.
Okay. So, and you mentioned, see this will go everywhere but on there, so it's not gonna work. Those two green squares there, those are landing sites you mentioned earlier are for pulling off or the proposed deck area, right?
Yes.
All right. And then those little dotted lines are supposed to be the roads out of the means of ingress and egress to the highway, right?
All roads, yes.
All roads. So you prepared this and you walked the property, right?
Yes.
So in it, we saw the video, the disputed stream versus wet ditch area. Where is that on this map?
Just west of the easternmost log deck, proposed log deck.
So you said just east?
Just west
just
of the easternmost log deck.
I apologize, sir. So just west in the blue selective harvest area, right?
That's right.
Okay, so when we were watching that video, with that of everything that's going on, that was actually in the selective harvest area, right?
The beginning of the video was not.
But all the parts with the stream around it were though, right?
That was in the selective area, yes.
Okay. And in this, so you got two of these, let's see, decking areas, right?
2 proposed decking areas, yes.
Two proposed. Now, how many were actually constructed?
1,
One. Okay. And which one was that?
the furthest east one.
Okay. Now you had discussed how timber was going to be hauled out of the cutting area, though, right? With Ms. Jackson.
I mean, yes, we had discussed that.
And had there been discussions about two separate hauling, roads?
She's seen that map
Did you see that map? So she relied on this map.
in our conversations.
She relied on this map and your conversations, and my client believed that there were going to be two hauling roads, right? That's your testimony?
We never did use the second hauling road.
Oh, you didn't?
No, them were proposed,
Oh,
is what those are.
but my client saw this and spoke with you and believed there were going to be two.
She never asked if there were going to be 2.
But that's, what she had, was she ever notified by you that the map that you'd given her, that was not going to be followed?
We talked about that on the phone, how we were going to come in and get that timber, yes. And I told her we were going to be able to get it all from one section and she wouldn't have to see that other one from her house.
All from what section?
If we would have went into the west, on her west property line, it would have been right in view shed of her house. And that's the reasoning that log deck was never, it was proposed that if the logger wanted to set up there, he could have. We chose to use the other log deck.
So, do you remember when this conversation was with Ms. Jackson about the decision to go with just one log deck?
It was probably around the time that email was sent, about it was probably about the same, the week before we was going in there to log, that week.
Around in there, well, could you clear about, rough estimate, when do you think that was?
The end of May, 1st of June.
In May, and where was that conversation?
It was a phone conversation. They were out of town. She was out of town.
In May, and was that the only thing that you guys spoke about?
We talked about that we were going in there to log. She said, okay, we just need to have it out before the hemp crop gets put in.
So when was the decision made to only go with one deck area?
When we went out there to look at it with Shannon the second time, and he said, hey, I can get all of this timber from right here.
So it was decided in February of 2019?
No, it was decided, we did not decide that in February 19. We decided it at the pre-harvest meeting right before the equipment was pulled out there.
Okay, so the pre-harvest meeting right before equipment was put out there, so beginning of June?
Somewhere around that time frame.
Beginning of June of 2019?
Somewhere around there, yes.
All right, so got a conversation. So going forward, so then that decision was made. Let's see. Now you also testified earlier about the location of the logging road. So I know these little green marks here, those are haul roads. Now, what do you mean by logging roads, though?
That is a logging road, the green road.
Well, as far as what we were seeing in the video, where there are these, I guess you'd say, skid trails.
That's a skid trail.
Now, when was the decision made about where the skid trails would be, their distance, length, all that?
That was made when we went out there to start logging. I mean, you use the roads in the most logical place to put them.
All right, and let's see. And you testified earlier that was at the pre-harvest meeting. You guys orally discussed it, right? About where the skid trails were going to be.
Absolutely.
Now, was there ever a plan condensed to writing about where they were going to be?
No.
Okay, just kind of decided. So how? So if it wasn't condensed to writing, how did the boots on the ground know where and how to place it?
Well, I may take that statement in the timber sale contract. If you read, it said, or in the timber sale prospectus, it says that the I can read it exactly if you give me a second. It says the location of all roads, skid trails, and logging desks must be approved in advance by the owner or agent, and I approved them.
You approved them.
The owner was not there to approve them. She was not going to walk down in those woods and approve any roads.
But you, this was at the pre-harvest meeting. She was out of town, so you didn't have an opportunity to discuss with her about where they were going to be placed.
We were told to get in and out as quickly as possible, and that's what we were doing.
In and out, all right. So you guys did that. So, and we're going to talk about, best management practices for forestry here in a little bit. But you're familiar with the rules promulgated by the state, these best management practices, correct?
I had a part in writing those rules, yes.
Oh, wow, yeah. I'll have to talk after this. Yeah, that's awesome. So in looking at writing the rules, so you're intimately familiar with the rules, the corresponding regulations passed on Section C, all that. So can you tell the court if there are specifications called for by the BMP for the placement of skid trails?
There are, and you understand that BMPs are voluntary in the state of Tennessee, right?
Oh, I do. If you could just answer the question,
Okay.
because they're called for in the contract, so I'm
But
asking.
yes, there are ways that they describe in that BMP pamphlet of how to build skid trails.
Are you familiar with them?
I'm familiar with them.
Could you summarize them for me?
I mean, it talks about the slope, the grade you need to put the skid trails, and how they need to be reclamated once the logging operation is complete.
All right. So you guys had a pre-harvest meeting. You made these decisions, and there's these rules. You mentioned slope, grade, scale, all that. Now, how did you evaluate the land to make sure it complied with all these rules?
I mean, Shannon and I were standing up there on the ridge. We said, right here is the most logical place to put this road across, that we can get all this timber on the western ridge, and we can skid it right back across here and use one log deck. And it was not anywhere near over a 40% slope.
It was just, kind of eyeballing it, looking, what seemed to make
Yeah, I
sense.
did not get my clinometer or reloscope out to lay the road out, no.
No trigonometry
I'm not
done?
an engineer, no.
Yeah. So, all right. Well, now in it, so you guys made a decision based on just what seemed to make sense, just from lay of the land, just from sight. It was pre-harvest meeting. There's nothing condensed to writing. And then you guys decided to go forward from there.
Yeah, Shannon's built thousands of logging roads. He knew exactly what he was doing.
Okay. And, you testified a little bit earlier about still continuing on the best management practices and the impeding of a stream or any affluent, channel. So could you tell us now the best management practices, what does it say about the building of any kind of obstacle in a stream area?
You can lay debris in a stream to skid across it, and then pull the debris out of the stream after crossing.
But the best management practices provide that it should be avoided if possible, right?
It just talks about how you can do it.
So let me see if I can pull this up. It's page 17 of that. So let's see if I can get that just to clarify. You are the expert. So I got this stream crossings. Can you take a look at that, sir, for me, sir?
What page is that?
That's page 17 of the best management practices document.
Okay, I got it pulled up here.
All right, well, you just testified that it prescribes how to do it, but nothing about it being avoided. If you could read that first bullet point for me, sir.
Avoid or minimize stream crossings.
And what's the next sentence there?
If crossings are unavoidable, roads should cross streams at a right angle if possible.
Okay, so we have that. So the best management practices, provide that any kind of crossing should be avoided and should only be done if unavoidable, right?
That's what that says.
Now, here, you got to see the video clearly, and you testified that we had obstacles put in place for a ski trail to go across the stream. So that was constructed here, right?
Absolutely.
And now, why was that unavoidable?
Because we were going to use one log deck to get all the timber out.
You're going to use one log deck to get everything out. So that was, everyone decided to do that. Now, had the parties proceeded with the plan that was included in the prospectus and as previously communicated to my client, would that stream crossing have been unavoidable?
If the logger would have chose to do the second deck, you would have still had to get into the stream, but you would not have had to have that main skid trail across the stream.
Because, to clarify, that's a topographical map. The low point in that blue section, you can see that's the direction of the stream, right? So everything to the east of the stream can be caught by the east loading deck, and everything to the west by the west deck, right?
Yeah, and I'd also like to make a comment that that is not a stream. It is a crossing. It's a ditch. I think it's been deemed not to be a perennial stream.
Right. But this geographical oddity, this spot right there, it would not have had to have been traversed if the original loading deck plan had been followed, right?
That is correct.
I just want to slide through here a little bit more. We've got the crossings a little bit. Let's see, going through William, through, trying to get collected. Okay, I want to move forward a little bit real quick. Okay, so moreover, while we're looking at this, we talked about the rules for the skid trail. I think you testified about that. It was just kind of decided there. Let's see. Across stream. Okay. I'm sorry, trying to get myself disorganized here. Illustration. So tell us a little bit, you had testified earlier that when you're at the property that you didn't see any oil cans or anything out there, right?
I did not.
You did not. Now, had there been oil cans though, how does that comport with the best management practices?
I mean, it doesn't say anything about litter in the best management practice being on a logging site, but it is my rule that no litter, and that is a pet peeve of mine. Like if there's any oil cans, pop cans, whatever out there, that is absolutely a no-go on any of my jobs.
Yeah, I'm going to direct your attention to page 23 of the best management practices, if we could. You can read that first bullet point out for me.
Prevent oil and fuel spills.
Mm-hmm. So yeah, so your policy comports with the best management practices. Yeah.
Yes.
So the rules do provide that that's an issue there. And if we could go forward, if you could read a little bit more of that for me.
If a spill occurs, clean up all spilled materials and contaminated soil and dispose of both properly.
And that goes on from there. So we've got that. So I'm going to circle around. We'll come back to that here in a little bit. I want to kind of walk through time a little bit. So let's start in the beginning. So you have met my client, Miss Jackson, and you guys discussed this timber, sale, right?
That's right.
All right. Now, and in it, you guys had conversations. My client expressed that she was interested in you specifically because of experience, and that you explained that the cutting could be healthy, could be beneficial for her property, right?
That's right.
That's right. And now, when you went through it and explained, what representations did you make, though, about how it was going to be handled and the condition of her property afterwards?
I mean, I think I use my motto that I always use. There's ugly logging and there's real ugly logging. And you've got to, there's gonna be treetops, there's gonna be debris left. That's part of it.
So you guys, enter into professional service contract, and then there's the prospectus, and then the bidding process, and then the timber sale agreement, and then that's you guys execute the contract. Now, what further communication do you have with Ms. Jackson after that contract is executed, March 6, 2018?
I mean, we talked on the phone a few times about, a couple times, Jordan Beasley, Mr. Beasley called me and said, hey, we might get a logger out there, in a couple weeks. I called Miss Jackson, said, hey, I'm gonna bring a guy out, show him your timber. Just pleasant phone conversations.
And roughly when were these conversations?
I mean, I know one of them occurred in, I know it was probably July somewhere.
Of 2018?
Yeah. Larry Wood was gonna come out and look at the site.
And who's Larry Wood?
He's another contract logger that was finishing up a job, and they were thinking about putting him on that job.
And what happened there? Did he not come out?
We looked at it, and that's when the hemp conversation came up with Ms. Jackson, and he said, we just, Jordan just said, we won't do this right now. We'll just wait till the fall.
So yeah, do you, I want to ask about that, but before we do, before we move to that, July 2018, what other time did you communicate with Ms. Jackson?
I mean, maybe September, October of 2018, somewhere in that range.
Uh-huh.
I don't have a phone record of it all, but
About how many times did you guys communicate?
probably 3, 4, 5 times.
3, 4, 5 times, and that is on the phone the entire duration of your.
And I also talked to her son a time or two about it as well.
Yeah. Jeff can be, yeah, he's a trip. Yeah. So 3 or 5 times over the duration of your dealings together, right? On the phone.
After the contract was signed, yes.
3 or 4 times after contract signed, on the phone. Got it. Okay. So I want to talk a little bit. Now, something you mentioned earlier, I just want to clarify. Now, you mentioned that Ms. Jackson said that that when you guys came out there with Jordan, Mr. Beasley, you guys looked at everything, and you testified that Ms. Jackson was concerned about the hemp crop, and she was talking about you guys going around on the edges to be careful and to be careful with the hemp, right?
Well, that and it was mentioned that she didn't want anybody out there stealing her hemp crop.
Didn't want anybody stealing the hemp crop. So yes, you mentioned then that Ms. Beasley decides a professional courtesy. Hey, she seems uneasy about this. We're just going to delay, right?
That's pretty much it. Yeah.
So she had some concerns, and Ms. Beasley chose not to proceed. Ms. Jackson didn't come out there waving arms saying, well, there's a hemp crop, nobody can set foot, right?
No, I mean, it wasn't like that.
Now, looking at all of that, let's see. Now, a lot of oral, agreements, sounds like. Now, you mentioned, you talked a little bit about your opinion about the weather, and your concerns about the weather in the end of 2018.
Yes.
Now, with it, you had some concerns, and the parties decided not to proceed anyway, just because of her hemp, and as a professional courtesy. Now, was there ever any notice given to Ms. Jackson of his issues with the weather, or any kind of suspension or anything like that?
I mean, we talked when I know we talked in February, that when Shannon and I came out there to look at it, and I said, we're not going to do this right now. It's just too wet. I know I think I had that conversation with her and Jeff both.
Yeah, you talked in February saying it's just, too wet and that's it. You think of any other times that you?
I mean, I know in when we looked when we talked to her that summer, we said we're just going to hold off and do this after the hemp crop is off. I do know we talked about that.
That was the summer in 2018.
Yeah.
And then gap there in the winter, and then talked again in February of 2019.
I mean, I know that's 2 that I know for sure we talked about it. Yes.
Okay. Now, you spoke with, Ms. Jarman, February 2019, all right. Now, you testified earlier that throughout the entire time when everyone was looking at the contract and timetables on, there was no written agreement ever, or written extension ever executed by Fox Hardwood Lumber Company and my client.
No.
And you spoke with Ms. Jackson. Agreement. Now, how long, I think you testified earlier, but trying to keep up, you testified earlier, how long have you been practicing, in this profession as a logger? Well, as a agent?
I'm actually a forester, and I've been a forester for 22 years.
22 years, yeah. Not just forester, foresters, I have a hand in the BNP. Yeah. So I'm catching up, yeah. 22 years, all right. And how many of these arrangements, how many clients have you represented?
Through Arbor Springs, probably an average of 2 sales a month over a 12-year period, 20 to 30 sales a year.
That's through Arbor. Do you represent any clients in this line of work through any other entity?
No.
No, so that's it. All right, so that's two, on average, 2 a month total. All right, so in this, how many clients do you have at any given time?
I don't know. I mean, long-term clients or like one and done clients? I mean, I've got
Active contracts.
active contracts. At any given time, we might have 5 or 6 active logging jobs.
5 or 6. And do you, and you're familiar with, where they happen, where you've logged, who you've represented? What geographic area do you represent?
Tennessee, statewide.
Where's the concentration of your clients?
Middle Tennessee.
Middle Tennessee, any particular part?
I'd say the Tennessee River is the majority of my clients, up and down the Tennessee River.
Tennessee River, all right. And whenever your clients, they go forward with logging, any kind of permits pulled or anything like that, or any kind of...
Say that again.
When you represent your clients in Middle Tennessee, mainly along the Cumberland River, any kind of permits pulled for cutting, anything like that?
No.
Now, in it, so in 2018 and 2019, can you clarify for me, so you had about 2 clients per month. So, and it's been a while, so you may not recall, that's fine, but roughly, what cutting occurred with a client that you represented in 2019 or 2018 at any point in the 3rd or 4th quarter, or the 4th or 1st quarters of 2018 and 2019. So we're talking October 1st to March 31st. How many clients did you have that had cut in Middle Tennessee?
I'd have to go back and look at records. I mean, I don't have any, I have no idea.
No idea? You had some though?
I had some active logging jobs going.
Logging jobs in Middle Tennessee in this area. On the move forward a little bit.
Could I expand on that just a second?
Absolutely.
There's a difference between logging behind someone's house where they live and logging on a West Vaco property that is in the middle of Stewart County that has gravel roads back and forth into it. There's a difference there.
Absolutely, absolutely. Okay, so, let's see. Okay, so with all this, let's see. Now you saw on there the video. So if you could clarify for me a provision of the contract. Now here's the standing timber agreement. If you want to pull that up too, if you have a paper copy. And I'm looking at section 9, subsection A.
Okay.
Now, it says, only trees in the terms of the agreement shall be cut, see sale prospectus. Due care must be taken to protect the leave trees. Now, what is a leave tree?
A tree that's not being cut.
Tree that's not being cut. And so you saw that video. I mean, there's quite a bit of, I guess you'd say, collateral damage in the cutting process. So what's the distinction between a tree that's not supposed to be cut and another tree that's not being harvested but is being knocked down or damaged to get at the trees we want to harvest?
That is a tree that needs to be felled for the necessity of getting to a skid. If you read on down that paragraph, if you don't mind me reading it, however, the purchaser shall however not be liable for the penalty in felling trees when making necessary skidways, roadways, or landing areas, or where trees become unavoidably lodged in the felling process.
So there, so unavoidably, yeah. So they, enables make these skid trees, or these skid trails, and these are the same trails that were decided at the pre-harvest meeting. Everyone just kind of eyeballing it.
That's the skid trail that you've seen on the video.
So I wanted to look at this a little bit. Here are some in there. So in light of everything, I still believe that there was compliance with every effort to protect the trees, the property, avoid oil spilling, and comply with the best management practices.
Absolutely.
Okay. Now, even despite we talked about earlier, the crossing that was necessitated by the decision to not have the second loading area, even in light of that.
Absolutely.
Now, in it, let's see. Now, the best management practices use existing roads. Let's see. So, shift in here real quick. Now, you mentioned earlier, you talked about looking at the video, and let's see. You testified that you met with Ms. Jackson, her son Jeff, on the Monday when they came down. They told everyone to stop cutting. You met with them, but then you also testified that after that date in June, you didn't go down the property and everything, but you did later in August, right?
I did.
And you testified that they had 2 days of cutting, a Thursday and a Friday, and the following Monday is when my client kicked everyone off.
I think that is correct. I'm not 100%, but I'm pretty sure that was the timeline.
Gotcha.
Because I was thinking in my head, what a way to start a Monday morning right here.
Yeah. Hey, today's my birthday. I'm thinking the same thing, brother. Yeah. So, so on that, so we got look at that thing. A way to start the week. Let's see, June. Okay, and you testified earlier that your practice is to come out to make sure BMPs are being followed at least once a week.
That's right.
At least, and you'd been there for the pre-harvest meeting. Now, you weren't there that Thursday when they cut. You weren't there.
I was there that Thursday.
You weren't. You.
I went out there the day they were pulling that equipment in.
And what times were you there during that time?
I don't know. I mean, I was there, it was mid-morning, I think.
And how long were you there?
Probably 30, 40 minutes.
And they were pulling in equipment, mid-morning, 30, 40 minutes Thursday.
Okay. Thursday, and I was back Monday.
Yeah, and so
2 out of 4 days I was there.
And that 30, 40 minutes on Thursday, you said they were pulling in equipment. So that means they were bringing in everything, getting ready to cut, right?
They were fixing the road, getting ready to get in there and cut.
Fixing it, yeah.
And they started cutting about the time I was there.
Get in there and everything, and you saw that it was fine to leave that point, that nothing else needed to be observed, that was sufficient.
That's the way it operates, yes.
And so the next time came that Monday. Let's see, look on that. Okay. I want to look at one other thing real quick. I got the wrong look at it. Okay, now this is that September 12th letter. If you want to pull that up, I think you got a copy there. It's a letter you sent to Ms. Jackson and.
Okay.
All right, we've got that pulled up on the screen there. So I was wanting to see if you could just walk me through how your computation here. I like the Excel. So going through, so you came to counting the number of trees. That's the count you came to walking the property, looking at what was still standing, what was still marked with the paint, right?
That's right.
And how'd you come up with the board feet volume?
You measure the diameter breast height of a tree, and you measure the height of a tree, and then you use a volume summary, Garrard Form Class 78 volume summary table to come up with the volumes.
Okay. And so you got that, and so you had measurements of all these trees, and that's how that came out? That was on a estimate, right?
It's an estimate, yes.
Oh, it is an estimate. So how was that estimate derived?
It was derived by measuring the diameter, lasering the heights, and putting it in our software to calculate the board footage of each one of those trees.
It was done for every tree?
Every single tree.
Want to clarify it? Good. You have the average there, you got the value. Now, you testified earlier that you sent this and you testified what you thought the value or what Ms. Jackson should repay, right?
That's what I was asked to do, yes.
Yes, sir. And so I was wondering right here, so you testified earlier as to the 39,000 figure, right?
Yes.
Now, this number right here though, what's this 6636 number?
That was a number put in there for the 20% incurred for interest, loss of work, just as it says in the profit margin that Fox Lumber Company came up with.
That Fox Lumber Company, so they came up with that number.
So my value was 33 and the 6 was their value.
Okay, so just to clarify, so your value, so your testimony here today is that if Ms. Jackson should have to buy back the trees, that the value of those trees is $33,184.66.
That's the value of the trees, yes.
Okay. And let's see. Okay. Guess so lastly, this is you guys deal with some serious stuff. I appreciate you educating me on board feet and these different things and all that. You guys deal with some serious dollars. I know this is probably a pretty small job for you, right?
I mean, it was a job.
Oh yeah, absolutely. So 22 years of experience and dealing with all these different properties and the different things that come up, and with your experience, is it normal practice to not communicate between your client and the logger in writing as to extensions of the contract or your determinations as a suspensions or anything like that? Is that your normal practice?
A lot of times we don't get stuff in writing, so yes, I would say that's a normal practice.
And let's see.
Everything's in writing in this contract right there.
And let's talk about that real quick, yeah. Because you guys were reading this off earlier, and it was a little quick. I was having difficulty following along. So I want to go through that real quick. So let's talk about provision 4. So here, and if you can pull it up.
All right.
Sir, at first, well, I guess second full sentence in provision 4, starting with an additional 6 months. Could you read that for me?
An additional 6 months may be granted if seller's agent is notified in writing within 30 days of the expiration date.
And you testify that you weren't notified of anything in writing, right?
No.
Okay. And if we could read that last sentence, I think you guys was a little bit of that earlier. If you could read that for me.
Should restoration work or timber removal not be completed prior to contract expiration due to inclement weather conditions, the purchaser shall be granted an additional period for such restoration equal to the time of the suspension.
And could you read that part starting with the purchaser shall be granted? Could you read that for me again?
Purchaser shall be granted an additional period.
Could you finish the sentence, please?
For such restoration equal to the time of the suspension.
Okay, and so, I just wanted to clarify. So that mentions restoration. Now, you also talk about, you testify with your contract that you are, that's part of your practice. You're big on restoration. What is restoration?
It's restoring the site after the logging is done.
And just walk me through that. What takes place when you do restoration?
Water barring the skid trails so soil erosion doesn't occur. That's the big, erosion and water quality is the two big things. And most landowners want their skid trails left open for access for ATVs, horses, whatever. So that's, I mean, we do a great job every time I'm on a site to achieve the goals and objectives of the landowner to do that.
Look at that last sentence again. So if restoration work or timber removal is not completed within the contract prior to its expiration due to inclement weather, then they can be granted additional time to do all that restoration work you were just talking about. That's what that says.
Yes, that's what it says.
Yeah, I just wanted to clarify, we're talking about just restoration there, right?
That's what it says.
Okay. I just wanted to go down here a little bit. So we got section 7. Let's go through this real quick. Let's see, right. In any all parts of the act. Now, if you could, we've gone over the first part there where you've got, as the agent, you've got discretion to suspend the logging operations, right?
That's right.
Now, if you could start with as right there at as stated. If you could read that out for me real quick.
As stated in paragraph 4 above, should restoration work not be completed prior to contract expiration due to suspension by the seller's agent because of inclement weather conditions, the purchaser shall be granted an additional period such as restoration equal to the time of the suspension.
Yeah. Purchaser shall be granted an additional period for such restoration equal to the time of the suspension, right?
That's what it says.
So this is saying, just, correct me if I'm wrong, plain text of this contract you wrote says that if there is a suspension in your discretion due to inclement weather, that the parties shall have, the logger will have additional time to equal to the suspension to restore the property.
That's what it says, yes.
Let's see, and section 18, integration clause. We've already testified there's no modification in writing, so I'll move on. Let's see. So looking at this. Now, real quick, have you experience with the forestry best management practices and your experience last 22 years in restoration work, all the different things you guys do, roughly, how long does restoration work usually take?
That's very dependent.
Depending on acreage and the slope and all those things.
Exactly.
How long do you estimate the restoration in this case would have taken?
Once the logging was completed, there was probably 2 days, 1 to 2 days of restoration work to do.
1 to 2 days. And in your estimation, does your company ever deal with just pure restoration cases? Does anyone ever hire you to?
No.
Are you familiar with the costs if someone is to retain someone for restoration work?
I'm familiar with what it costs to run a dozer, yes.
What would you estimate the approximate cost to restore the property would have been, or would be if Ms. Jackson went and hired someone to do it?
Probably $125 an hour for 2 days of work, so 2 8-hour days, so $1,600, $2,000, somewhere in that range.
$1,600, $2,000, and that's for the dozer, right?
That's right.
Now, you mentioned a whole mess of stuff earlier, though. We're talking about restoration, seeding, messing with the, trying to prevent erosion, pulling out these different logs. I mean, when we're talking about restoration, isn't there more to it than just running a bulldozer?
Pretty much, no.
No, that's.
I mean, you're going to pull the tops back out of the stream if you do that. But other than that, it's most restoration can be done with a dozer.
Oh yeah. Is there any seeding that needs to be done?
If necessary.
If necessary. So that's it. Just running a bulldozer through there.
Pretty much.
Well, now I'm really confused. So you testified earlier about the skid trails and the trees that were knocked down for the skid trails, and you said, well, that's fine because we've got skid trails, and there's all these other trees that are damaged. So now, if we restore the property, your testimony is that restoration is just running a bulldozer through there?
I think your definition of restoration is different than my restoration.
Well, you're the expert. I want you to tell me, what is it?
Well, restoration is not cleaning up treetops. It's not cleaning up logging debris. It is restoring the site to prevent erosion and any water quality issues that may occur. That's my definition of restoration on the BNP side of things.
And that's what you intended by with the contract. It was just that.
We didn't have an opportunity to abide by that.
I'm not asking that. That's when you speak of restoration of the contract, you're, contemplating running a bulldozer through there.
And if there's any other special terms that a landowner requests, then, I mean, a landowner could request me to log a track with mules if they want to, but it's not going to happen. So any terms and special conditions, we would put it in there. In this case, there was no additional special terms and conditions put into the
Just bulldozer
contract.
through there. So if you're going to go through and restore it with the bulldozer, there's leaf trees and there's smaller brush. So how is the bulldozer used to restore it then?
He is putting water bars and water diversions on the trails to keep them from just washing straight down a slope in creating soil erosion.
And just along banks or, I'll move on. Yeah. So let me, I'm this real quick. When you arrived at the site, those 30, 40 minutes on the Thursday that cutting started, how close how far into the logging area had the skid trails gotten to? Because they were just unloading their equipment.
They started in the pink area at Miss Jackson and Jeff's request to get the clear cut unit done. So that's where they were cutting when I was on the site.
And how far into it were they?
I mean, Shannon had just started cutting the first few trees.
Just the first few trees, and they were just in the pink area, so they hadn't even gotten to.
It was close to the green dot right there.
Oh,
just east of the green dot probably is where they were starting to cut.
In the loading deck, gotcha. All right, and so they were just starting out in the pink area, and they hadn't started in the selective area, the harvest area, and that's the area where the disputed creek is, right?
That's right.
So when you were there wasn't a chance to see any of that. You just saw where they had begun right east of the one loading deck.
Yep.
Last question, again, I think just to clarify, I think you justified this, but just to be clear, and on that Monday, when Ms. Jackson objected to continue cutting, you met with her on the property, but you didn't go back and inspect the logging area until mid-August was your testimony, right?
That Monday, I did not have an opportunity to go back into the logging area.
Thank you. No further questions, Judge.
Mr. Boggs, why did you not have an opportunity that day?
When I had got there, it was Miss Jackson, her son. I believe Mr. Jarman was still there, and then a sheriff deputy. And as soon as I pulled in, I was being screamed at by Miss Jackson. So we kind of went from there, and sheriff deputy told me it was just best for me to probably leave the property.
I want to ask you about the decking area and the fact that there was only one. Was that something you agreed to on Ms. Jackson's behalf?
I did that because I knew that the visual aspect of this whole deal was her biggest deal, and if we'd have set up that eastern or that western log deck, it would have been in plain sight of her house, and there would have been another half an acre just mowed down right there, as in her words. So we just used the easternmost log deck,
In your judgment, this was benefiting her.
benefiting her.
And did that make it harder for Jarman to log, to only have one decking area?
I mean, it just made his skidding a little longer, which a little more diesel fuel and that kind of stuff. So it was a little more expensive to him, but he agreed to do it.
Was it your suggestion or his suggestion to only have one decking area?
It was both of ours, because we knew the situation, that aesthetics was the most important thing here.
On the contract, you looked at that provision about the term and the restoration. What has to happen before restoration can occur?
The logging has to happen first.
In your view, does that provision presume or assume that logging has occurred?
That's exactly right.
And as the drafter of the contract, was that your assumption in writing that agreement?
Yes. That's
And so in your view, an extension would also be granted for the logging itself?
That's right.
You mentioned that it's not a stream. How do you know that the stream is not a technical stream under the
Well,
definitions?
it's got, there's definitions, but I believe there was a water quality complaint issued on this site, and it was deemed by the professionals, the professional people that come and look at these through the Department of Agriculture, that this was not an active stream.
Government had to handle this exhibit. Boggs, this was previously admitted as Exhibit 17. Is this the water quality report that you're referring to?
Yes, it is.
And if you look at it says page 3 of 6. It says describe stream crossing violation. Can you read that?
Not applicable.
And why was it not applicable?
Tristan Forsberg and I concluded that the streams on the property did not meet the criteria for classification as intermittent or perennial streams. The harvest had occurred 4+ years ago. There is no distinguished crossing.
What does that mean, there's no distinguishable crossing?
Like the debris that video showed is no longer there.
And while we're at it, if you look at these pictures on the bottom of this report, on the next couple of pages, do you have any observations based on those pictures?
That looks like a very healthy, regenerating young understory forest.
Thank you. Our no further
4-year-old forest.
That's all I have.
Commissioner Massingill,
Yes, Your Honor.
do you want to make that an exhibit? What's
It is, Your Honor. It's Exhibit 17.
I'm sorry.
Parties have stipulated to it.
Well, he referred to an exhibit that we hadn't gotten to yet. So yes,
I made a new one, Your Honor.
we were up to 12, I think, and he skipped over.
Should I apologize. I probably shouldn't have done that. That will.
We're slow, but we can catch up.
Okay. That is Exhibit 17. It's the records custodian affidavit.
Commissioner Massingill, any other questions?
Thank you, Judge. Just briefly, talking about these, two skid rows, if I get that map back up, please. These two loading areas. Now, you testified just now that you decided that only going with one was the best decision for the aesthetic appeal of the logging area.
Absolutely.
Now, and you were concerned because you're about the aesthetics. Now, you had previously provided this map, though, to my client, right?
She had multiple times to look at this, yes.
And she never objected to it?
She never mentioned a word about where the loading decks were.
So why did you think that she didn't want the second one?
Because it wasn't, let me put this, it wasn't so much her, it was her son. Once he got involved with this whole process, I just knew that we better, we just need to make it where it's not going to be visualized from their house. Even though I was asked to mark trees right around their house.
Now, functionally, you just testified that it required longer skid trails, though, for Mr. Jarman by just having one.
Obviously, yes.
And you testified earlier before that it necessitated crossing this ditch, creek, disputed waterway, right? Yeah.
Say that again.
And you also testified about having one, it necessitated crossing the disputed stream.
Yeah, I mean, that's the way the skid trail went in, yes.
So it was your professional judgment that Ms. Jackson's best interests were served by deviating from a plan she previously agreed to and having one loading deck necessitating more skid trails, more damage, and crossing the stream
Yes,
because of aesthetics.
yes.
Now, when you went out to property, I mean, you had a lot going on here. It was surveyed off, right?
It was, the back line was surveyed.
Back line was surveyed. And when you met with the surveyor to walk it, did you walk it with any neighbors, anyone else?
Nope.
You ever have any communications with Henry Todd?
I never, I may have talked to him on the phone once or twice, but yes, I knew he was the neighbor north of Miss Jackson, yes.
But in your testimony, you never spoke with him face to face though, or anything like that?
I think he and I met, but he didn't come out there when me and Jack were out there.
So you said you spoke with him on the phone, so did you meet him in person?
I'm pretty sure I met Henry out there, yes.
Okay, so you met him out there, but not while the surveyor was there?
No, it was before the log. It was one day when we were marking trees out there. And the reason it was surveyed, I'll make this point, is because he had it painted back there with purple paint and it was in the wrong location. And I knew it was in the wrong location, and I talked to Miss Jackson about that, and she said we cannot get over on him. So I said, well, we need to get a surveyor out here then. Got it corrected.
Now, did you discuss with Mr. Todd at any point how the trees were going to be hauled out?
No.
No,
We
nothing about the
never
haul
got
roads?
into the in-depth conversation about that.
You never say anything about the two haul roads or anything like
I don't
that?
recall ever having any conversation with him about that.
Yeah.
He was more worried about what he was gonna do to the honey back there.
Sounds like Henry. Yep. Let's see. Yeah, no further questions, Judge. Thank you.
Nothing further, Your Honor.
I've got a couple. You've been doing this for 22 years.
Yes, sir.
As a part of this agreement, were the tree laps that were left over after a tree was cut supposed to be left, or were they supposed to be removed?
They're to be left.
In fact, are there very many logging companies in the Middle Tennessee area that grind up the tree laps and leave it completely pristine, so to speak, other than roads?
None of that I know of.
And then under the letter that you had referred to, or actually the report, I think from the, it was Exhibit 17 that you made reference to, water quality complaint that was investigated and by the department. It refers to the fact that there are no streams that were meeting the criteria of a perennial, or what was the other one? Intermittent or perennial stream. Tell me what an intermittent stream is.
An intermittent stream could also be referred to as a wet weather stream.
That's what I thought.
That has water during heavy periods of rain.
And a heavy rain, it fills with water and then it goes away as it
Dissipates.
dries out.
Yes, sir.
And a perennial is that one that's constantly got water in it.
Yeah, and will have aquatic life.
You were out there on the property in that particular area where we're talking about this, Mr. Massengill put it, the disputed stream. Was there water in that stream at the time that or that area, I won't call it a stream because they're not referring it to, but in that particular area, the low-lying area, was there water in it when you all were out there looking at it?
At the time the logging was
Yes.
occurring, no, sir.
All right. And you had said it was pretty wet out there. That's the reason you couldn't get to log. Did you ever go out there and see water in it at that point?
Yeah, I mean, there was water in it when we were marking the timber in like January, February.
But was it a constant flow of
It
water?
was
or
not a
just
constant flow. It was just wet.
like some of them on my farm, there's a spot where there's water and then you go on down a little bit and there's another spot.
Yes, sir.
Is, in your experience and opinion, was there anything deficient about what these men were doing on the logging part of it at the time that they were allowed to log? anything that they were doing wrong or not. I mean, I understand it's an argument about that, but in your opinion, was there anything deficient about it?
No, sir.
And you were acting as her agent during that time?
I was, yes, sir.
All right, I don't have any other questions. Do y'all have questions for that follow-up?
No, Your Honor.
Mr. Massimo?
No, Judge.
Thank you, sir. You may stand down. And we releasing him from this subpoena.
Yes, Your Honor.
You're released to go about your business. Thank you.
Thank you.
That contract on behalf of Fox Hardwood,
Yes, I did.
what date did you sign it on?
March 6, 2018.
After you signed the contract, what was what were the next things that happened on this timber sale job in 2018?
The next thing, we believe it was September of the year, went out to the tract took a logger out there to see if it was something he was interested in. It was, spoke with Miss Jackson, and she told me that she did not want us in there while her crop was in the field. So
I want to ask you about a couple things you said there. You said you took a logging subcontractor with you
Yes.
to visit the property. Who is that?
Larry Wood.
Okay. And when did that occur, that you all visited the property?
It would have been the September of 2018.
And at that time, was Fox ready and willing to proceed with logging at that time on her property?
Yes.
And why didn't you?
Ms. Jackson told us she did not want us on the tract while they had their hemp crop in. Thought that the logging crew would steal it and didn't want it damaged.
So after of September of 2018, do you know when the hemp crop was to be harvested?
I do not know when they harvested.
When asked not to log in September of 2018, what did Fox decide to do?
As a courtesy, we decided to wait till later on to harvest it and let her get her crops out.
And so what happened after the crops were out?
Logging crews moved to other tracts, and then it rained for 6 or 7 straight months.
What impact does rain and wet conditions have on logging operations?
In the fall and winter of the year, when the days are short, the grass and trees are dormant, the ground gets wet and it just does not dry up, especially when you have continuing rain throughout the winter.
What's the process that's entailed in identifying a logging subcontractor to cut timber on a tract, and then scheduling and getting the logging contractor to come out? Can you tell me about that process and what it involves?
The logistics of it, the loggers are there to work, to make money. And when we moved out did not start in September, the logger that I had lined up took another job, and he was on it for several months, and then it got wet.
How long would you estimate that it would take a logger to log a tract like Ms. Jackson's tract with the number of trees that you all were contracted to harvest?
The logger that I took in there initially could have got it done in a month. Smaller loggers, less mechanized, it would take them longer. But the loggers that we used are mechanized, and barring bad weather or breakdowns, they can do it relatively quick.
I'm going to hand you what has been previously admitted as Exhibit 13. This reflects rainfall data from the National Oceanic and Atmospheric Administration for Bon Aqua, Tennessee, for
fall of 2018 and spring of 2019. What was the rainfall total in October?
A little more than 3.5 inches,
What about November?
a little more than 6 inches.
What about January?
January was 8 inches plus.
And then what about February?
February, there was over 12 inches of rain.
What were the conditions of the, if you know, what were the conditions of the fields on Miss Jackson's property where the hemp was grown?
Soggy.
Why was that?
Because of 25 inches of rain over the previous 6 months.
What would happen if logging operations were to occur on Miss Jackson's property with such wet conditions?
You could go out there and try and log, but you would ruin her fields and ruin the woods, and you would not be able to log.
Did you ever communicate with Mr. Boggs concerning an extension of the contract's term?
Yes.
Tell me about those communications.
Talked to him on the phone after Miss Jackson didn't want us in September. I communicated with him, told him what happened. He said that was fine. When the fall of the year, when it started getting wet, I'm like, we will have to have an extension. And he said, I know you will.
Do you recall when when in 2019 your conversations with him concerning an extension occurred?
January or February.
And did he approve giving an extension to Fox to harvest the timber?
Yes.
And was that communication done? How was that communication with him conducted?
Verbally.
Verbally. Was it over the phone or in person?
Probably both.
Okay. So after February of 2019, what happened next from Fox Hardwood's perspective on this job?
We, Shannon Jarman, a logger, went out there in February when it had rained 12 inches, and he said, there is no way to get in here now. And it was several months later before the ground dried up and the logistics of getting a logger in there was able to happen where we could get in there.
Was Shannon Jarman, was he the logger that Fox ultimately used to perform this logging job?
Yes, he was.
Have you worked with Mr. Jarman before?
Yes, I have.
How many times have you worked with Mr. Jarman before?
I think he has cut at least 3 tracks for us.
And what's your opinion of him as a logger?
He's excellent. He's a logger of the year multiple times.
What does that mean?
They actually have an award called Logger of the Year?
Yes.
Who awards that?
It's voted on by your peers. The Tennessee Forestry Association spearheads that.
That's news to me. I didn't know there was a group that got together and voted on Loggers of the Years. All right, I'm sorry.
Anything else about the Logger of the Year designation that you can tell us?
No, it just, he, Logger of the Year, to get it, you do things right.
Did Fox and Mr. Jarman, when did they ultimately commence logging operations on this tract?
I believe it was in June of 2019.
Were there any communications between you and Mr. Boggs prior to that commencement of logging operations?
Yes.
Tell me about those.
Told Mr. Boggs that was going to try and use Shannon Jarman. He had nothing but good things to say about him. And He had no problem with him. I had no problem with Shannon, and we went from there.
Did you communicate with Mr. Boggs to let them know when the logging operation would commence?
Definitely.
And when did the logging operation commence?
I'm not sure of the exact date.
Were you present for any of the logging operations?
Yes.
Tell me what you were present for.
I was there when he first got started, and I was there the day that the sheriff's deputy was called. And I think there was just maybe they got started on a Thursday, and the sheriff was maybe called on a Monday.
On the Thursday when you were there when they got started, who all was at the property that you recall?
The only ones that I can recall was Shannon. I'm not sure if John Boggs was there when I was there or not.
Did Mr. Boggs ever tell you before logging operations started that the contract had expired?
Well, we were aware of that, but with the rain and stopping in September for Miss Jackson, so it was no problem.
Did Mr. Boggs or Miss Jackson ever object and tell you that you couldn't start logging in June because the contract had expired?
No.
Did Mr. Boggs on Miss Jackson's behalf approve of you all beginning the logging operation in June of 2019?
Definitely.
So after the Thursday when you were present for the first day of logging operations, what was your next interaction with the logging crew or the logging job on this particular job?
They were bringing logs into the mill, our sawmill in Franklin, and everything going well, cutting the logs like we needed. I was out on site Monday morning, went to the mill, and got a call from, well, a truck driver came in and told me that things were going bad at the logging site. And I called Shannon Jarman and had talked to him an hour earlier. Everything was great, and everything had gone haywire an hour later.
Did you go to the site that day?
Yes.
What did you see when you got there?
Can't remember if the deputy had showed up yet, but Miss Jackson and her son were out by the logging site, not in a good mood.
Did you observe any of the areas that were being logged when you were on the site on Monday?
Definitely.
What areas did you observe?
Where they had cut in the woods behind her house, and where they were having a clear cut out next to one of her hemp fields.
Did you see anything unusual or out of the ordinary about those parts of the logging site when you were there?
Not at all. It was a cleaner than average site.
What does the term tops or tree tops refer to in the logging industry?
That would refer to your whatever products left over that is not merchantable, that you do not take to the mill to make lumber out of.
And how much of if we have a big tree, how much of it is non-merchantable or tops?
Maybe 5%, 5 or 10% of the tree. And every tree can be different.
And what's supposed to be done with the tops that are on those trees that are not merchantable?
As long as it's not in a creek or a field, you leave them where they lay. As long as it's not impeding a road.
Did Mr. Jarman and his logging crew depart the property on that Monday that after you came to visit them?
Yes, the deputy told us to.
You were there when the deputy told you all to leave?
Yes.
Okay. And was Mr. Jarman able to take his equipment with him?
Not initially, but he was able to get it out.
Why do you say not initially?
Miss Jackson told us that we were not taking any equipment out of there. We're leaving it.
Do you want to go back out to Ms. Jackson's property to finish harvesting the remaining trees that Fox purchased from her?
Definitely not.
Why not?
It would not be a good working environment.
I don't have any further questions. Ask the witness.
MegsCW, you may cross-examine.
Judge, one moment. Good afternoon, sir.
No.
Just briefly, you mentioned you were present on the property on that Thursday when they started cutting?
Yes.
And about what time did you get there? Rough estimate, or how long were you at the site that day?
I was on the site for no more than an hour,
No more than an hour, all right.
just making sure that they had moved in.
And did you come in the morning time or in the afternoon?
Do not remember.
All right. Let's see. And how long were you on the property that Monday?
Approximately an hour.
An hour, both times. And let's see. Pass this, Judge.
No further questions?
Thank you, sir. You may stand down. We will release you from your subpoena. You may have a seat in the courtroom, and you may leave. Call your next witness, please.
Call Mr. Shannon Jarman.
You'll step up here.
Good afternoon, Mr. Jarman. Could you please just state your name for the record?
Yes, Michael Shannon Jarman.
And Mr. Jarman, do you commonly go by Shannon Jarman instead of Michael?
Yes, ma'am.
Okay, and Mr. Jarman, where do you live?
In Sladen,
So you're
Tennessee.
from Dixon County?
Yes, ma'am.
You've been here your whole life?
Yes, ma'am.
And what do you do for a living?
I log, I cut timber.
Do you own your own business?
Yes, ma'am.
What's the name of that business?
Jarman Logging.
How long have you worked in the logging industry?
My whole life. My dad done it. My grandfather done it. I finally went into business for myself in 2009 and incorporated in 12. Just wouldn't know what else to do.
Okay. And do you have any specialized training in logging, or was it you learned it from your father and you've been logging your entire life?
Yeah, I learned it from them. Plus, I got some special training. I'm a member of the Tennessee Forestry Department. I got a master logger.
Okay.
So we was logger of the year for 2020 and 2021. So.
Well, congratulations. And do you know how you won that award, the Logger of the Year, 2 years in a row?
Yeah, for doing a good job from what I was told.
And do you know who votes on that?
I think sawmills and other timber people that deal in the timber industry.
Your Honor, we're going to go ahead and move to qualify Mr. Jarman as an expert in logging operations.
No objection.
To be qualified as an expert in the field of logging.
Mr. Jarman, have you ever been involved in a legal proceeding over your business before?
No, ma'am.
Have you ever had anybody kick you off of a job site before Ms.
No, ma'am.
Jackson did?
No, ma'am.
I want to talk a little bit just about how you operate your logging operations. What is the first thing you do whenever you're reached out and hired to do logging?
When I show up on a job, I want to know the maps, and I want to know where the property lines are, where the streams are, where the best possible way to haul the timber out, to drag the timber out. We walk, we a lot of times mark our trails where we want the roads to be, and then we make a plan of it and then go to work.
Did you do that here?
Yes,
And who did you meet with initially at the property?
Jonathan Boggs.
Do you have a good relationship with Mr. Boggs?
Yes, ma'am.
Have you worked with Mr. Boggs before?
Yes, since he started.
How many different projects do you think you've worked on with Mr. Boggs, if you had to guess?
There's been several, probably 20 or better.
And you think highly of Mr. Boggs?
Yes, yes.
In this case, you were retained by Fox Hardwood Lumber to go and actually do the harvesting, correct?
Yes.
And did you go through that same process you just described with Mr. Boggs on this project?
Oh, yeah, he walked some of it with me.
And was
Mr.
that
Boggs
before you started logging?
Yes, Yep.
Do you remember the first time, what month it was whenever you went out to Miss Jackson's property?
Seemed like we went out there in like February, and it was too wet. I told Jonathan and stuff, I said, it's too wet to log this. There's no way. We'll just tear the place up. And he agreed, and I said, we need to look at this at a better date so that we don't destroy the place.
Is that always your goal, to leave a place in as good a condition as you can?
Oh, yeah, yeah. I own a farm myself, and I try to treat everybody else's farm as I would my own.
And you did that here?
Yes, if I could have finished.
We'll get to that in just a little bit. So you had this initial meeting with Mr. Boggs in February of 2018. Did you have another meeting with Mr. Boggs prior to going and actually starting the logging operations?
I think we met out there when we was gonna move equipment, but we always stayed on the phone with each other, trying to pick the right time to do this job. There may have been some time in between, but if you're on a job, you can't leave someone else just to come, there. So it worked out good for, I think it was in June.
Of 2019?
Yes, ma'am.
Okay. When you arrived, did you and Mr. Boggs have an opportunity to go over where a loading deck would be?
Oh, yes. Mm-hmm.
What can you tell me about what goes on at a loading deck?
The trees are drugged to the loading deck, and the trees are merchandised into the lengths that is required from the sawmills that they want us to cut the trees in, and then the trucks are loaded.
Is it a messy area?
Oh, it can get messy with limbs and, and bark, and yeah, it's a working area.
Mr. Jarman, can you see the TV screen over here?
Yes, ma'am.
I'm looking at what's already been admitted as Exhibit 3, I believe, Your Honor. Do you recognize this?
Yes, I do. Mm-hmm.
And on this, can you just tell me what this is to begin with?
Yes, the pink is, if I remember correctly, the clear cut, and then the blue is the select cut.
Does it indicate that there were 2 proposed decking areas?
Yes, ma'am. Yep. There was one, I can see it over to the left, and then the one at the edge of the pink where the clear cut was is the one that we set up on.
And why did you choose to only have one decking area?
Less mess, for sure. And that way, the other one you could see from her house to where we'd be set up at. So all of the mess would be in front of her house. And then there was another hemp field there too. So over here, we're only messing up one area, and it's at a clear cut where it's going to be cleared initially anyways.
Let's talk a little bit about that. So you knew that you were going to clear cut a portion of Miss Jackson's property and then do a select cut for the remaining timber?
Yes, ma'am.
When you arrived at her property in June of 2019, where did you start your logging operations?
If I remember correctly, she wanted all of the clear cutting done first.
Do you typically go by what a landowner asks you to do?
Well, usually we know we have the whole job, so we kind of choose the job as weather permitting, like, okay, it's been a little bit muddy and stuff, we'll work in the clear cut. If the weather is permitting where it's drier for a few days and we're not going to tear up the ground as bad, we'll move on to the select cut to go on to the furthest spot of the property to log, you know. So but we went ahead and done what needed to be done. Jonathan Boggs actually called me, I remember now, and said that she was really wanting the clear cut done first. And I thought, well, maybe they're going to get a dozer in there right behind me and clean. So that's why they had scheduled, you know, so we got in there and knocked the clear cut out.
What type of equipment did you bring to this project?
859 John Deere track cutter. I brought a dozer, Barco knuckle boom, John Deere log skidder, and I also brought a what they call a rubber tire cutter because I figured it would be a lot better in the clear cut area.
Okay, and what exactly is a rubber tire cutter?
It's a big machine like a great big farm tractor with a cutting head on the end, or if you're familiar with log skidders, it's like that. Instead of the grapple to grab the tree, it's got a cutting head.
And why did you decide to bring that piece of machinery? Is that something that you typically bring to job sites?
No, I just thought that it would be more sufficient on cutting the clear cut to get it done. Because from what I understood, she wanted everything down, everything knocked down. So that has a saw on it that spins continuously. So as I'm driving to another tree, I'm going out of my way to knock trees down that I'm not going to make money with, but I was doing what I was told to do to clear it, so I cleared it.
Let's talk a little bit about that. What were the value of the trees in the clear cut? Were they very valuable trees?
No, there wasn't. It was a waste of my time.
What kind of trees were they?
Mostly sweet gum, from what I can remember, and not very long bodied, just one or two logs on each tree.
Were they mature trees or were they younger?
No, they wasn't mature. A lot of it looked like old, overgrown, like old fields that had been, overtaken over time.
And you said that was adjoining Miss Jackson's hemp field, where
Yes.
the clear cut was?
Yes.
Was it your understanding that she was going to expand that field?
Yes, and I think, if I remember correctly, maybe a drying barn or something put there.
To build a barn where you did the clear cut?
Yes. Mm-hmm.
How many days did you work on the clear cut?
A couple days. I don't think we was there, but maybe 3 out of the whole time. So,
During the time when you were working on this job site, you were present the whole time, correct?
yes, ma'am.
At that point, how many crews did you have working?
Just
for you?
one crew at that point.
And you were present at the job site the entire
Yes.
time?
Yes.
Did you ever leave the job site to go make a delivery of any of the timber, or did?
Oh yeah, and pick up parts or something, but never gone all day.
So you were there for a large
Yes.
portion of the day every day?
Yes.
Did you see Mr. Boggs on the job site ever?
When we first started, and then when all of it blew up, I seen him.
Did you ever see Mr. Beasley on the job site?
No, just there at the end. I think he was busy with what he had going on. I don't need nobody to hold my hand. We know what we're doing, what we need to get done. So.
Did you ever meet Miss Jackson when you were working on the first 2 days of the job site?
Just at the end is the only time I remember meeting her.
Did you ever meet Miss Jackson's son, Jeff?
He come over there in a pickup truck. He would ride by and say hi and stuff.
Did he observe you on the first 2 days of the logging operations?
No, I don't remember if I talked to him much. It was maybe hi, how you doing, or something like that.
But he was present?
I remember seeing him a couple times.
Did Mr. Jackson, Mr. Jeff Jackson, Miss Jackson's son ever to come out to you on the first 2 days and tell you you're not allowed to log?
No.
Did Miss Jackson ever come out and talk to you on the first 2 days of logging operations and tell you you're not allowed to log?
No.
What happened on the third day?
We was going along as we normally do with our day, And then we was stopped on the cutting, I think it may have even been a phone call, or maybe her son come over. It's been so long, I can't remember it exactly, but, so we was stopped on the logging, on the job.
How were you stopped? Do you speak with Miss Jackson or did you speak with her
I
son?
think I spoke with her on the phone. I think she called me, or maybe her son had, or something there, and to that point. And I said, well, we have a contract to cut this. And then that's when they said that our contract was no good, which I knew it was, or we wouldn't be there, or would have been run off before the third day to begin with. And then that's when I called Jerden, and I called the Arbor Springs Forester, Jonathan Boggs.
Did Miss Jackson come out and actually speak to you at that point?
I think so. It's been so long. I wish I knew it better. I didn't know we would end up here. Maybe I would have tried to remember it better, but I just done her wishes and left like I was told to do. Did not want to. I always want to finish my jobs, but I was pushed to leave.
And who told you that you needed to leave, other than Miss Jackson?
I guess her son.
Was law enforcement called?
Yes, they called the law.
Was there a sheriff's deputy present?
Yes, he come.
Did a sheriff's deputy tell you that you needed to leave the land?
Yes, he basically said that he wasn't there to battle whatever battle it needed to be. That could be handled in court or whatever. That we was to best thing that we could do is leave,
Did he give you a reason why you had to leave?
because she told us to leave and she owns the land.
And so you respected that and you did leave?
Yes.
Did you have an opportunity to finish the job that
No,
you had started?
no, and I wanted to, but I could not finish. I had to leave.
Were you allowed to retrieve your equipment?
Yes.
How long did it take you to load your equipment up and leave?
I got it out of there in a hurry. I didn't want any more, I didn't want any more confrontation. I got it out of there that day.
Let's talk a little bit about your equipment really quick. Do you use chainsaws?
No, ma'am.
I think you testified earlier about the type of equipment that you use, but you have no use for chainsaws, correct?
No, no, we probably don't use a chainsaw. I don't know. It may not get started 3 times a year anymore.
Do you even know if you had one on this job site?
I don't know if I did. It never got used if it was one there.
How, and forgive me, I know that you've mentioned that you had some specialized mechanized equipment. How does that equipment work?
It cuts the tree, lays the tree down, and then you can cut the limbs off and then cut the top out of the tree. Then you can re-pick the tree back up. This machine weighs 84,000 pounds. You pick the tree back up, hand it up the hill, hand it down the hill, repurpose it so the skidder can get to it easier without damaging any more than you have to, on the property.
Okay, and I think you mentioned it's gonna cut the branches off and it's gonna cut the tops off.
Yes, it won't get 100%, but it'll get it cleaned up really good.
And what do you do with the branches and the tops that are left?
They lay where they cut off at.
And why do you do that?
It would tear the forest completely up if you drug that out of the woods. It's like dragging the disc through your forest. I mean, if you ever walked in the forest and looked down at the ground and look at all the baby trees growing, why would you want to pull a bunch of tops and kill all your younger growth timber? That's just seedlings coming up, and the tops get laid there. It'll become fertilized. Also, it's cover for wildlife while it's rotting down. And it only takes, it rots 1 inch a year. So it's not that long before nature recovers and the tops are gone.
When you left, let me back up. Did you do anything special with the tops on Miss Jackson's property?
Best I can remember, in the clear cut, we tried to lay the tops so it would be easier for them to clear, with the dozer. And that was another reason why I brought my rubber tar cutter, because when I cut a tree, I can actually tote it while it's standing and lay it down in certain areas, So, I always try to benefit whoever's property I'm on, for what the job is.
Have you ever had any complaints before from any of the work that you've done?
No, and if I ever do, we all talk together and work out a solution. Never just instantly from 0 to 100%, you got to leave, never.
Mr. Dorman, I'm going to go over a video with you that's been produced during the course of Ms. Jackson's deposition. And can you see it on the TV screen?
Yes, ma'am.
Do you recognize this property?
Yes, I believe so. That's the clear cut.
That's the clear cut?
Yes, ma'am.
Okay. And are those the tops and branches left?
Yes, that's the undesirable stuff that cannot be sold. That's the waste.
And
from the tree.
according, how are you supposed to treat that? You're supposed to leave it
Leave
there?
it. That'll also keep your ground from eroding.
Is that consistent with the best practices?
Yes, yeah. I follow the BMPs. Best
Always?
management practice, yes. Mm-hmm.
You recognize this road here? Did you had to put in any roads through the woods?
Yeah, and if I ain't mistaken, that is the main trail to get all of the timber from the select cut out.
And you had to take that back, you get the timber from the woods and take it back to the decking?
To the decking area, yes, ma'am.
Okay.
This is the access road that they cut to get down to,
Is that accurate? Did you cut that road in?
Yeah, and if I ain't mistaken, it was like maybe even an old logging road there. I always try to look for that, but I ain't gonna say that it was 100%. But I mean, that was the best way that you could have got from that decking area to the rest of her farm. The rest of it, if I remember correctly, was steep banks, and this was the most gentlest spot going.
back into the woods that, so, instead of what we agreed on, going down from both sides, they decided to cut a trail to go straight around all the way through the property.
And up in the corner at the top of the screen, they're about midway through the screen, are those branches and tops?
Yes. Mm-hmm.
And actually had to clog up this creek down here so they could get over it.
Does that appear to be a felled tree there? Did you cut
No,
that tree?
that's blew over. That's something blew over. We would not tear the roots up out of the ground to get the tree cut.
That's not how you operate.
No, unless a tree fell and uprooted one, but no, that's a blow down tree.
You can see they just,
When does this video appear to be taken? What season?
It looks like fall to me. And I was surprised to see that the road was not washed any more than it would be. I mean, most of the time I have water bars in when I leave a job. And that to not be washed any more than it is, and we cut it in June, and that's probably October, November there.
Okay. And you have no idea when this video was taken?
No.
What makes you think that it's October?
No leaves on the trees hardly.
wherever the hell they wanted and left everything. There was one tree in there they wanted, they cut everything around it.
Is that accurate?
No, that's not what we do.
Do you have to cut down other trees to access the tree that you want with your equipment?
Yes, and we picked the least of tearing up anything direction out for the trees, or I wouldn't be in business now.
To get to it.
Does that appear to be another tree?
Yeah, it's a blow down. I mean, and that's a fairly good sized tree. So it wasn't nothing that we had pushed over to make a road or anything.
There's trees down everywhere. That's actually the back of our house up there on the hill. That's how close they got.
Yes.
There was trees marked all the way to their house to be harvested too. So we did not even go at this point in time near close to the house as the trees that were bought to be harvested.
And those trees were marked,
Yes, they were marked.
and you're not the one who marked the trees, of
No,
course.
no,
You just went in and harvested them.
yes. Mhm.
And this was supposed to be just a select cut, just picking out the old ones. And this is the creek they dammed up.
Did you dam a creek?
If you look at the film real closely, we laid tops in line with the creek so the water can go through the limbs. You drag your timber over. When the job is done, then you take the tops back out of the creek.
And were you given that opportunity to remove?
No, I was not given my opportunity, and this is not even a creek. I'm not even sure you could call it a wet weather conveyance, but we still done by the BMPs, so there was no question about it, put tops in it. Most loggers would have just drug across that and stirred up mud in the creek and all. And we laid tops down so it would filter the dirt and drive over it. Believe me, I would rather have my machines running just right through the gravel or the water instead of over top of all of this rough slash and pulpwood and stuff laying in there.
And why did you decide to do that?
Because that's what you're supposed to do by law.
So you followed the best practices,
Yes, I did.
management practices here as well?
Yes, ma'am, I did.
Even though you didn't think it qualified as a creek, you wanted to make
I
sure.
wanted to make sure there was no question about it, that I was doing my part.
Completely dammed this creek up. It's a natural spring all the way up.
Did you see a natural spring when you were in the woods?
No, ma'am. No, ma'am, I
It's all the
didn't.
way up to the top. You can see now it's just jammed up. This is what they bulldozed and filled in. Nice oil.
No.
Do you recognize those cans?
We would not even have cans or jugs in the woods at all. And that looks like a white hydraulic bucket, like you buy at TSC or one of your, tractor supply places. I don't buy any of my hydraulic oil from there. That is not any of the oil, the white bucket that would go into any of my equipment. So
What kind of containers does the oil and hydraulic fluid that you use?
all of the John Deere buckets usually are yellow that we get our fluid from. And then if we buy at the auto parts store for the fluid that's recommended for the John Deeres, they're dark gray with a red top.
Those appear to be black.
No, it looks like white with maybe a blue top on it.
Okay. These are not this is not anything that you buy for your logging
No,
operations.
that's not for my equipment. That jug is not for my equipment.
If you have to service your equipment on a job site, where do you do the service?
At the landing?
Is this at the landing?
No, ma'am.
When you left the job site that day on that Monday,
Mhm.
did you see any leftover
No, ma'am. Mm-mm.
oil receptacles,
No.
any litter at all?
If there would have been any kind of jug that accidentally got left on a job site, it would have been at the landing. And looks like the small black jug is an oil that we use at the landing. There would be no reason for that jug to be in the woods at all. It's not a fluid we use in the woods.
What
at
type
all.
of fluid is it?
It looks like bar oil. Looks
Okay.
like a bar oil jug.
And where do you use, type of equipment do you use that on?
At the knuckle boom that loads the logs, it also has a big saw, like a big chainsaw bar, and it cuts the log into lengths, into sticks, And so that would be an oil that we would use in that saw.
You don't use that type of oil for any of your machinery that actually goes into the woods?
No, ma'am. Mm-mm.
How many employees did you have working for you at this time, if you can remember?
Probably 3 to 4.
Do you get on to your employees if they leave any trash in the woods?
Strictly. Yep, strictly.
How would you reprimand them?
Every day to be picked up, and put on the truck. The stuff is not going to be left around the job site and nasty looking and stuff, or I wouldn't be in business today.
Have you had any complaints in the past by anybody that you've done logging for that you have left
No,
trash?
no.
And left in here.
What type of jar can is that?
It looks like, from what I could tell, antifreeze jug, and I don't know why that would be used at all for anything there.
You don't have any equipment that needs antifreeze?
Not daily, you know, I hope not, or I have a problem with the motor or something, but no, ma'am, that is not my jug. I don't know how that jug got there.
But you didn't do it.
No, I most definitely wouldn't do any kind of, servicing or any of that near a stream at all. That's a no-no. I would not do that.
Is that because it's not consistent with the best, with the BMP?
Yeah, the BMPs, and I'm just a good Samaritan to the ground. I mean, I would not do it.
From the workers, I guess, we gotta dump out. Nice. From their machinery. So they filled this in so they could come down this path and traverse this to get over the creek. And now this, the water was so nasty. Afterwards, it was just cloudy and tons of algae.
Does that appear to be another felled tree?
I don't know if that one got pushed to build the road or if it's just blowed over, but,
It just really messed up. You can see how they filled that creek in right there too. See how the creek slipped over. We'll walk over there. Now we have erosion issues from where.
Do you see any erosion issues?
no, ma'am, it actually looks a lot better than what I thought it would with us not being able to put the water bars and stuff in.
Can you just describe to the court what a water bar is and what purpose it serves?
Is to redirect the water from disturbed soil over to undisturbed soil. So that if it's running down the road, you redirect it over into the leaves, into the undisturbed soil, and the tree roots and stuff will slow it up and filter it out.
Is that something you do when you finish harvesting?
Yes.
And you weren't given that opportunity
No,
here,
it
were you?
was not. That's why I'm surprised to see it look as good as it does.
Would you also have removed the tops of the trees from the creek?
Oh, yes, ma'am. That would have been done as we're coming across it.
They filled that in. Now you can see it just runs. It's completely diverted and really messed up our creek. And it's a natural spring that feeds it. And you can see they just fill in, cut, and block anything they want so that they have a path.
Would you have removed any of those, or would those tree tops, or would have those have been left?
All of them other ones. And the reason why there is so many treetops here also is because there were so many trees that were sold. And most of the jobs that I go to select cut, they don't want this many trees actually taken off their farm. I was really surprised that we was taking this many trees off of her property. You know, I mean, it's really close to being, I mean, it's not quite a clear cut, but it's a little heavier select than we normally do. But they was painted trees. It ain't trees that I just randomly took out more.
And it goes all the way through. Wherever they went, they just bulldozed everything to get to.
Was that accurate? Did you just bulldoze everything to get to a tree that you wanted?
No, we make certain roads. If you can notice here, this is in a valley. If I can remember, her house is up to the left of there. We made one path to get everything from towards her house down and from this hillside down. And the other road that was pointing up does the same. You get everything to two roads. You don't just go from the woods with the tree to the boom. You'd have no woods left, you know, so you have to make paths. in the woods.
We weren't even supposed to be able to see what they cut.
Is it, can you do your job without someone seeing that you cut something down?
No, and not as hard as they wanted it cut for the money. So if you're going, I don't know how you can sell your timber and still keep your timber. And the only way to get a tree out of the woods, unless we owned a helicopter, is it's got to be cut, felled, and drug out.
And then drag what they cut out.
And you agree with that? You have to drag what you cut out?
You have to.
It's the only way to get it out.
That's the only way.
None of this, look.
And if you can see here too, the little branch is, there's not very much room until you got that steep hillside. So that's where you got to put your tops out of the way so that the machine can drag the timber down.
So you just place the tops out of the way of the road?
Out of the way, yes, out of the road.
And you let nature run its course at that
Yes,
point?
yes, ma'am.
No, that's where it's just stripped.
Do those appear to be tops as well?
Yeah, it's tops, yep.
Left trees where they cut everything, just mauled everything down.
Does it appear that everything is mauled
No,
down?
I see a whole lot still standing, but it would not look quite as bad if they didn't want so much cut to begin with.
Get to whatever 2, 3, 4, 5 trees they needed to get and just demolished everything around them.
Is that another top?
Yes, ma'am.
Everywhere you look, it's just nothing but trees cut and left so they could get to what they wanted.
Did you see trees left, or were those the tops and
No, there were
branches left?
tops. There was, what tree got cut got taken out.
They blocked up. They just filled the creeks in. It's another.
That was already there.
That was already
That
there?
was a dead tree. Had been laying there for probably years, what he was just showing. That one.
That one?
Yeah, that was nothing we cut or anything. That was a tree that been laying there, blowed down years ago.
It's another creek that's completely blocked up here. So they could keep going.
And again, are those just tops?
Yes, like I was saying earlier, I'd rather just drive across the dirt, but we put that there purposely so that we're not stopping the stream. We're not damaging the stream with dirt and debris and stuff. When we get the trees drugged, then we'll take them out of the branch.
And here you didn't have that opportunity?
No, ma'am, I didn't.
Yep, this was a creek. Looks like a tornado went through here. But you can see they just picked paths, and wherever they crawled,
Is that another treetop?
I didn't, I'm sorry, I think so. Yes, it's just treetops left.
looks like a tornado went
And treetops can be quite large, correct?
Yes.
here. But you can see they just picked paths, and wherever they crawled, they cut everything through it, everything down around it to get those machines in, that one big machine in that grabs the one tree they want.
What machine is that he's referencing?
The 859 John Deere cutter. Yep.
To cut it and pull it out. Look at this. Look, it's like they need looks like a 12-foot path to get through.
How big of a path do you need to get your equipment through?
At least 12 to 15 foot or so. I mean, they're 12 foot wide.
It goes on and on and on.
Okay, Mr. Garman, after reviewing that, is there anything that you saw that was out of the ordinary for a logging operation?
No, ma'am, not at all. I was really impressed to see how well that it looked, to tell you the truth. And everybody that works on my crew and was with me there had been in this line of work for years, for very, very long years. At that time, my knuckle boom operator and skidder driver had been with me for 11 or 12 years. The guy on the cutter had been cutting for over 20 years. So they're very professional of what they know, of what they do.
You operate a professional logging operation?
Yes, ma'am.
You don't have any complaints from anyone else in the past?
If I did, I wouldn't have been logger of the year 2 years in a row for the state of Tennessee.
And that was immediately the following year after this?
Yes, ma'am. 20 and 21.
If you would have had an opportunity to finish logging here, how many more days do you think it would have taken you?
Just a couple more days and we would have been done. Her streams would have not had branches in them and we would have been out of her hair.
And why weren't you able to finish?
Because I was asked to leave. I was asked to stop cutting.
I have no further questions.
Good afternoon, Mr. Jarman.
Howdy. Good
So,
afternoon.
so a couple of questions for you real quick. You mentioned that you met with or you went out to the property in February of 2019, says too wet.
Yes, sir.
And then when was the next time you were on the property?
June. Yes.
And then why were you there?
Because it worked out with the right timing with me finishing up another job and the weather was permitted correctly for doing the logging. And also, if I remember too, we needed to get there and get it done as fast as possible. If I ain't mistaken, they was gonna maybe begin planting again. So we needed to get the job done as fast as we could.
And when was the decision to go to the one loading site made?
It was made after walking the job and understanding that we would end up right in front of her house. And I don't know, I would not want that right in front of my house, a loading deck area where there's a lot of trash and, trash as far as debris from tree limbs and stuff.
So was that the pre-trial or pre-harvest meeting? Yeah.
Yes.
And how long did that meeting last?
I guess an hour or so walking,
Okay. And you justified that it would have taken a couple more days to finish up the cutting there. You say, give me an estimate, a few more days, I think 2, 3, 4?
I would say 2 to 3 would have finished the job.
Would that have included restoration work?
Oh, yeah, because we do, like, if we finish an area, then we'll start restoration as we're going.
2, 3 total. Got it. And you mentioned earlier that the clear cut was not worth your time. What do you mean by that?
It's just no profit there. I got paid by the truckload of timber that left there.
What was that rate? What were you paid per truckload?
Shoot, I think we was at like 26 cents a foot, and if you get, I ain't got a calculator with me, so if it's 26 cents a foot and you got 4,000 feet on, is that $920 or something?
So is that 26 cents a foot or a board foot or?
Board foot, yes, sir,
26 cents per board foot.
on a Dole scale.
Board foot. So just based on the volume that you guys can get out of there. Gotcha.
Yes, yes.
All right, and.
But I agreed to take the job and to clear cut and to knock down all of the other pretty much stuff that I don't get paid for, you know, because Jonathan asked me to, and she had asked Jonathan to make sure everything was knocked down as possible in the clear cut. But in the contract stuff, it states that the logger really does not have to do that. I went out of my way to try to knock more of the stuff down so it didn't have to be pushed down later when he was clearing to do whatever.
Deal. Let's see. Just kind of eyeball a little bit. No further questions, Judge? That's witness.
Redirect, Ms. Franklin. Thank you, sir. You may stand down. You may have a seat in the courtroom if you like, or you may leave.
Okay, thank you. Thank you.
You may call your next witness.
Your Honor, we're going to call Tommy Fox, so may I have a 5-minute break for that?
Yeah, we'll take a break. Well, maybe longer than 5 minutes. We'll take a 5 or 10 minute break.
Mr. Fox, could you state your full name?
Thomas C. Fox III.
What do you do for a living, Mr. Fox?
I'm in the timber business, in the lumber business.
What is your relationship to the plaintiff in this case, Fox Hardwood Lumber LLC?
I am the owner of Fox Hardwood Lumber Company.
What does Fox Hardwood Lumber Company do?
Fox Hardwood buys logs from loggers and buys timber from landowners and harvests it and then brings it into our yard, processes it, and then sawing it, then drying it, and then we make finished goods, all sorts of flooring and products that go in homes.
How long have you been in, how long has Fox Hardwood been in the timber business?
We just marked 40 years just a few weeks ago.
And how long have you personally been in the timber business?
40 years.
Have you ever had a problem like one we're here about today?
No, sir, never.
Mr. Fox, I'm going to hand you what's previously been admitted as exhibit number 14. What is exhibit number 14?
This is a summary of the remaining timber from Ms. Jackson's property in its lumber form, how that we have taken it and what we would have done to it if we had gotten it on the yard and processed it in the lumber.
And I believe you should have up there in front of you, Mr. Fox, exhibit number 12.
Yes.
Which was previously admitted, and Mr. Boggs prepared that exhibit. How do exhibit 12 and exhibit 14 relate to each other?
Okay, so this, the last page
Of which document?
on exhibit 12 would be Mr. Boggs's recruits of the remaining trees that were left whenever he went and recruits the trees, the 183 trees that made up a total volume of 73,000 feet. And he placed a dollar value on those based upon what the timber brought that we paid for at the time we bought it.
Well, let's just take an example. Let's look at the very first one, yellow poplar. So what does Mr. Boggs's exhibit 12 show as the remaining board feet volume for yellow poplar?
24,415 feet.
And then what did you then do on Exhibit 14?
So in order to figure out how much volume, there is a difference between log footage and lumber footage. And so that is typically figured by the way that we saw, and I would just say these are, you know, these numbers are very accurate because we know exactly in sawing and when the lumber comes out, we track every log. We have literally thousands of logs on our yard today, and every log has a barcode on it, and we can go out and scan a log on our yard, and we can tell you where that log came from, what tract it came from. We can tell you every detail about that. We can tell you the species, the grade, the length, and everything. So we track all of these logs. So in doing that, we know what the lumber footage versus the log footage would be. And so that's where this comes from. And it's in our industry, it's called overrun. And that's why there's a difference between the lumber and the log footage.
So for example, with the yellow poplar, Mr. Boggs showed 24,415 board feet, which, where is that then reflected on Exhibit 14?
That'll be the top left-hand number, that 24,415 feet. And then the column right beside of it would be the lumber footage, the board footage of lumber that would come out of that 24,415 feet, which would be 31,740 feet.
And then to the column to the right is board feet by grade. What does that indicate?
So in grades, what's called the National Hardwood Lumber Association rules and grades, that lumber will be broken down into grades. The first column, the first set of numbers there, 25,392 board feet, that is what we call first and seconds, or the very best lumber. And then the next one will be what's called a one common. The next one will be what's called a two common.
How do you know you've got 31,740 board feet of lumber, and then the grade then makes up that number? How do you know what the proportions are?
Because we track our lumber out of logs, like these logs of this grade and this kind of a class of log, and we know what the breakdown in the board footage of each grade would be.
The column to the right of that, it says market $/MBF. What does that indicate?
So that would be per 1,000 board feet. So that first number on top that lines up with the 25,392 feet, that is $965 per 1,000 board feet, which translates into 96.5 cents per board foot. And then the next one down is $570 per 1,000 board feet, which is 57 cents a board foot. And then the next one would be 35 cents a board.
At what point in time did you determine the market dollar per 1,000 board feet as of?
So what we did is we went back to the very date, the month, and the date whenever this transpired, and we pulled, and I can verify it through hard copies. We took the actual sales price of lumber that day, and then we used that to plug that in here to come up with this. This is not smoke and mirrors. It's not guesses. These are the way the numbers work out.
The description at the top says it's based on the fair market value as of September 12th, 2019. Do you see that?
Let's see here. Yes, September the 12th, 2019.
And we've heard testimony here today that the logging was stopped in June 2019. How does the June date then relate to the September date that is calculated here?
So the June date would be the date that we ceased cutting, that we stopped cutting, which the logs would have been delivered to the mill and then processed. And so it coincides with the date that we stopped logging.
So would there have been a delay, or not a delay, but an amount of time it would take to process the logs?
Right. And so what we did is we figured what we call green lumber prices. So these prices were all green lumber. They're not kiln dried. They're not any kind of processed other than just fresh sawn green lumber that would be sawn and shipped, and then within 10 days, 20 days. And that's the way we figured this at the very lowest, the lowest price point there is.
Could you have calculated your damages in another way?
Well, the best way to calculate the damage would be to take it to the finished good product. We would take green lumber, put it on sticks, we kiln dry it, and then after we kiln dry it, we process it into flooring, we process it into all kinds of ceiling and wall materials, outside natural sidings for houses. But I didn't do that because we were trying to, it may not seem like that because we're in a court of law now, but we were just trying to be as fair as we could, and just to say, this is a real number. And the other one is a real number too, but it has more time and it has more cost that you have to figure out of this. This is the kind of the lowest common denominator of what lumber would be worth in its freshest green state after it's sawn, that could be sawn and sold within a week.
If you had added in those extra steps for processing, would your profits on this lumber have been higher?
Right, that's where the profits are at. As you can tell, there's not much profit here, and the profits are in kiln drying it and then processing it into things like we're looking at in this beautiful building here, in architectural millwork and moldings and tongue and groove materials. That's where the profits are at, and that's what we do. We sell material that makes stuff just like you're seeing here.
And I presume that you wouldn't be doing those things if those extra activities were not profitable for you.
Right. In our industry and in any industry, it's called value added. And so we take things to another step because we need to add value to our product and take it to a consumer so that we can get more out of it. But none of that was figured in here at all. No, absolutely zero.
If you had done the value added, do you have an estimate of what your damage number would be?
No, sir, I didn't figure it, but it's several times what this would be. It's several times.
All right. We were looking at the market dollar for 1,000 board feet, and then we have the next column over lumber dollar by grade. Is that just the multiplication then of those?
It is,
prior
yes,
columns?
sir.
All right.
Yes, sir, it is.
And then the column to the right says logging 220/MDF. What does that indicate?
So that is the logging cost of what it costs to get the logs out of the woods and get them to the mill that we would pay Mr. Jarman, which would be by the 1,000 board feet, $220 per 1,000 board feet, which translates into 22 cents a board foot.
So after Ms. Jackson stopped the logging here, did you pay Mr. Jarman for the rest of the job here?
No.
Okay. But if she had not stopped it, you would have had to pay him that 220?
Yes, sir. That's where that, yes, sir.
All right, the next column to the right is 220 for sawing. What is that indicating?
So the cost of sawing versus the cost of logging is not a lot different. The number is greater because the board footage is greater. So the cost of the sawing was figured at 22 cents a board foot. The actual cost of sawing a board off of a log.
And then we have the end number, the profit dash timber. That's just the mathematical result of the prior columns.
Yes, sir, that's correct.
And then would it be the same? We just did that for yellow poplar. Would it be the same for all the other species indicated on this spreadsheet?
Yes, sir, it is. The only difference is that the poplar has a different grade breakdown because it's a better species for the mix of lumber coming out of it. So if you look at the others, you can see that it's a little different. But yes, sir, it's the same. It's all the same in the end, which comes down to the end number.
Use the same methodology.
Yes, sir. Yes, sir.
If we look back at Exhibit 12, Mr. Boggs's calculation, he's got a slightly different starting number. He has a total board foot volume of 73,743, You have your starting number at 72,100, so yours is lower. Do you know why that is?
No, sir, I don't know exactly, except, I mean, I do know. We did not include some of these, what we call minority species. So if you look at some of these, the sweet gums and some of the other species there, we did not include them. So I didn't exactly total it up versus the other, but it's because they were such a trivial amount of footage and money, we didn't even count it because it just wasn't worth it. So we just left that out.
If we look at, if we just compare the species on Exhibit 12 to the species on Exhibit 14, yellow poplar is there.
Yes,
right?
That's the number one species by volume.
White oak is on both. Is that right?
Yes,
Red
sir.
oak is on both.
Yes, sir.
Hickory's on both.
Yes, sir.
Chestnut oak's on both.
Yes, sir.
Mixed hardwoods is on 12 but not on 14.
Correct, yes.
Why is that?
That's correct. Just because it was a minor species, it didn't have much value, and we just left it out. We were not trying to push it to that point.
Post oak is on both.
Yes, sir.
Sweet gum is not on 14. Why is that?
And again, it's a minor species that doesn't have a lot of value to it, and so we just left it out.
Mr. Fox, how would you characterize how you have calculated your damages in this case?
Well, it's kind of hard coming from the guy that's doing the calculating, but I would say more than fair. We have calculated these based on our past history, and we whatever we do, we just want to be fair. We've never tried to be anything but fair with Ms. Jackson, and to try to resolve this, and this is more than fair. I can't imagine anybody treating me this good if I were on the other side of this.
Mr. Fox, this number 48,000 is a lot of money, but it's also not a lot of money in relation to the cost of bringing a lawsuit. Why did you decide to continue with this litigation?
Well, the reason we brought litigation is because we tried every way to settle this thing and to get some resolve, and we couldn't even get a response. So we were left with no other choice unless we just gave her the timber back and walked off and left it, but to have to legally do this. And so I can't say it's not about the money, because it is, but it's more about not letting someone do this to you. And I know this may sound trite, but it's like, this is America, and we are a land of laws, and we are a land where truth prevails, and that's why I'm here. I've thought about this a lot in my own mind, and I just so why am I doing this? Because this is kind of stupid to do this in some ways. It's like, well, is this a matter of principle? It's like, well, no, not really, because principle can have a lot to do with pride and just determination to just regardless what something costs, just to do it. But it's just more about truth and wanting to see the guys that I work with vindicated from wrongdoing, and us as well, because we have done absolutely nothing wrong. Everything we did was right. And so therefore, that's why I'm here, is to be vindicated from wrongdoing, and to say that the law and truth is no terror to people who do right. And that's just the truth. But the law is a terror to people who do wrong. And so I kind of bared my soul to you.
Thank you. Mr. Fox, you've laid out what your damages would be. Another option would be to go out and finish the logging. Which of those would you request from the court?
Well, we don't want to go back out to the property again. I think there was a time we would have probably done that. The problem is nobody that my guys, Mr. Beasley, who is a professional forester who has cut hundreds and hundreds of tracts of timber, Shannon Jarman, he says he's not going back. I don't even think we can get the timber cut if we even wanted to. I don't think we could get a logger besides Mr. Jarman because nobody wants to go back behind somebody else, and then I think everybody'd be scared to death. All we want is just as a resolution to this, and just to be made whole. And even at that, we will never be made completely whole.
Thank you, Your Honor. Pass the witness.
Messenger, any thoughts again?
Thank you, Your Honor. Good afternoon, Mr. Fox. How are you? Good deal. Well, I have a few questions for you. Just wanting to go through this real quick. You mentioned, you just testified at the very beginning of your testimony just now that you guys are you're engaged in logging business, and you guys routinely buy timber from property owners and logs from loggers.
Yes, sir.
All right, and so could you tell me the distinction between timber, logs, lumber? Can you define terms real quick for me?
Okay, so we buy logs from loggers who go out and buy tracts of timber on their own, independent loggers, and we buy that's what we call gate wood. It comes through the gate. It's their logs, and they've either bought it or they're cutting timber on some kind of arrangement with the landowner, and they bring logs in, and then we buy the logs from the logger and from the landowner as gate wood. It comes through our gate. Then we buy tracts of standing timber from landowners, and we have two graduate foresters, Mr. Beasley, that you have already heard from today, and then my oldest son, who is a graduate of Mississippi State University with a forestry degree, just like Mr. Beasley.
All right. So when you guys are going through and buying this, let me take a look. And so you've got logs, you've got timber, and then we've got over here, and you talk about lumber. So what's the distinction between that? What's the difference between lumber, logs, timber?
Well, timber would be standing in the woods. Logs would be round cut logs or tree length, but mainly cut logs. And lumber is boards.
Boards finished, cut, refined? Yes, sir.
Made into finished goods.
All right, thank you for clearing that up for me. Good deal. And a board foot, that's 12 by 1 by an inch. What's that unit for me?
12 inches by 12 inches by 1 inch thick. That is a board foot.
Board
That
foot.
is one board foot.
And that's the same for timber, for timber out in the woods, logs coming in to get sawed, and lumber, right?
When you figure board footage, it's board footage.
That's
Now,
what it is.
it's impossible to figure board footage in logs the way you do in lumber, because lumber is already sawn, and it's a definable size. In logs, you're trying to figure out how many board feet of lumber is in a log, which is done, through a conversion scale.
Got you. So they estimate that, so it comes out to the it's all same unit, the board feet you testified to. So how exactly if lumber is refined from timber and logs, and it's all the same unit, how, in your estimate, do we have a larger number for lumber, the refined product?
Okay, so that's what's called in our industry, and this is worldwide. It's called overrun. It's called overrun, and it's built into the price of the timber. It's built into the price of the timber.
Can you explain that to me? How it's built into the
Okay,
price?
so when we figure board footage, it's figured on what's called Dole log scale in the region that we live in. It's Dole log scale, and so Dole log scale is figured based on the size of the tree, the size of the log, the taper of the log, and is converted into board footage. But it depends on what you cut the log in to how much what's called overrun that comes out of the log. And not all sizes are the same. Different size logs have different amounts of overrun. And so it's not complicated. But at the same time, it's a little bit hard to understand. But it's just, it's like anything else. It's like dry weights versus wet weights. It's the same exact thing. It's just things weigh differently, and they sell for a different price, dry and wet.
Now, the board footage is a unit of volume though, right?
It is.
So, and whenever we.
So is poundage.
That's right, absolutely. When things are wet, it makes a difference. But if we're talking about a unit of volume, if you've got a log, there's only so much wood there, right?
Yes.
And when you cut it, there's going to be pieces that come off. You're not going to get 100% of that log converted into timber, right?
Well, I don't really know how to answer that question. I don't know that that's even a good question. You had to restate that in different language.
I'd be happy to, sir.
Witness is objecting to the form of your question. I sustain the objections.
Yes, Your Honor. So if you have a log and, wet, dry, how have you, whatever its weight is, that's the amount of wood that's in there. Now, if you cut it, there's gonna be lumber on the other side as well as sawdust, unusable portions of that wood, waste cut, everything else, right?
Correct.
So if there's only so much, you mentioned a board foot is a board foot. That's a unit of volume. So again, if we have if we have a unit of volume and we go from timber and we cut it into something that is going to be less, how do your figures come up with an even larger number?
Okay, so I'm going to try to answer this for you, and it's so the people in our industry or any industry who do the best are the people who do the best job, who figure out how to do the best job. So we use what's called a bandsaw. So I grew up around a sawmill with a circle saw, and a circle saw takes out over 1/4 of an inch of dust. So most of the mills in this area, in Middle Tennessee, are circle mills, and they're using a circle saw that's a 56-inch round circle saw or a 60-inch round circle saw, and they're taking out over 1/4 of an inch of dust. Some of them are 3/8 of an inch. We use a bandsaw, we take out 1/8 of an inch. So the people that figure out how to recover the most out of a log are the people that come out with the most lumber. So that's how that translates into more lumber. Somebody else would not come out with as much lumber as we do, but they don't use the same equipment we do. They don't have the same investment we do, and they haven't figured out how to do it as efficiently as we have.
I still don't understand how we end up with more wood after it's been cut.
I end up with more wood than somebody else does down the road. So somebody else might end up with less wood because I'm taking out less sawdust. I'm taking out what's called the kerf. I'm taking out such a small kerf that I end up with more lumber.
Less waste.
So the scale between logs and lumber is based on taking out a lot of kerf. So people smarter than me figured out how to take out less kerf and end up with more boards.
If you reference this, your damages calculation, I guess to clarify, so how do we go from 24,415 board feet of timber, and then we go through the cutting process, which you just testified is very efficient. So we've minimized the waste, but there's still waste, there's still loss, and end up with an even larger number of 31,740.
Because we figured out how to end up with more lumber by spending millions of dollars in investment to buy machinery to do a more efficient job than to use an old sawmill that would have this much kerf in it and turn all of the lumber into sawdust. So instead of sawdust, we have lumber. So in the world I live in, sawdust is not a good thing. Lumber is a good thing. So we're trying to figure out how to have more lumber and less sawdust.
And so that's how we end up, you said a board foot's a board foot, so that's how we end up with more lumber after we've cut it than we started out with.
That's exactly right. That's it. That's 100% right.
I will leave it there.
That's 100% right. And not everybody's going to end up with the same amount of lumber.
Right.
It's like there's some farmers that's going to grow more corn on an acre of ground than others. They're going to grow more soybeans, and it's people that figure out how to do it and in a more efficient way. They're going to thresh their wheat. They're going to get more wheat. They're going to have less. They're going to have less waste. And so it's whoever figures out how to do the best job that's able to get the most recovery out of a log.
Well, we'll come back to that.
I'd be glad to.
Yes, sir. So on that though, so how did you come up with the conversion between timber and lumber? So we've gone through these numbers. So you testified that by sawing 24,000 board feet of timber, we end up with 31,000 board feet of finished lumber. How did you come up with that ratio?
40 years. That's how.
And you came up with that across the board. I was looking at that, and you testified that you guys have 40 years, and you guys have tracked every tree you testified to.
No, I didn't track every tree. We track logs. If you come to my yard, you could see that there are tags on logs everywhere. It's thousands and thousands of tags on logs and on lumber too. And so we track those logs. The only way for us to be able to saw and to make money, because we don't make much money. All you got to do is look at the amount of money that's on the profit side of this, and you can see that we don't make much money. We don't make hardly anything. If people knew what we made on lumber per board foot, they'd say you're crazy to do what you do. So the only way we've got to make any money is to do lots of it. It's like farming. I mean, you have to raise lots of tobacco to do any good with tobacco. You have to raise lots of corn. We have to cut lots of logs in the lumber, because the profit margin on this is just not very much.
Long game, huh? Yeah.
It's just, that's the only way we can make money. We have to compete with people all over Middle Tennessee, Southern Kentucky, North Alabama in order to buy logs. And whoever does the best job are the people that makes the most money or stays in business. And there's people better than we are.
How did you determine the variable or the conversion here by species? Is it all the same, or is it or does you come at it broken down by species?
Every species, not every species, but oak is going to be different than poplar is. Poplar is the highest grade of the amount of the higher grade lumber versus the other. And I just it's I'd hate to open up another can of worms, but it's the reason some of these numbers are like they are is because the best timber was left. All the lower grade timber got cut on this tract when it was cut. So the higher grade logs were still on this tract. They were never cut.
So you just testified that there's a difference between oak and poplar. Every species is going to be a little bit different, right? All right, now look at this. I was going to pull up something. Reviewing the numbers, it looks like the conversion you have between timber and lumber is roughly 76.9% across the board. May I pull up my computer real quick so we can run some numbers? Be brief. Let's see. Can you hear me, Mr. Fox?
Yes.
Good deal, good deal. Let me run one real quick. You mentioned poplar. Let's see, new one, we got yellow. Let's just do 24,415 divided by 31,740 equals 76,921. Now,
I don't know what you're trying to do.
let me pull this up for you so I can show. So right here, this is what I was asking about earlier. See there? This is your damages estimate, sir. You have here board feet of timber, where you start out with 24,500 board feet of timber, and then after cutting it and refining it, you end up with 31,740. And you mentioned there's differences. I'm trying to look at how this was developed. You mentioned that every species is different, so I'm trying to look through here, see if there's
Well, no, you missed it. The grade breakdown is different because some species are a higher grade species than others. we figured the overrun, and it's about the same thing as far as the percentage wise of lumber versus logs.
So you use basically the same multiple
right.
all the way through, just
Right.
an estimate, and that was just based off 40
Right.
years of
Right.
experience.
And you could get professional witnesses to come up here and to corroborate everything I've told you, and we're on the conservative side of this.
All right, well, let's take a look. Now you testified that we've got $220 per thousand board foot. It comes out to 22 cents per board foot. That was the sawing expense, right?
Yes.
Now, you just heard the testimony. You've been in here today. Earlier, Mr. Jarman testified that his rate was 26 cents per board foot. Is he mistaken, or are you?
I don't even remember.
You don't even remember?
No, I don't. I don't remember. And maybe it was 26 cents. I don't remember. Maybe there was I'm not sure if there was some kind of bonus rate. At the time we were paying an average of about 22 cents a board foot for logging.
So as an average, but
20 cents, some tract for 20 cents. If we were paying him 26 cents, I don't remember it. And maybe that was, but I didn't go back and look at that particular tract. Maybe I should have. But at that time, we were paying about 22 cents average for logging costs.
to use, just kind of the just a general average, kind of like the overrun.
That's
estimate.
correct. Absolutely.
Okay. Let's see, go on there, and then similarly sawing. With it, you testify that it's roughly the same expense as logging, and you used the exact same rate.
Yes, sir.
22 cents per board foot.
Yes, sir, I did.
But you testified earlier that there's significant difference between, say, poplar and oak.
Yes, sir. My sawing cost on poplar may run 18 or 19%, or 19 cents a board foot. Not percent, but 18 or 19 cents. It's going to be cheaper than oak because I can saw more of it in a day. The logs are longer, they're bigger, and it's softer. I can saw it faster. But we were using general numbers. Again, these are verifiable numbers.
General numbers is estimates, right? Just kind of, all right. Let's see. I think, and back to the beginning, you mentioned buying logs from loggers, and you mentioned that your estimate here, your damages estimate, is a derivative of Mr. Boggs's estimate, right? Is that correct?
Yes.
Look at those numbers, everything. So, and this represents your profit, taking the timber and transporting the logs and then turning it into lumber, right?
Not much money.
But all those steps, all right. Now, Mr. Boggs, though, his estimate represents the value of the timber, right? The value of what was taken from the land in a contract. Okay. And do you think that Mr. Boggs' estimates, you testified earlier that you think it's a fair estimate for the timber value, right?
I did this.
No further questions, Judge. Thank you. Thank you, sir.
Mr. Fox, let's just try to deal with this overrun issue. How can it be that you have more wood after you saw it than before you saw it?
Well, as I said a few minutes ago, through time and efficiency, we have figured out how to get more board footage out of a log than they did 100 years ago.
But is the original estimate of as timber, is that accurate and 100% accurate?
Yes.
Okay. So is there actually that much, are you adding more wood to it, or are you just being more efficient?
No, we're turning sawdust into lumber.
How are you doing that?
By taking out less sawdust when we saw. We use thinner saws. We're sawing thinner slabs. We have figured out, not me, but people have figured out how to be more efficient and how to get more lumber out of a log, which translates into having cheaper lumber in the end, which is a benefit to the consumer.
Would you say that overrun estimate is also conservative?
Absolutely.
No further questions, Your Honor.
Ready, Judge? Right. So referencing the 40 years of experience and the advances in efficiency in the timber industry and familiarity with it, could you tell the court briefly what the utilization rate is on a log? So if you bring in a log, what percentage is converted into lumber and what percentage is lost to sawdust and waste products?
Well, a whole lot less today than it was a few years ago. So, but percentage wise, tonnage of sawdust and slabs versus chips, I don't know what the conversion rate is on a log because it all depends on the size of the log. So you're going to have definitely more sawdust in a bigger log than you do a smaller log. But I don't know. There have been studies done. I don't have those studies at my fingertips right now, so I don't know what they are. But you've probably heard before about killing hogs. It's like people figured out how to use everything but the squeal, and so that's kind of that way with logs. We have figured out how to convert logs into more lumber, into more usable products, and we want lumber. We don't want sawdust. Sawdust has no value to it. Chips have no value that make paper, but we save those things and we sell them not for a profit, but just to keep them up off the ground and to be able and to use them. But we're trying to figure out how to get more lumber out of every log. And there's not much waste in a log compared to what it has been in the past.
Absolutely, and that's great. And we've been estimating all day on this, so I'll permit you on this. With your 40 years of experience, though, use an example we talked about earlier. Remember we talked about dry weight? So I'll give you a hypothetical, and it doesn't have to be precise. I don't need scientific precision. You can give me an estimate because that's what we're working with here. Example earlier, if we've got 1,000 pounds of dry timber, and we saw it, and there's no change in the water weight. It's the same weight across the board. How much weight will you have on the back end? We start with 1,000 of timber. How much weight in lumber will we have? Rough estimate. I'm not going to hold you to this.
So if we're talking about lumber, we're talking about a 7% weight loss in lumber.
A 7%?
A 7% weight loss of water weight. A 7 or 8% range in moisture is what we're talking about in moisture. But I can't answer your question. I can't answer your question on how much waste there is in a log because every log is different. Based on how straight it is, based on how much taper it's got on it. So there is no way I could truthfully answer that for you.
So,
but I can say this: the numbers I gave you can be verified. They are true, and they're on the conservative side, way on the conservative side.
So we can estimate these costs here, but we don't even have a rough estimate for what the utilization rate is on a log.
So this is what I would say to you: is I'm in the lumber business, not in the sawdust business. So I gave you and gave this court the lumber ratios. I don't, sawdust is a byproduct to me. And so therefore, I can't tell you how much sawdust comes out of a log, and every log is different.
I'll pass the witness, Judge.
Thank you, Mr. Fox. You may sit down. Will you have another question? Another witness?
No, that concludes the plaintiff's brief, Your Honor.
The plaintiff is rested. Mr. Massengill, do you have witnesses you wish to call?
We do. I have Ms. Jackson, and we have, which might take a while, I've got Mr. Todd. Does Your Honor still need to leave at 4?
Well, I have to leave at 4. So will Mr. Todd be able to be, I've told you all the next day I have available, which is only because is it a murder trial that got continued on the Tuesday? I think it was a second-degree murder trial that got continued some time ago, but Tuesday is open for me. If you can reconvene Tuesday morning at 9 o'clock.
If I can.
That's fine. I'm not telling opposing counsel how to try his case, but if Mr. Todd would take half an hour, we could maybe knock that out and then get to Ms. Jackson on Monday.
You want to try to get Mr. Todd on?
Yes, Your Honor, I think it'll be fairly brief. Yeah.
Let's talk fast.
Yes, sir. You don't always do.
Mr. Todd, if you'll come up, please, raise your right hand, face our clerk.
You solemnly swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God.
I do. All right. Good afternoon, Mr. Todd. I am Philip Massengill of the Dixon Bar. Pleased to meet you, sir. How are you today?
Very good.
Good deal. Let's see. You know why we're here today?
Yes, sir.
All right. Could you please state your name for the record?
Henry F. Todd Jr.
And are you familiar with my client, Ms. Diane Jackson?
I am.
And how do you know her, sir?
She is the widow of my brother-in-law.
Right.
I don't know whether that makes us in whatever, but
relations, huh? Yeah.
Right.
And where are you guys geographically located? How close do you guys live?
Her property and my wife and I's property adjoin, and I guess my property goes around two sides of her property.
Sir. And I'll pull up something briefly so you can see just some maps and get our orientation real quick. So this is Ms. Jackson's property in question. This is exhibit previously admitted to evidence. Can you indicate for us roughly where your property is?
My property would be on all of the north and eastern side, except for the field up there right along the edge of Porter Road.
All right. Right there. Now, so you can tell us in your own words, we had been a dispute over timber contract, and how did you first become aware of the Ms. Jackson's intent to enter into a timber contract?
To the best of my memory, Ms. Jackson called me and asked me to meet with a surveyor and Mr. Boggs to show them where the property lines were located.
And did you end up meeting with them?
I did.
All right, and while you're there, were there any discussions or communications with Mr. Boggs or any other about the property lines and boundaries?
Well, yes, and the surveyor. We went several places, started out actually over on Jump Off Road in front of Ms. Jackson's house, and went through that area over into where the property adjoins onto Porter Road. And I actually identified corner pin for surveyor. And then we started north. We went along that property line, and when we got all the way to the back there, the surveyor was trying to say the property went over some other direction, and I directed him to a steel fence post that is listed on the deeds as being 150 feet from that corner. And at that corner, there's a steel pin. We didn't find that pin that day, but then we followed steel fence posts from there around what would be west, and then turned north where her property kind of juts into my property. and then back west. And Mr. Boggs was with us and the surveyor. And I remember eventually they were trying to say the property went further on down and one thing or another. Ms. Jackson got on the phone with the surveyor and told him, you mark the line where the steel fence posts are, because the fence posts were put there by a prior surveyor. And I remember distinctly Mr. Boggs told me, you got to get these deer stands off this property over here. And I said, there's not any deer stands on her property. Now, I was mistaken about one. One was 30 feet over, which we moved. But it was pretty obvious that they thought the property went further on down. But the surveyor marked the line from the steel fence post all the way around.
Right.
And then we had Mr. Boggs and I kind of sitting on his truck while they were doing. I told him I had two concerns. One was, obviously, I didn't want them over on my property. We don't cut our trees. And the other was the creek, that the creek that starts next to her house in the hollow goes down into one of my ponds and becomes a creek that goes by my house and eventually goes into Nails Creek and into Turnbull. And I was concerned about, logging activity and that creek.
What was the nature of the conversation with Mr. Boggs then?
He told me, look, that's not going to be an issue because there's a field on either side and the timber on the east side of the creek will be taken out to that field and the timber on the west side of the creek will be taken out the other side. So that made me feel better.
Everything was good. Deer stand. Addressed the survey. Everything was fine. What happened next with your involvement with this situation?
Well, I guess it was when they actually started logging. And I could see the equipment drive by, and I could hear equipment. So I walked through the woods to obviously make sure that they, were not taking any timber on my property, which they didn't do. But then eventually noticed that they were taking timber across the creek and running machinery across the creek.
What do you mean by that? Is this the creek? If you could kind of point out for us roughly where that is on there.
Well, where you have the pink section there becomes blue and it runs up toward where it says 1051 Jump Off Road.
Mm-hmm.
That is the hollow where the creek starts, and it runs all the way down to my house. And it's not a year-round, flowing creek. There are some small springs, or were small springs in there that would periodically run, but it is the same drainage that goes all the way down, and we have a pond that sits in the woods behind the house that's on that drainage, and then that drainage comes by my house, and I have a very large spring that dumps into that creek that then runs on down into Nails Creek.
And so you mentioned, dragging logs back and forth through this creek, a little bit. Tell us what you saw when you were concerned by the cutting.
Well, what I saw was trees down across the creek. And what really concerned me is I saw trees down on the western side of the creek, because I thought, they were going to take them out the other way. And I knew that, they had great big equipment, track hoe type equipment.
Absolutely. And since then, have you been back to the creek area in question?
On numerous times.
And have you noticed any changes since this debris was placed in the creek area?
Well, it's kind of two changes noticed. One was that almost immediately after they were doing the logging, there'd be sediment coming down the creek a lot more than usual. And then in the last couple of years, there's been, debris. I don't want to use the term logs. I'd say limbs the size of your leg, bigger, come down and, stop up the creek. And our pond, which it was a woods pond, and it had leaves and stuff in it, it's filled in with quite a bit of sediment.
And then has that obstructed the flow through there all the way to your property?
Well, not all the way, just probably down to that pond. That pond kind of catches, the stuff now. And we've got some trees that are dead because of where it's flattened out and the sediment.
Now, after Ms. Jackson directed for cutting to cease and and logging had stopped, did you get a chance to go back in the cutting area at that point?
Yes, I have been back through it. I can't tell you how many times. Ms. Jackson lets me hunt over there, and though we don't put any tree stands on her property, we've been through there, and I've actually been with one of her sons back through there several times who deer hunts in there.
And you testified about the debris in the creek area. While you've been back there hunting or you've gone back into the cutting area, have you noticed any litter or other kind of man-made objects left there?
Nothing other than a few drink bottles, and I can't tell you where they would have come from. I can tell you that it's very difficult to even get through there. You got to get out of the creek and go up on the side of the hillside to get through there. At least I do. I'm older now, and other people might be able to crawl through there and get through there, but I can't get through there.
How old are you now? How old are you?
I was 71.
A young man.
Yes, we are.
Is there
I've
anything?
known Mr. Todd for
46.
40 years.
46.
Almost.
Is there anything else that any other interactions with the loggers or Mr. Boggs that you'd like to discuss with the court?
The only other thing was he marked the trees to be cut in blue. And this section that wasn't cut, that juts back into us, he told me that day out there he was going to mark some that were bad trees, and there's some hollow trees and that sort of thing marked to be cut. I guess to get them out so other trees could grow. I don't know, but I knew that there's some of that, and that really what I think there's somewhere between 7 and 7.7 acres that wasn't cut, and it's that part of her property that juts into our farm.
Mm-hmm. All right, pull this up real quick. You'll be able to just point that out, just so we have our bearings real quick. Oh, it's shut down on me. Here we go. Yeah. The part that the remaining acres needs to be cut that juts into your property, if you could point that out just so we have an idea what you're talking about.
Well, I don't know how to point it out without going up there, but
yeah, I'll let
Are you tall enough to reach up there to the screen?
sure. So that's what.
Step around there and point it out where you want.
There's steel fence post here and here and here, and they cut to here almost to where this of the adjoining field comes in. So what remains to be cut is kind of across there is what wasn't cut. I think there may have been one tree right here that I saw marked blue. That would be right on the edge of that, but it was kind of like that part back.
Anything else you like to testify or discuss with the court?
Only other thing I said, my wife and I have been married, be 46 years in October, and I've lived on that place twice, but I've helped my father-in-law farm that place, and I pretty much know every foot of the place, their place and ours too.
Thank you. I'll pass the witness, Judge.
Ms. Franklin?
I'll be brief, Your Honor.
I'm supposed to tell you Miss Roberts is in the hall, and she is gonna protect me.
Oh, Ms. Roberts? I'm surprised she hasn't barged in. Wanted to touch base with you just real quick on a few of these issues. I know that you've recently retired and have gone inactive with the board, correct?
Correct.
Did you at any point in any of this litigation represent Ms. Jackson or offer her legal advice?
No, I did not. The day she told me she had received a lawsuit, I told her I anticipate I would be a witness. I cannot and will not talk to you about it at all.
Did you refer to Mr. Massengill?
Matter of fact,
What's the relevance of that? How does it matter if he did, she's related to him somehow?
Sure.
How would it matter whether or not?
I'll strike the question. Did you assist her in reviewing any of the contracts that she signed prior to the logging operations beginning?
I have never seen it.
Okay. Did Miss Jackson contact you while the logging operations were ongoing?
Not about the logging.
Did she ever call you and ask whether she should try to stop the logging operations?
No.
Did you ever tell her that she should stop the logging operations?
No. My wife and I, when I found they had been crossing the creek, considered calling TDEC. And we decided we were not gonna do that because she's my brother-in-law widow, and I thought that she would get in trouble too, so I didn't even call her about that.
Oh, I understand. I'm gonna pass you or have handed to you what's been marked as Exhibit 7, just because I think this 17, this may address a few of the issues that you've had with regards to this creek or stream that fed into yours. Were you aware that a complaint was filed with the Tennessee Department of Agriculture regarding the water quality?
No.
I'll give you an opportunity to review this document, Mr.
Which
Thomas.
exhibit number?
17, Your Honor.
17.
Miss Jackson did bring somebody from the state down on Monday, and I gave them the combination to the lock that goes into the field.
Okay.
But
Sure. And I think you can see, and correct me if I'm wrong, it looks like on page 1 of the actual complaint after the affidavit, it states that the date of the visit was August 21st. So that would be consistent with somebody coming out last week. I'm going to direct you to look on the top, or during page 3 of 6 of this actual water quality complaint. Does it seem, and correct me if I'm wrong on this, that the streams on the property didn't even meet a qualification for a intermittent or perennial stream?
I wouldn't know.
I'm just asking you, is that?
Yeah, that's what it said.
Okay. I mean, I think you testified earlier that it kind of dries up, there isn't water that runs through that. ditch area consistently year-round?
It's not a ditch. And it doesn't run year-round, but years ago, there was a spring right off the base of near where Miss Jackson's house is. And her older son got down there and dug the spring out. And it actually was running. Now, after he moved away, well, I can't tell you how often it does or does not run. I can tell you that once the stream gets out of my pond, because there's another spring there, the big spring at my house puts out, I believe it had 110 gallons a minute. And it's part of the water that goes on down. Now, where this is above that spring.
Okay. So your spring is still functioning fine?
Yes.
And
now, the spring that's in the pond that is silting in, we can't tell. I mean, there's still water coming out of the pond, but it's just seeping, and because you can't tell what it's doing.
Okay. And I think you testified on direct as well that you saw some treetops inside of this creek bed when you were walking through Ms. Jackson's property after logging operations had stopped.
Yep.
Do you know, and this is just based on your personal knowledge, what happened to cause the logging operations to stop?
The only thing I would know is what Ms. Jackson told me after the fact.
And what did she tell you?
She told me that her son told her that the creek was blocked, or there was a bunch of trees down in the creek, and she couldn't even walk down in there, and that she stopped them logging.
Did she tell you that she called law enforcement that day, or do you remember a sheriff's deputy coming out to the property?
I think she did tell me that she called them, but I never saw or talked to them.
It's your understanding that the loggers were asked to leave the property?
That's my understanding.
So you don't know if they had an opportunity to finish doing the work, like removing those treetops out of that creek bed?
I don't know that, but I do know that the trees were felled and they kept on moving toward the west and left trees across the creek. And the trees are still across the creek, and the limbs and stuff are rotting off of them now. I mean, I can't answer what was going to happen after that.
I believe you also testified earlier that you have wooded areas on your property.
Yes, ma'am.
And that you have not logged your property.
We have cut a little bit where we don't log. If I have trees come down around my pasture, I generally cut them myself. I did have, I don't know, 6 or 8 years ago, we had some trees that were leaning over dangerous. And I had a young man named Robert Wood come in and cut those, and we sold those, but those were trees that were down. My wife and I guess you'd call us tree huggers, but we don't cut the timber.
I understand. So you don't have very much personal experience with logging operations, or what's expected, or what the best practices are?
Well, what I do know is from practicing law and representing a lot of loggers, that when they crossed that creek, I would expect them to have filled that creek with gravel before they ever took a track hole across there. And then the gravel would have come down the creek instead of settlement.
So it's your understanding that gravel should have been placed? They should
If
have
you're
brought gravel?
if you're gonna cross the creek in a logging operation, then on gravel. But see, I never thought that would be an issue because they had an easy way. Just to be honest, I'm very familiar with that place. If I was gonna get anything out of those woods, even a deer, it would be out on the western side of that creek. It would be out by Ms. Jackson's house, because that's the easy way.
Sure. Do you agree that if they would have set up some type of loading deck at that location, that proposed location, which I think you are familiar with, that that was in sight of Miss Jackson's house and she would have been able to see it?
Sure.
And you know Miss Jackson pretty well, I would assume.
Yeah.
Yeah, yes. Do you know if she was concerned at all with the aesthetics of the logging operation, that she wanted it to look good?
I don't know. The only thing she ever said to me about that is, I'm not having any trees cut right at the house.
And Mr. Todd, there's been some testimony presented today about some oil cans and other types of receptacles left in the woods, specifically where the trees are laid across the creek bed. Have you ever seen any oil cans in your time walking through the woods?
I don't think I can get down into the creek right there where they're talking about, because I would have to go up on one ridge or the other on either side. I physically can't go, have not been able to go the entire distance of that since they logged it.
I understand. So but you personally have never seen any oil cans or anything like that out in the woods?
I've seen a couple of drink bottles, I think,
And that's the extent of it? Maybe
yeah, but
some
like I said,
Coke
I haven't
bottles.
been down in whatever, and I would be surprised, that how anything could get through there anyway. It's so clogged up.
Well, thank you for your time. I know that judge has to leave at 4, so
You want your exhibits back?
I will, unless Mr. Massengill has some follow-up questions.
Nothing further, Your Honor.
Thank you, Mr. Todd. Have a good weekend. You
I'll
are
be
released.
excused, Your Honor.
You are excused. Good morning. We are ready to resume our hearing in Fox Hardwood Lumber Company versus Diane Jackson. I believe the plaintiff had rested last week, or rather Friday, right?
Yes, Your Honor.
And we are now ready for the defendant's continuing proof. So, Mr. Massengill, you may call your next witness.
Call Miss Diane Jackson.
Ms. Jackson, if you'll come around, please.
If I could request leave of the court to get the projector set up.
Good luck. Gonna have to go to that. But you got it where you want it.
Yes. Great. Is this on? There we go. All right, Miss Jackson, how are you doing this morning?
Fine, thank you.
Great. Could you please state your name for the record, ma'am?
Diane Marie Jackson.
And where do you currently reside?
I live in Dixon County at 1051 Jump Off Road, Bon Aqua, Tennessee.
And you know why we're here today?
Pardon?
You know why we're here
Yes.
today? All right, so let's start from the beginning. Can you tell us why you entered into the professional services agreement with Mr. Boggs?
The reason why I did that is because I had a couple trees falling around my property. One went on my shed, and I have 15 grandchildren, and when they come to my house, the first thing they like to do is to go out in the woods. So I was concerned, well, is the woods safe? I know that Henry Todd, a branch fell down and hit him, and he ended up in intensive care. So I had that concern that maybe one of my grandkids would get hurt. So that's the reason I called Mr. Boggs. From what I looked up, what he said he did is what I wanted done, that to see if the woodland was safe and had the proper cover. He kept saying that the trees had to be open enough for the sun to go down for vegetation, and it would be healthy for the animals.
All right, and so after you guys got into the professional services agreement, what happened next?
He did a bid for the cutting of the timber.
And the bid was successful?
Yes.
And then what happened after the bid was successful?
he came over and told me about the bid. There were 12 bidders, and we agreed Fox was the top bidder, and I said, fine, we'll go with that.
All right, and then there was the standing timber agreement that was executed.
Yes.
All right, and do you remember when that was executed?
It was done on March the 6th, 2018.
All right, so after this standing timber agreement was executed, what happened next?
Not much. There wasn't, I never heard anything from Fox or Mr. Boggs until when it was almost a year. I had not heard anything. So when the contract was almost due to be up, I called Mr. Boggs and I said, do you have anything in writing? What's going on with this contract being almost finished? And he said, there's nothing in writing. And he said, I will call you back. So he called me back and he said that there was an email that gave them the extension. I said, okay, when are they going to do it? And he didn't know when they were going to be able to do the cutting. That was in 2018. 2019, excuse me.
We've jumped way ahead, so I want to go back. The timber contract you testified was executed in March of 2018. So during that time, going forward in 2018, were there, what communications did you have with Mr. Boggs or Fox Hardwood Lumber Company or any of their agents regarding the property cutting, anything?
I have never talked to Mr. Fox ever until we had mediation. That's the first time I ever met him. I never talked to Mr. Beasley until April 6th of 2019 because Mr. Boggs told me, I don't know when they're going to do it. He said, he gave me his telephone number, and that's when I called him and said, what's going on with this? When are you going to do it?
All right, and during this time, throughout 2018, what communications did you have with Mr. Boggs?
Mr. Boggs, I really didn't have any communication as far as I remember. It was just, I was just waiting to hear from him about when they were going to start cutting the lumber.
Ma'am, and it shows on. Yes, I would now briefly direct your attention to what's been previously admitted into evidence as Exhibit 18. These are the discovery responses from the plaintiff, Fox Hardwood Lumber Company. Ma'am, to the interrogatory number 6, please state all dates which Fox alleges logging was suspended by Jonathan Boggs of Arbor Springs Forestry, hereafter Arbor, and the dates on which Arbor made such suspensions. What was the response you received on those?
Objection, Your Honor. It's hearsay, and Ms. Jackson has no foundation for, she can read the screen, but beyond that has no foundation for giving any testimony on this answer.
Well, the basis for your objection would be what, Mr. Abelow? I mean,
It's hearsay.
it's a statement by your client in response to discovery, so overrule the objection. It would be a statement by a party opponent would be admissible under any circumstances. Overrule.
Would you please read the response, ma'am?
My glasses are, I can't see it. I just.
If you need to get up to approach, you may.
Can I come there?
Yes.
Are you saying 6?
Yes.
It says, please state all the dates respect to legislating was suspended by John.
What is the answer, ma'am?
None.
None. Would you speak loudly enough so the court can hear?
None.
Thank you. You may return to the witness stand, ma'am. And during 2018, similarly, did you receive any notice of suspension from Mr. Boggs?
No.
No. Okay.
I did not.
Now, during this time too, was there, with your testimony about minimal conversation with any parties, what discussions during 2018 were there about this hemp crop that's been discussed so much?
The hemp crop.
In 2018?
2018, I don't think we had any discussion because I don't remember talking to anybody in 2018 until the date of the contract was up.
All right, I'm going to pull up what's been previously admitted into evidence as Exhibit 7, the standing timber agreement. Actually, the prospectus, excuse me. So we can take a look at the map there. multiple times now. Do you recognize this map, ma'am?
Yes, I do.
And what's it a map of?
It's my property.
All right. So, and we'll get to discussions about the hemp, but even if there had been discussion about the hemp, where on your property was this hemp field located?
Where there's two fields, so one below my house on the left, and that field in 2018 was only partially filled because we didn't have enough plants. It was the first year we'd ever done hemp. To the right, where below the pink in that green area is where the other field was with the hemp.
And both these fields, what's their relationship to the blue proposed haul roads listed on that map?
Well, there are two haul roads that I was told when Mr. Boggs told me how they were going to get the lumber. There's two. There's one on the left, which would have brought all those trees in that blue part down that way. And then on the right, there's a 30-foot easement that's where those trees would have been brought down.
And a 30-foot easement, who is that? Who is the dominant stakeholder there? Who is the easement in favor of?
Me, but I share it with Henry Todd.
Now, these fields, is there any overlap with cutting areas or haul roads or anything on that map?
Absolutely not.
All right. And what was, we'll get to the concern. Well, I mean, we can do it. What was your concern with the hemp, if any?
I had no concerns because the logging had nothing to do with the hemp.
All right. Now, let's go forward in time, gone through 2018. You've kind of touched on this a little bit, but let's move forward in time. Now, what happened next in the beginning of 2019? You can recover ground.
2019, that's when I contacted Mr. Boggs about the ending of the contract. And that's when he said that they did have an extension through an email.
Approximately when did you contact Mr. Boggs?
It would have been right before the extension would have been up. I don't know the exact date, but it would have been probably the first part of March or the very end of February. I don't know for sure.
All right, and then you had those communications, and then now what happened next? You had that communication with him. Who did you next speak with?
I talked to Mr. Boggs in April because I had still not heard from anybody when they were going to do the logging. And so he said, well, you'll have to call Mr. Beasley. So he gave me the telephone number, call Mr. Beasley. I called Mr. Beasley, it was on the 6th. And I asked him, do you know when you're going to come out and do a logging? And he said he would get back with me. I never heard anything back with him until Mr. Boggs said they had done the pre-harvesting agreement and they were going to come out on June I believe the 20th.
All right, so after you spoke with Mr. Beasley, just keep walking us forward. Well, next, I want to direct your attention to Exhibit 8. It was an email with Mr. Boggs and submitted evidence. Here. You may not, and let me know if you have difficulty seeing this. I can read it for you, ma'am.
Can you read it, please?
Absolutely. Hello, Ms. Jackson. I hope you are feeling better. If you get a chance one day next week, please give me a call to discuss the timber sale on your property. I understand your concerns about the extension and not wanting to get in there while your crops are planted, as we discussed earlier this week. I also understand the reasoning from Fox Lumber that it was too wet to get the logs out from October to March to remove the logs without destroying your fields and woods. And from June until October, he was concerned about the crops in 2018. If we could talk and try to come up with a plan to get in there immediately following the crop harvest, I think they could beat the winter weather and get in there while it's still dry. I look forward to talking with you. Have a good weekend. Thanks, Jonathan Boggs.
What is the date on that?
May 31st.
May 31st? Okay.
It's been previously admitted. So here, what are the concerns about the extension that, what were your concerns about the extension that Mr. Boggs references?
Well, I understood that there was going to be 6 months extension from when the contract was, finished. And it was almost the end of the 6 months. And my concern was what happens after that? Do we have to go through another extension? Do we have to do another contract? I didn't know what to expect because I had not heard from them.
And what are, this reference to concerns about your hemp crop? Could you discuss what's going on there? What were your concerns in 2019 about the hemp crop?
Well, there was no crop planted at all at that time. The hemp wasn't even coming until the middle of July. And my concern was if they waited until that time, coming in and out of that road where the easement is, with these loggers and different people, we were going to have all these plants sitting along the fence line. My concern was we wanted to know what they were going to do because we could have made arrangements to put those plants over on my property so we could keep track. I was afraid if we left them there after they were delivered, somebody could very easily gone over the fence that had told friends or whatever and taken the plants.
Now, these plants, these hemp plants along the fence line, were they planted along the fence line?
No, they were not planted.
So they were loose?
They would have been, they would have just been, we didn't have them at that time. They would have been clones.
It was planting of seedlings.
Yes.
Now, aside from when they were by the fence line waiting to be planted, was there any issue once they were in the ground with harvesting?
No, because nobody would have been, they wouldn't have been able to go over the field because there was that easement. It's a 30-foot road easement for trucks to go up and down for power lines and stuff.
There's no issue once planted with?
Absolutely not.
So going forward now, you've had this communication with Mr. Boggs on May 31st. What happened next?
I waited until he called me and said they're going to start harvesting, that they had the pre-harvesting agreement and they were going to start harvesting. I thought, okay.
And from this point all the way back to when the contract was executed, did you receive any notification that there was only going to be the one loading area used as opposed to two in the prospectus?
I was told they were going to use two. I was told they were using both sides. That would be the best way to do it. There would be no destruction on the property.
And
I mean, pulling the logs down. I was told they were going to bring down the sides of the fence lines, and that's how they were going to properly harvest the logs.
And did you make any representations to Mr. Bogg or Fox Hardwood Lumber Company or any of his agents that you didn't want the second loading area for aesthetic reasons?
No, I just assumed that's what they were going to do. I was never told they were not.
So fast forward, what happened next? We're in June.
They showed up and started the logging, and they brought their equipment on. They started logging. They were there 2 days. Actually, they were there with 2 days for logging. There was a day they didn't show up, and then when they came on where the easement is on the right, where the 30-foot easement is, and they started doing the logging. They did the clear cutting first, and according to Mr. Jarman, he said that that was just a waste of his time. There was no value to that, and that's what he said in court. And so they finished that, and they, according to Mr. Fox, said that I kicked him off the property.
Objection, Your Honor. The witness is now just recalling the testimony of Mr. Fox here in court.
We can move on, Your Honor. Now, on that, so there's a couple of days of cutting, and then what happened next?
Well, when they did the cutting, I just witnessed what they were doing to my property. They had taken, according to the numbers that they took 381 trees in 2 days. And they had this big machine, and there's no way anybody could go in there in 2 days and cut that many trees and not do damage to the property. It's just, I'm not a professional logger, but I just went by what I saw them doing. And they went all the way to the end of the property of where they were supposed to go with the logging.
All right, and this disputed creek ditch area, where is it in relationship to your home?
if you go where they enter the log in the road, down there, it's close to that area.
Is it close to your property and visible?
Not from my not from my house. You can't see that part.
So then you're concerned about the nature of the cutting, everything. Then what happened on the day that you decided to terminate cutting?
I tried to call Mr. Boggs, and Mr. Boggs was not available. He said he would come out that night. And I just thought I have to stop the logging because of what I was noticing, what they were doing to my property. I was just very upset that they just went in and were just destroying trees. Everywhere I looked, they were just destroying trees. And so I talked to Mr. Jarman. He said that they had that right to do that. And I said, oh, actually, yes, so Mr. Fox had bought those trees, but it was my property. I owned the property, and it's not being done the way they said they were going to do it. So I did call the sheriff. The sheriff came out. Now, in the testimony, it says that Mr. Boggs was there that
Objection,
day.
Your Honor. The witness is now again recounting what Mr. Boggs said.
Staines, she can't recant what the other witnesses have said.
So I can't say that?
Oh, no, if you'll, it's getting the argument, if you'll stick with just what you experienced on that day.
Okay. On that day that I told him to leave. And Mr. Boggs came out that night and looked at it was getting dark. It was later that night, and he looked at went in a little ways into the woods and didn't say anything about the condition of anything. And he came back to me and he said, you know, Mr. Fox is already at the attorney's office. You're going to get sued. And so I asked him to take me back to his office to give me a copy of the email and a copy of the insurance, because I was never given any of that.
All right.
Then the next day is because I never told them they couldn't come back and get the logs, because they had all these logs laying around. They had cut that many trees in those 2 days. There were logs everywhere. So I said, Mr. Jarman can come back and get all the logs and take them to wherever they take them. And I just said, I didn't want any more cutting because I didn't want any more of my property destroyed.
So how many days how many days did Mr. Jarman spend coming back to the property to collect his equipment and the logs that were already felled?
I would say 3 or 4 days.
Now, moving forward in time, what communications did you have with Mr. Boggs or Fox Hardwood Lumber Company thereafter?
After the sheriff came out, that's the only time I ever talked to Mr. Beasley. I never had any conversation with Mr. Fox or Mr. Beasley after that.
Okay. And then, let's see, and what further communications do you have with Mr. Boggs?
Mr. Boggs just, I don't remember having any conversation with him. I mean, he knew that I was going to let them on the property. And then he called the sheriff on me about the 4th day and said I wouldn't let Mr. Jarman come and get his equipment. I was like, well, you had to call me to let me know to open up the gate. I did not want their equipment. I did not need their equipment. So that's the last time I talked to Mr. Boggs.
And lastly, there's been, you've seen the exhibit previously admitted into evidence regarding the recent evaluation of your property by Department of Agriculture regarding the water samples. Could you tell us what happened there?
Well, I just thought, I need to, because everybody's saying, do you have an expert? Do you have an expert? My only expert that I had was Henry Todd. And I don't mean he was an expert, but he was aware of my property and knew what was, knew where we're talking about the trees and all that. I called them because I thought, well, I need to know. But then the person that was supposed to be doing the water examples and whatever, he called me. His name was Kevin. I don't remember his last name. He called me and said that they had to call Mr. Boggs and wanted to know what was going on with the cutting and everything. And he said Mr. Boggs or somebody from Fox was going to come out with them, that they needed to come out with them. I said, no, I don't want them to come out. That was into that.
All right. And
oh, well, I do want to say this. Well, when they came out, we went into the field And we went to where they entered from the field into the logging area. And those two men and myself, we couldn't even go down into that area because it was so blocked. They couldn't go down in it. So we had to go back to my house, and they went from my house down the back of my house down into where the trees are and stuff, not the trees that they were logging. And they were down there for about 15 minutes, and they came up and they said, this has been 5 years ago. We don't see any damage. And that's basically what happened with those people, and they left.
And as far as the contract extension, all those questions, at what point did you have an impression that that there had been an extension and the contract had lapsed?
The extension, are you talking about 2019 or what are you talking about?
2019, whenever, I'll move along. Now, is there anything else that you think the court needs to hear or anything else you'd like to testify about today?
Actually, Your Honor, calls for narrative. Calls for narrative. It's an open-ended question.
Let's let her have her say though, overall.
The only thing that I thought I had, I thought our video would show that there is damage done. That was my biggest concern, was what am I going to do with this property that has just left a mess? I thought it was going to be, safe. You can't even, we used to be able to take a four-wheeler and go from the field down into the woods. That doesn't exist anymore. And that's where, when those two men from the forestry, that's where we went. And you couldn't get down in there because it was just all blocked up and a mess.
Thank you. I'll pass the witness, Judge.
Could I get a drink? I mean, Phil, can you?
Can I approach you?
Thank you.
Good morning, Ms. Jackson.
Good morning.
As you know, I'm Mike Abel. I represent Fox Hardwood Lumber Company. Yes, Your Honor, we're going to put up a couple of exhibits. Could we have access to the screen? I think I just need you to switch it.
I have to switch it. I've disconnected.
Okay. As you know, I'm Mike Abel. I represent Fox Hardwood Lumber Company. We met before in your deposition at the mediation.
That's correct, yes.
The first thing I want to talk to you about is your relationship with Mr. Boggs and his company, Arbor Springs.
He was my agent for getting the contract and making arrangements for the logs to be logged.
He was your agent to make sure that Fox followed the guidelines with regard to logging?
Yes.
And you put Mr. Boggs out there in the world on your behalf, correct?
Yes.
I now want to ask you about the contract drafting and review. That standing timber sale agreement, that was drafted by Mr. Boggs.
Yes.
And Mr. Boggs was your agent.
Yes.
And you had an opportunity to review the standing timber sale agreement.
Yes.
Before you signed it.
Yes.
And you had no comments on the standing timber sale agreement.
Are you talking about the bid to the people that were going to go out there? Or are you talking about the original one? I mean, the one that was, I signed for them to, Fox to do the bid.
That one, ma'am, the contract with Fox. That's the standing timber sale agreement. Do you understand that?
Yes.
Okay. Mr. Boggs sent you a draft of that agreement. Do you recall that?
I don't think he sent it to me. I mean, what do you mean? Send it through an email or?
Yes, ma'am. He emailed it to you. Do you recall that?
I don't remember that, no, but he may have. I think he sent it to my son.
Ms. Jackson, I've handed you what's previously been admitted as exhibit number 5.
Okay.
You see, this is an email from Jonathan Boggs to a number of people, including yourself.
Yes, I because he did say, I told him I was going to be leaving. I wanted to get that done.
And that Diane.Jackson1@yahoo.com, that's your email address?
Yes, it is.
So Mr. Boggs did send you a draft of the timber sale agreement to your
I don't remember that.
Do you dispute that you received this email?
I can see where I received it, but I don't remember getting it.
Right.
I don't always look at my emails, basically.
You mentioned your son Brian Jackson is a lawyer,
Yes,
and you did not ask your son Brian, the lawyer, to review that standing timber sale agreement, did you?
I didn't think I had to.
Your
I thought it was, it was from Mr. Boggs, and I just thought, why would I, didn't think it was legit.
So again, you did not ask your son Brian, the lawyer, to review the agreement, correct?
No, I did not, he was really like, Mom, why didn't you do that?
Your Henry Todd is your brother-in-law?
Yes, he is.
He's a retired lawyer?
Yes, he is.
Did you ask Mr. Todd to review the agreement?
Did I ask him what?
To review the agreement before you signed it?
No, I did not. Mr. Todd has never been involved with anything about the agreement, because he said he was going to be possibly a witness, and he said absolutely could not look at the contract. He could not talk to me about it, and he never did.
Ms. Jackson, I now want to talk to you about the term of the agreement. And first, I want to talk to you about the hemp crop in 2018. 2018 was the first year that you decided to grow hemp on the property.
That's correct.
And your son Jeff was growing that hemp crop with you.
Yes.
And your son Jeff is the voice we hear on the video that
Yes.
was previously admitted. This was the first time you'd ever grown a hemp crop.
Yes.
And the hemp growing season is you plant in July and you harvest at the end of September.
The end of September, first part of October.
Your hemp plants were worth $100,000.
Are you talking about when we sold them or what we paid for them?
You said that crop was worth $100,000. Do you recall that?
No, I did not. I think our plants were worth that because we had to pay a lot more because we had decided late that we were going to buy these plants, and they were $100,000.
So the hemp plants were worth $100,000.
Yes.
And you did not want strange people coming in with those plants sitting there.
Correct.
That
was in 2019.
Wasn't it also true in 2018?
Well, those plants were already planted.
You thought the loggers might step on the plants?
No, because there was a road. There was no way there would be no reason unless they were just purposely trying to damage the property or the hemp. There would be no reason. There wasn't anywhere near the plants and the road where they went.
Ma'am, do you recall that you gave a deposition in this case about a year ago?
Yes.
And I asked you about the hemp crops?
I don't remember what you asked me, to be honest, but
I'm going to turn my hands to it. Turn your attention to page 182.
okay. Am I supposed to read it off or what?
You see on page 182, line 22, you talk about people running over the plants.
It says they couldn't run over the plants. Stealing plants or whatever,
You said you didn't want the leaving the gates open, people coming in and run over the plants. Do you see that?
Well, the only way they could run over the plants is they were doing it to be vicious, because where the road is, where the trucks would be or wherever, had nothing to do with where the plants were.
You were also concerned about people stealing the plants.
I was only concerned about when the plants were being delivered in July of 2018 or 2019.
So you told the court here today that there's no connection whatsoever between the plants and the ability of the people to do the logging. You recall that in your direct examination?
There was, no, there wouldn't be any way of damaging the property if they stayed on the road they were supposed to. The only time I was concerned in 2019 was when the plants were being delivered, that somebody along the fence line could possibly steal them. We would have had to have made other arrangements to put them over on my property by my house.
Ma'am,
It confused me by,
there is a connection between the hemp crop and the logging. You agree with that?
No.
Okay. In Exhibit 8, Mr. Boggs told you that from June until October 2018, Fox was concerned about the crops. Do you remember that document?
Where is this document?
I can hand it to you. It's up on the screen. Can you read that? No, I can hand you a physical copy.
Read it.
Let me hand you a document.
Oh, okay. I think we already went over this, right?
Didn't direct, I'm asking you a question about it.
Okay.
You see at the bottom of the first paragraph, it says, and from June until October, he was concerned about the crops in 2018. You see that?
When I are talking about that, we're talking about the plants were not planted on that in that time. There were
And I
no
just asked you if you saw, do you see that in the email?
about my concern.
That there's a concern about the crops in 2018 from June to October. Do you see that statement in Mr. Boggs' email to you?
I see where it says there while your crops are planted.
And this is an email to you from Mr. Boggs dated May 31, 2019. That's to you received that email.
Yes.
And you never objected to that email and said, what are you talking about, Mr. Boggs?
Well, I guess not.
And Mr. Boggs is your agent.
Yes.
I want to now talk about the rain from October 2018 to March 2019. That same document we're just looking at talks about it was too wet to get the logs out from October to March. Do you see that in the document?
Yes.
To remove the logs without destroying your fields and woods. You see that?
Are you talking about this one?
Yes, ma'am.
I see where it says beat the winter weather and get it while it's still dry.
And the concern is to protect your property, right, without destroying your fields and woods.
In 2019?
In 2018, ma'am. October 2018 to March 2019. That's what the time period is.
This is what I'm reading is 2019.
Correct, but he's talking about the October 2018 to March 2019 period. Do you see that?
Okay.
Okay. And you didn't object to that statement, did you?
No.
And you heard Mr. Boggs, Mr. Beasley, and Mr. Jarman testify that it was too wet during that time period to log.
Yes.
And you have no basis to dispute that, do you?
No.
You're not an expert on logging operations.
No, I'm not. That's why I hired Mr. Boggs to do that.
You heard them testify that the logging was possible, it just would have damaged your property.
Repeat that, please.
Logging was possible, it just would have damaged your fields and woods. Do you remember that?
No, I mean, that's not true.
We've seen, and there's been admitted Exhibit 13, which is the meteorological records from the National Centers for Environmental Information. Do you remember that exhibit?
Yes.
And that had the correct location of Bon Aqua, Tennessee, did it not?
It did.
And you live at 1051 Jump Off Road, Bon Aqua, Tennessee.
Yes.
And the timber tract is right behind the house at that location.
Behind my house. No, it's not where the main logging was done. Where the logging was done was on the side of my house, from where you enter the field to where they start the logging. That's where the main part is. And where they went down behind the thing, there wasn't hardly any logging done there because that was close to my house and that's where they were going to do the trees. up by my house, but that never got done.
Sorry, I didn't ask a good question. The
Oh.
the logging location was in Bon Aqua, Tennessee,
Yes.
correct? And so that meteorological report is for the right location for the logging?
Yes.
And you don't dispute those are the correct rainfall totals for that October 2018 to March 2019 period, do you?
No, because I don't remember how much rain we had.
And you don't dispute the expert's testimony that it was too wet to log based on those rainfall totals? I want to now ask you about the March 2019 extension that Mr. Boggs granted. You said right before the agreement expired in March 2018, you called Mr. Boggs and asked what was going on. And you said you had not heard from Fox.
Mr. Fox?
Yeah, or you did not heard about when logging was going to start.
No.
Correct. And Boggs said he would call you back.
Yes.
And then Boggs called you back, right?
Yes.
And Boggs said there was an extension.
Yes.
And you said, okay.
I assumed it was okay. It was coming from Mr. Boggs. So why would I not say that?
You said okay to the extension. Okay. You deferred to Mr. Boggs's judgment that there was an extension.
Yes.
In April 2019, you called and asked when the logging would occur.
Yes.
And that's after the 1-year original expiration of the agreement.
Yes.
And we've seen that document Exhibit 8, May 31. Mr. Boggs emailed you and talked about the extension.
Yes.
And you didn't say it's too late, the agreement has expired.
No. My concern was I'm allowed to answer that. My concern was, okay, he brought up about the extension. It was almost at the end of the extension for the 6 months. What happens after that? I mean, do we go another 6 months or that was my concern.
So the original term of the agreement ended March 8, 2019, right? And a 6-month extension would take you 6 months past March 8, 2019.
September 6th.
Right. So there was still several months more to complete the logging.
They started in June.
So that would take us to, if I'm doing my math right, October 8th, right? April, May, June, July, August, September 8th, sorry.
Okay.
Right?
Mm-hmm.
Is that correct?
Yes.
Okay. Your 2019 hemp crop was going to be planted on July 10th of 2019.
Yes.
And you wanted the timber cutting to be done before the hemp crop was planted.
I just thought it would be a lot easier for everybody if it was done.
And so
We had already waited a year and some, there was no reason for it. It wasn't wet. I didn't understand why they couldn't get in there and get it done.
So that, as of June 20th, 2019, the agreement had not expired.
What's the date?
June 20th, 2019, the agreement had not expired.
No.
Correct?
Yes.
Okay.
I'm getting confused about these dates. I mean, I'm trying to answer honestly.
Sure.
Just,
When they came in June to do the logging, the agreement was still in effect.
As far as what Mr. Box told me, yes.
And you had agreed to that extension.
I was told I had to.
Well,
I said yes,
Okay.
because I didn't think I had an option.
They came out for a pre-harvest meeting.
They didn't see me and nobody called to open up the gate. So they had to climb over the gate. They didn't talk to me or to my son.
You knew the pre-harvest meeting had occurred.
That's what Mr. Fox had told me. Not Mr. Fox, Mr.
Mr.
Boggs.
Yes. Okay. Now, the first day of logging occurred, right? And you were aware of it.
Yes.
You heard the equipment.
Yes.
You did not object to the logging on that first day. The second day of logging occurred. Yes.
Yes.
You were aware of it.
Yes.
You did not object to the logging on that second day.
But that's the day I told them to stop. They said they had 2 days of logging.
Right. You object on the third day. Is that not right?
I was under the impression that they skipped a day. They did the logging, skipped a day, and then they came out, which would have been the third day, but it would have been the second day of logging.
So they were there on your land for 2 days.
Yes.
And you did not object to anything they were doing those first 2 days.
Not the first day because I had not seen what they were doing. The second day I did, that's when I stopped the logging.
Ma'am, do you recall the testimony that there was a Thursday, a Friday, and then the Monday, June 24th was the day you objected?
When did they come out though?
Thursday.
Thursday, they didn't come out Friday, Saturday, or Sunday, as far as I know. They came out Monday. I was told they were just there 2 days, from what I remember.
I want to now talk to you about your decision to cut off the ability to log. Mr. Boggs was your agent.
That's correct.
And he was your agent to make sure that Fox followed the guidelines Fox was supposed to regarding the proper care of the land and cutting the trees down. You hired Mr. Boggs to determine if Fox was doing what Fox was supposed to do.
Yes.
And we've seen in the timber sale agreement in section 7 that seller's agent had the right to suspend logging operations if in the judgment of seller's agent there were poor logging conditions. Do you recall that?
So this is the contract, right?
Yes, ma'am.
Okay.
If you look at section 7.
Okay. Yes, I see that.
You see it says seller's agent reserves the right to suspend any part or all the logging activities whenever in the judgment of seller's agent such activities due to inclement weather conditions or poor logging practices are determined to be injurious or harmful to the property of seller.
Yes.
And seller's agent is Mr. Boggs.
Yes.
And the seller is you, right? You're the seller.
Yes.
And the seller's agent never determined that there were poor logging practices.
Well, he didn't come out until that second day at night after I had asked him to leave, because I tried to call him before. Sheriff, I had to have the sheriff come out, and he was at another site. He said he couldn't come out till later.
You made the determination that there were poor logging practices?
Yes, because of what I was watching being done.
And you're not an expert on logging practices, are you?
I'm not, but I'm an expert on my property and felt like I had the right to tell them that they were not doing it right according to what I was seeing, and that I had the right as a property owner to say, you have to leave. And that's what I did.
You told Mr. Jarman he needed to leave your property?
I asked him to leave, yes.
You told him you're not going to destroy any more of my property, get off?
Yes. I don't know if I said it like that, but I asked him to leave right then and stop until I had a chance to talk to Mr. Boggs.
Can you pull out your deposition transcript there, ma'am? I turn to page 142. And look at lines 3 to 12.
Okay.
You see on line 17, you say, quote, no, you're not going to destroy any more of my property, get off. That's what you told Mr. Jarman.
I guess I did. I don't remember. It's been 5 years ago.
And you gave this deposition on August 29, 2022?
Yes.
And you swore to tell the truth?
Yes.
And you did tell the truth?
I think I did, yes.
And your memory was fresher then than it is here today?
What are you asking?
Your memory was closer in time to the events in question on August 29, 2022 than it is here today. Would you agree with that?
I guess, yes.
When Mr. Beasley arrived and said he had the right to be there, you said, quote, you are leaving my property, you are destroying my property.
Mr. Beasley?
Yes.
Well, the sheriff was there, and I just said, my property, from what I was watching being done, the way they were doing the logging, yes, it said, they're leaving.
If you'll turn to page 52 of your deposition, line 24.
Okay, line what?
You see, you gave me a quote there about what you told Mr. Beasley,
What number did you
page
say?
52, line 24.
Okay. I was just trying to say they have the right. And I said.
Can you speak up? Can you speak up?
Yes,
What did you say?
I told them that, they have the right to be there. That's what Mr. Jarman said. And I said, you're leaving the property.
You're destroying my property. Go to the top of the next page.
Okay, you're destroying my property. And that's what I thought was happening, yes.
And they left within an hour.
I needed to sooner.
You did not talk to Mr. Boggs before you called the sheriff?
I couldn't get a hold of him. He was at another side, I was told. He'd come out later when he could.
Ma'am, you recall when you gave your deposition testimony that you told me a couple times that you would have to have a professional come out to tell us how Fox allegedly breached the agreement between you and Mr. Fox?
I thought I could get one, but I couldn't find anybody that could do that.
And
I was just told, my attorney said that would make,
I don't want you to tell me anything your attorney told you, but you recognized in your deposition that you needed a professional to back up your claim that the agreement was breached.
I assumed that, yes.
And you've never obtained a professional to do so,
I
have you?
couldn't find somebody to do it.
I want to now talk about the complaint to the environmental department that you made. On August 16th, you made a complaint to the Tennessee Department of Agriculture. Is that right?
I didn't make it as a complaint. I just wanted to know if they could come out and look at my property and see what they thought.
And you did that on August 16th of this year. That's less than 2 weeks before the trial of this case.
Yes, and that's why I just thought, well, maybe I'm being unfair. But I thought if I could get, because I never got a professional, I thought if anybody could tell me, what they looked at. But like I said, we started at where the field went into the thing, and they couldn't even get down in there. They went down from behind my house later because we had to come back around because they couldn't get down through that area because there was so much debris. So they came around, they went down below my house where there's very little logging. They were down for about 15 minutes and came back up and said, it's been 5 years. There's not much we can tell.
The department examiners visited your property on August 21st of this year, and they determined there was no skid trails violation.
They didn't get that far.
Well, they determined that there was no skid trails violation, did they not?
I don't see how they could have said that. I mean, they might have said that, but they didn't have 15 minutes. They couldn't have walked back that far because it's pretty far from.
Jackson, I've handed you what's previously been admitted as Exhibit 17.
Okay.
See on the page 2 of the report, it says, describe skid trails violation, and the answer is no issues found, skid trails naturally regenerated.
Well, I don't know where they walked, so.
So you're disputing the adequacy of the investigation by the Tennessee Department of Environment?
No, not doing that, but like I said, they weren't there long enough to go to the area that I was concerned about. It would be at least, I would say, half hour, 45 minutes to get over there. That's where the trail started, where the skid marks would have been, and that's where we tried to go over there, going down to see where those skid marks were, and we couldn't get there.
The examiners from the department determined that there was no stream. Do you recall that?
Yes.
And if you look at the next page, they say they determined that the quote streams on the property did not meet the criteria for classification as intermittent or perennial streams. Do you dispute that?
I can see that, but I don't understand what those are. That's what Henry Todd was, am I not allowed to say that? Henry Todd is the one that's familiar with all the streams. I don't know that much about Nels Creek and those areas. And like I said, my concern was that they called Mr. Boggs to get his opinion about what was going on. And Mr. Boggs or somebody from Fox were going to come out with him, and I said, no, I did not want them to come out. So I'm not sure that they went to the areas that I was concerned about.
Do you see on the last page, they found no water quality issues, no water quality violations?
Well, the person that the water quality person, he's the one that did not come out. And he's the one that his name is Kevin, and he's the one that called Mr. Boggs. And he called me to say that they're coming out, and he told me, he said, it's been 5 years ago. There's no way we're gonna be able to determine that.
You initially in this case listed the state's forester, Tristan Forsberg, as a witness on your behalf, did you not? Tristan Forsberg, one of the examiners, you listed him as a witness in this case.
He came out, yes, but another man came out that I had no idea who he was.
And you listed Mr. Forsberg as somebody you were gonna call in this case, correct?
Well, I guess if it, I was told that it's too late for all that.
But
I was told that we had to have at least 10 days for discovery, that would not be, you couldn't do that.
But Mr. Forsberg's report establishes there was no damage to your property.
No, he does not, because the video shows there was damage done, and also Mr. Todd's testimony that there was damage done.
Now, with regard to Mr. Jarman, you heard him testify that the tops that were left in the ditch would have been removed as part of the normal logging process. Do you recall that?
Yes.
And Mr. Jarman didn't have the chance to pull those tops out of the ditch, did he?
We had three to 4 days after they stopped the logging, because they went back and took all the trees. There were a lot of trees everywhere. And he had plenty of opportunity to do that, but it was never done. There was no seeding done. There was no filling in the ruts. They had days afterwards. They could have stayed longer if they needed to, but they took the logs and left.
One of the complaints well, let me back up. If you'll turn to page 148 to 150 of your deposition.
You said 148?
148.
Okay. All right.
You see that discussion there that they did not have the chance to remove the items left on the property because you terminated their access?
Well, they said there were cans there, but they're saying that they weren't there, so.
You terminated Fox's access to this property, did you not?
Not until they took the logs until they took all the logs that they had cut, which I didn't have a problem with that. My concern was I did not want them to do any more destruction on my property, getting the other 183 trees.
See on page 150, I asked you if they had a chance to remove any litter.
I don't know what number.
Line 23.
Okay.
I asked you, they didn't have a chance to remove any litter under section 11. You see that?
Well, it says they didn't get a chance, but if they were there 3 days afterwards, that they're pulling all these logs out, wouldn't you think if they saw the litter that they say they never leave it, they would take it?
You see, I asked you, they didn't have a chance to remove any litter. And I said, is that right? And you said yes. You see that?
Okay.
You didn't tell me about this extra 3 days at the deposition, did you?
Well, I assumed that you knew. Because they were there. How else did they get all the logs? And like I said, Mr. Boggs called the sheriff on me 4 days later to say I wouldn't let them get Mr. Jarman's equipment off. Well, why would I want the equipment? What was I going to do with it? And there's a sheriff's report.
Ma'am, how would you characterize your memory?
Well, at 75, I would say probably pretty okay, but 5 years ago, I don't, it's hard to remember what you did 5 years ago.
You remember I asked you in your deposition if you recalled having a contract with Mr. Boggs?
Yes,
And you said you didn't remember?
I don't know why I would have said that, but I,
Can you turn to page 22 of your deposition, lines 4 to 6?
why would I say that? I don't understand that. Page 122?
Page 22, lines 4 to 6.
Okay, what line?
4 to 6.
Okay, did you have a contract with Mr. Boggs?
What did you answer?
No, but I don't know why I would have said that, because I obviously did.
Right. So
I'm not trying to lie.
I know, I'm just asking about your memory. I'm not saying you're lying, I'm asking you about your memory.
I must have misunderstood what you were asking me. That's all, because I'm not that far gone that I would not have said yes to that.
I also asked you if you had previously ever entered into a contract with any other company to harvest your timber. Do you remember that?
I did not.
And you told me you did not.
I
Right.
did not. I never signed any other contracts.
Your Honor, may I approach?
No.
This will be a new exhibit, Your Honor, for impeachment.
That was in 2017.
Yes, ma'am.
Okay, I never signed anything.
But you recalled in your deposition you denied ever having had any such agreement?
I didn't remember that.
Okay.
I mean, I know I did not sign a contract with any other logger. The person might have come out to the house and talked to me about it, but that's as far as it went. And that's what I ended up talking to Mr. Boggs.
Your Honor, move to admit that document as Exhibit 19. We've already established that you got the draft timber agreement by email from Mr. Boggs. You saw that earlier today, where he sent you a draft of the agreement. And today you testified you didn't remember getting it from Mr. Boggs.
I'm confused. I don't know what, you're confusing me with this date, that date, this. I don't know. I'm trying to be honest. I just, you're confusing me.
Ma'am, one of your goals in harvesting your timber was to get as high a price as possible.
My goal was to make the logging area safe for my grandchildren, so that it would be safe for them to run around and nobody would get hurt.
Can you turn to page 23, line 12 of your deposition?
Okay. Of course, I would have tried to get the highest
Can
price.
you read what you just
It
read?
says, so its incentive was to try to get it the high price as possible.
Can you slow down and just speak into the microphone? What was your goal? As you
Well,
said, as you told me in your deposition.
My goal, like I said, was to do that, but to get the highest price, if you're going to sell timber, I guess you had bids, you would want the highest price, right?
You wanted the clear cut on the property so that you could plant more hemp crop, correct?
But that wouldn't have been done for a couple of years because it would have had to be developed. But while they were there, I thought we might as well just extend it. It was only 8 acres, so.
So you wanted the property the clear cut portion so that you could eventually plant more hemp crop.
Yes.
Which would be profitable to you.
Yes, but we only did it for 2 years because.
And the clear cut in fact occurred and happened over the first 2 days of logging.
That's what I was told.
So that's what happened.
I was told, they did it the first day. Because in those 2 days, they did the clear cutting, plus they took 381 trees.
So Mr. Boggs was your agent.
Yes,
He granted an extension.
yes,
And you said, okay.
yes.
No further questions.
MegsCW, you may redirect.
Thank you, Your Honor. Briefly. Ms. Jackson, you testified that at the time the cutting commenced, you were under the impression that the timber contract had been extended by Mr. Boggs.
Yes,
Now, in light of that, do you believe today that the contract was still in full force and effect?
yes. I mean, what are you asking me?
Objection, Your Honor. The witness has already answered the question.
I'm sorry?
The witness answered the question, and now I think counsel is not satisfied with that answer.
All right, no further questions, Judge.
Ms. Jackson, let me ask you a couple of questions.
Yes,
I know that this was introduced as Exhibit 19, and back in 2017, you had some discussions with somebody named Stacy Whitlow regarding a possible timber contract, but you said that was never signed, correct?
as far as from what I remember, no, I just was trying to find somebody to do the timber cutting, so I interviewed somebody else and also interviewed Mr. Boggs, from what I remember, and decided Mr. Boggs had the best solution for what I wanted done.
All right. And had you ever had your land timbered before?
Never.
Had you ever seen any property that had been timbered before?
My neighbor had done some clear cutting.
Okay, clear cutting is different than select cutting, though, you
Yes,
understand
I'm
that?
aware of that.
And what was your expectation when you agreed to sell this timber to Fox Hardwood about the condition that this property was going to be left in after they went in and cut all of these trees?
I thought they were just going to take the trees along the sides. There wouldn't be that much damage. It would be, I knew there were going to be trees gone, but I didn't think it was going to look like it ended up looking like.
All right. Had you ever gone online, as a lot of people do, and done any Google search for what property would look like after it had been timbered? Anything further?
No, Your
Thank you, ma'am. You may step down.
Thank you.
Witness proof, Judge.
Defendant has rested. Mr. Aguilar, do you have any rebuttal proof?
No, Your Honor.
I'll hear you an argument.
Thank you, Your Honor. There's 3 key points I want to address today in closing. The first is that Fox Hardwood was actually the owner of the timber under Tennessee law until the agreement terminated. The second is that the defendant extended the right to enter the termination date beyond June 24th, 2019, as the defendant just admitted, and as all the evidence shows. And the third is that the defendant acted at a minimum recklessly by stopping the logging without any basis, backing up her demand by calling the sheriff, kicking the loggers off without having any expert basis for doing so, without consulting with Mr. Boggs. So the first point, that Fox owned the timber, the standing timber sale agreement, which is Exhibit 7, establishes this. Sections 1 and 2 provide that the seller hereby sells and the purchaser hereby purchases all timber. That's Section 1. And Section 2 provides that she is conveying title to the timber and guarantees title to the timber.
Trying to get this camera.
Yeah, no problem.
I'll make a record of it so that if I have to refer to it later and I wanted to get on camera what you've got, go ahead.
Okay. And our ownership right, and this is important for the conversion claim and punitive damages. Fox's ownership continued until termination of Fox's right to entry. This is from the Bond case from the Tennessee Supreme Court in 1914, which is an old case, but still good law and still cited. The facts there were that Sally Bond, very similar to this case, Sally Bond had sold and hereby transfer and convey unto the Hatchie, the manufacturing company, all the timber.
She had 5 minutes, 5 years there to cut. And what the court said is that such a deed passes a title to the timber subject to defeasance with the termination of the grantee's right of entry. So the law is that Fox owned the timber until the time for logging had expired. And Ms. Jackson just admitted, and all the proof establishes, that as of June 24th, 2019, when she kicked Fox off the property, the time to log had not expired due to various things, which we'll talk about. But that means that sitting there as of June 24th, 2019, Mr. Jarman was right. That was Fox's property that she was denying Fox access to by force of law, by force of the sheriff. The second point, and this was just conceded, so we don't need to belabor it, but the defendant extended the time for entry removal in 3 ways. The first is this hemp crop, that the request that the logging not occur until the hemp crop was harvested in 2018. The second is the wet weather extension. And the third is by permitting logging to begin on the first 2 days without objection. So the first one, the hemp crop, June to September 2018. She testified in her deposition that she was concerned that loggers would steal or damage her hemp crop, page 183, lines 4 to 13. She testified that these hemp plants are worth money, they're worth $100,000, which she affirmed today. She said she didn't want, quote, strange people coming in. She thought people might steal the plants, take them, step on them. Who knows what they could have done? So regardless of whether that's right or whether, Your Honor, there was a miscommunication between Ms. Jackson and Mr. Boggs, the key point is that Mr. Boggs understood something from Ms. Jackson, which was she did not want the loggers there while the hemp crop was planted in 2018. Rightly or wrongly, that's what he understood, and he as her agent then passed on that request to my client. And my client, as a courtesy you heard from Mr. Fox, agreed to that. So we were trying to be a good contractual partner and be a good, to make this thing go smoothly to accommodate her request. So Mr. Boggs testified that he shared defendants' concerns about theft or damage to the hemp with Mr. Beasley, and as a courtesy, Mr. Beasley and Mr. Fox agreed to delay the logging. Boggs confirmed that in writing. This is not just Mr. Boggs' testimony. Exhibit 8 establishes this, and this is an email that went to Ms. Jackson, which we just went over with Ms. Jackson. It says, and from June until October, he was concerned about the crops in 2018. Again, rightly or wrongly, Mr. Boggs got that idea, passed it along to Fox, and therefore that is a sort of contractual fact because as Ms. Jackson just testified, she put Boggs out in the world to act on her behalf. That was her words of what an agency relationship was, which is actually a fairly good summary of the law of agency. And critically, as I just established with Ms. Jackson, she said she received that email and she did not object or respond to it. So her testimony today that it's all wrong is kind of too late. She, at the time, empowered her agent with this information and he told her what he was going to do and he did it. You're going to hear from opposing, I think, that this extension was not in writing. It should have been. That's actually not true as a matter of the contract. Mr. Boggs testified he agreed to the extension. Exhibit 8 is in writing, so even if a writing was required, it's there. But regardless of that, under clear Tennessee law, even if the extension had to be in writing under the contract, the case law basically overrides that. This is the Lancaster case from the Tennessee Court of Appeals in 2011, deals with this exact same scenario where a contract says you can't modify the contract except in writing. And the Court of Appeals says, generally Tennessee courts follow the rule that allows contracts to be orally modified, even if the contract specifically state that the contract can only be modified in writing. It says men cannot tie their hands or bind their will so as to disable them from making any contract allowed by law. So essentially the new contract for the extension is a new contract allowed by law, which Ms. Jackson empowered Mr. Boggs to agree to as her agent. He agreed to it, and that's sufficient to make a new contract. And that's what the court says in the Lancaster case. So it just does not have to be in writing as a matter of law. The second extension was avoiding damage
to defendants' fields and woods from logging on the wetland. And this is after the hemp crop is harvested in late September 2018, all the way through March of 2019. And what you heard, Your Honor, from all of the experts, the 3 experts in this case that were qualified, they all said consistently that logging is possible. You could get in there, but they all testified that it would tear up the defendant's fields and woods. So this was a extension for Miss Jackson's benefit to protect her fields and woods. You could have done it, but we didn't. And Mr. Boggs testified he wouldn't have allowed it during that time period. So he just would not have allowed it. And the testimony was clear that it was too wet to log from October 2018 to March 2019. Boggs, defendant's agent, said it could have been logged, but it would have been damaged. And then we had that Exhibit 13 data, which Mr. Boggs testified about, that confirmed it was too wet. And some of these totals are quite high, including February 2019 to 12.29 inches. And if any confirmation was required, again, this extension under the agreement does not have to be in writing, but it was put in writing. It was too wet to get the logs out from October to March, to remove the logs without destroying your fields and woods, which is consistent with what everyone testified to. That's part of Exhibit 8. Your Honor, there's been an argument or a hint of a question that that's not how the contract works. What the contract says is you can suspend logging operations, and that's just the intent of the contract. That's a futility. They should have, I guess the argument would be, you should have started the logging operations and then said it's too wet. So basically they just short stopped it. They said, we're not even gonna get started. You can't start the logging operations. That's the effect of a suspension. So that's sort of a red herring or a nullity. The intent of the contract was not to damage Miss Jackson's land, and it would be a futility or an exercise in futility to make them go on there, start the logging, and then say, oh, it's too wet. So rather than do that, they just said, you have an extension in order to not damage the land. And that's what Mr. Boggs agreed to. Miss Jackson did not object to. Miss Jackson just testified that she deferred to Boggs in granting the extension, as she also confirmed in her deposition. Should you defer to Mr. Boggs's judgment that there was an extension? Yes. Further, as she just testified, and she testified in her deposition, she agreed the term had not expired as of the date she stopped logging. I asked her, and the term of the agreement had not expired when you kicked them off the property, correct? Yes. And she also just testified to that at the very end of redirect. So the agreement clearly, and was admitted both in deposition and court, was in effect as of June 24, 2019. So any argument that the term of the agreement had expired is contradicted by Ms. Jackson's own testimony. I'm just making the point here that the weather extension was automatic. It did not have to be in writing. Mr. Boggs drafted the agreement. He testified that it was automatic. He testified it did not have to be in writing. That's also a natural reading of the contract. And he testified it was granted due to poor weather and the risk of resulting damage. The third extension is that the defendant knew that logging was occurring and did not object, thereby waiving any objection to the logging based on any alleged expiration. She testified in her deposition and here today that she knew the logging was occurring on the first 2 days. I asked her, the first 2 days you did not object to the logging, correct? Yes. And under Tennessee law, the defendant's permission to enter the first 2 days to log waived any alleged termination of the agreement and modified any expiration. This is from the Tennessee Court of Appeals in the Carver case, a similar case dealing with dealing with an extension of an expiration date. And the court talks about, basically applies the law of waiver to that context, and it's no different than any other context of law of waiver. You can waive an alleged expiration date by course of acts or conduct, or by neglecting and failing to act. And that's what she did here. She knew the logging was occurring. The first 2 days she allowed the logging to occur, made no objection, and then on the third day went out and objected. And that's too late. It's too late for her to argue based on that conduct or failing to object. That's too late for her to argue that the agreement had expired. In one of the crosses last week, we heard about, well, it only extended the time for restoration, not the time to actually log. That's contrary to the plain language of the agreement. The agreement is not ambiguous. Section 4, suspension is due to inclement weather impacting either restoration or removal. This is from section 4. So should restoration work or timber removal not be completed, the purchaser shall be granted an additional period for such restoration equal to the time of suspension. And Mr. Bogg, if this was ambiguous, and I don't think it is, Mr. Bogg testified in his common sense that restoration can only occur after logging. You can't restore it until you log it. So the agreement is not ambiguous. By giving an extension for restoration, it's also giving an extension for logging. That's the natural and plain reading of the words. But if there was any ambiguity, Mr. Boggs drafted this agreement. He said that's what it means. That was his intent in drafting it. The third point I want to make is that defendant acted recklessly on June 24th, 2019 in stopping the logging. She had an expert agent, Mr. Boggs. She testified she did not know anything about logging operations. She permitted the first 2 days of logging without objection, and she rashly stopped Mr. Jarman on the third day of logging. The court heard from Mr. Jarman and can judge his credibility, but he, logger of the year 2 times, very careful, fair logger, trying to work with the defendant. And she really just went off half-cocked without a basis and without obtaining the advice of Mr. Boggs. And then she made matters worse by, rather than just like putting a pause on things, saying, hey, let's put a pause, come back tomorrow, let me talk to Boggs. That's not what she did, Your Honor. She called the sheriff and backed up her decision, her half-cocked decision, with the force of the law. And at that point, my client and Mr. Jarman had no choice but to leave. She did not wait for Mr. Boggs to consult. She testified she couldn't get him. She should have waited to get him, put a pause on things rather than forcing them off the property. She even threatened, Mr. Jarman testified, she threatened to keep his equipment. She wouldn't let them come back. And he said, there's no way that's happening. I'm getting my equipment. And he testified he got his equipment that day. This news story about it took 3 to 4 days for them to get their equipment. That's not what Mr. Jarman testified to. And it's respectfully, that's why I asked these questions about Ms. Jackson's memory. I think that's a news story, and I'm not saying she's lying, I'm saying she's mistaken. Defendant acted recklessly by not consulting with Boggs before acting. You heard Mr. Boggs testify about what he told Ms. Jackson before the logging began. He said he gives a standard spiel to set her expectations, and the phrase he used was that there's ugly logging and real ugly logging. So he properly set her expectations, and he did his job. He was trying to be careful with her. Defendant hired Boggs because he's an expert and she's not. Rather than wait for Boggs to see if there's really a problem, defendant made a rash decision, demanded Jarman leave.
Hold on a second.
Yes, Your Honor.
I know who this individual is.
Oh, no.
I think we have somebody in the wrong place. The wrong place. Yesterday. He needs to be back at 1 o'clock. You can step out and tell him we're taking up criminal things action. And 1:30.
That's what I thought, but
And we had a criminal docket yesterday, and apparently this individual showed up, didn't appear yesterday, but showed up today, and I just didn't want him sitting there all morning. I apologize for the interruption.
I think you might find this interesting. Your Honor, all 3 experts, they were all qualified as experts, Mr. Boggs, Mr. Beasley, Mr. Jarman. All 3 experts agreed that the logging here was excellent. Most critically, Boggs, her agent, Mr. Jarman, who was logger of the year twice, and Mr. Beasley. The experts were unanimous, and the defendant did not offer any countervailing proof, despite efforts to do so. You heard about that. that there were no issues and this was a good site. This logging was done correctly and well, and that they went above and beyond. A couple red herrings I want to take on. This one landing area versus two issue that we've heard about so much. The key point here, Your Honor, is that regardless of what Ms. Jackson thinks, the testimony is clear that Mr. Boggs, on her behalf, agreed to have one landing area rather than two. And so that disposes of it. Rightly or wrongly, Mr. Jackson made that decision. He testified that he and Mr. Jarman agreed on this at the pre-harvest meeting. And further, the reason he testified that the reason he did it was he thought it would be a benefit to plaintiff, that the landing site on the west side was too close to her home site, and he didn't want her to be able to see that. And she had expressed concerns about the aesthetic aspects of this entire job. And so he made that decision. Again, rightly or wrongly, if there's a miscommunication between her and Mr. Boggs, that's between her and Mr. Boggs. But the proof was undisputed that Mr. Jarman and Mr. Boggs at the pre-harvest meeting agreed to have a single landing area. And Ms. Jackson's bound by the decision of her agent. Again, rightly or wrongly, that's an issue between her and Mr. Boggs. The stream, we heard a fair amount about that and the tops left in the stream. The proof showed that a week before the trial, defendant tried to get the state to come in on her side. She complained to the state. Unfortunately for her, this backfired because the state found no issues at all from Exhibit 17. There's no skid trails violations. The skid trails regenerated. There's no stream management zone violation. The streams did not meet the criteria for streams, and there's no stream crossing violations. There's no distinguishable crossing. In conclusion, they found that there were no water quality issues found at all. So that effort to obtain the backup of the state as a last-ditch effort to get an expert witness to countervail our three experts just did not work. Turning now to the damages we're seeking, you saw from the exhibit that Mr. Fox testified that he testified that he's calculated damages conservatively. Most critically, the damages would have doubled if he testified the damages would have doubled from that 48,000 if he had included the value add processing. Essentially, this is just green lumber without any curing or aging or processing that we calculated our damages based on. He testified it could have doubled, but we didn't do that in an effort to be more than fair to the defendant. He also testified he did not include any minor species. He also testified about this overrun issue and that the estimate was conservative on the overrun. Boggs testified that he estimated the volume of the green lumber in Exhibit 3, which was the prospectus, using what he called the Doyle method as an estimate. And Mr. Fox then testified that Fox Hardwood Lumber has years of experience of processing logs, that the volume has been estimated using that Doyle method. And then when Fox saws them, how do we compare versus that Doyle method? And he said a conservative estimate is that we get more lumber than the actual Doyle method estimate by 30%. And so that's a conservative estimate that we've used in our damages calculation. The court should also award prejudgment interest in this case. The Court of Appeals in the Schlotz 2000 case says that fairness will in almost all cases require that a successful plaintiff be compensated in the form of prejudgment interest, and there's no special circumstances here that would change that result here. So prejudgment interest should be awarded in this case. And we're requesting that the court award prejudgment interest at the 10% rate, which the Court of Appeals in the Doghouse 2014 case affirmed. They said, we've affirmed recent prejudgment interest awards at the statutory rate of 10% as being within the trial court's discretion. The court should order the return of the performance bond under Section 7. Mr. Boggs is holding that bond. Mr. Boggs agreed that Fox has performed all of its obligations under the agreement. The only remaining issues with this are because of defendant's improper termination, the tops could not be removed from the ditch. That's what Mr. Jarman testified to. This new thing about 3 days for Ms. Jackson is not something that Mr. Jarman said. What Mr. Jarman said is he was kicked off that day, removed his equipment, and never came back. And so he testified he did not have the chance to remove the tops from the stream. And respectfully, his memory and his credibility would establish that that was a fact. So there's no issues remaining on Ms. Jackson's property. Finally, Your Honor, we're requesting that the court award punitive damages based on conversion. So that's why I started with what Ms. Jackson did here was convert Fox's property to her own, because as of June 24th, 2019, when she stopped the logging, those trees were Fox's property. She had conveyed title to those trees to Fox, subject to defeasance, as I established in that first slide, only when the term of the agreement ended. And so that's a conversion. That's Fox's property that she took. And the court in the White Empire case, Court of Appeals from 2012, said that punitive damages may be allowed in a conversion action when the conversion involves elements of fraud, ill will, malice, recklessness, willful or conscious disregard of the plaintiff's rights. And I respectfully submit that there's both recklessness and willful or conscious disregard of the plaintiff's rights in this case. Recklessness includes the disregard of substantial risk under the Hodges case. Substantial and unjustifiable risk is disregarded. And here, the defendant was reckless at a minimum. She committed an intentional tort of conversion. She demanded Mr. Jarvin leave his equipment at first. She demanded the logging stop immediately. She knew she lacked expertise to make this decision. She did not wait for her expert, Mr. Boggs, and she enforced her threat with the power of the law. And as part of the punitive damages decision, part of what the court has to consider is deterrence and what message should be sent to the contracting community. And here there would have been a much better way for Ms. Jackson to deal with this scenario. Pause, consult with her expert, rather than call it off and make everybody leave. Let's get Mr. Boggs out there. Had she done that, what Mr. Boggs would have said is he would have explained to her, I told you about ugly logging and real ugly logging. This is normal. This, in fact, is a good job. Fox was very reasonable throughout this whole thing. If there's some accommodation that needed to be made to Ms. Jackson, we would have made it. Court can conclude that based on Mr. Fox's demeanor. She didn't do any of those things. She stopped it and she backed up her threat with the law, and the court should send a message to contracting parties to avoid disputes like this, that's not the proper way to proceed. Instead, pause, wait for your expert. Don't end it. Let's put it on pause and figure out where we are. So for that reason, Your Honor, we're requesting the court award punitive damages, and we're requesting the court do so as a one-times multiplier of our compensatory damages as shown in the damages exhibit number 14. Thank you, Your Honor.
Thank
Thank you, Judge. Can you go back up? Judge. So you've heard the proof, Your Honor, and we begin with the proposition that the contract was fully performed and completed as of March 6, 2019. The clear text of the contract, as we've discussed repeatedly, makes it clear that the extensions contemplated there are all referenced by their plain text, extensions for restoration. Now, in contract law, Tennessee case law has been a long-standing tug of war between a stricter textualist approach versus a looser parole evidence approach, Your Honor. Recently, though, the Supreme Court in 2019, the case cited in the defendant's motion for summary judgment, referenced the point that the Tennessee Supreme Court's made clear that parole evidence may not be used to contradict the clear text of plain ambiguous contract terms. Here, Your Honor, as we went down, and I'm pretty sure I frustrated everyone with how long it took, but Mr. Boggs and I went down line by line and clarified each and every point, both in Section 4 and Section 7, clarified the reference to restoration, and he even defined the difference between restoration and logging. That was from his testimony, Your Honor. Based upon that, it's clear that there was no extension in writing, and the provisions in 4 and 7 do not operate for an extension for pure cutting. In these, you can see where there is a reference to, in section 7 there, suspension of all logging activities, and then poor logging, multiple references in these provisions to logging. Yet, when we get to the operative extension provisions, the term used is restoration. And we are forced, Your Honor, based upon the existing case law and the plain text of this unambiguous contract, to defer to its plain meaning. And the plain meaning is that these extensions in 4 and 7 operated for an extension of time for restoration. It is immaterial what the spirit of the term was, because provision 18 of this contract includes a full integration clause, Your Honor. This was a fully integrated contract where the meaning and the full understanding of the parties is condensed to the 4 corners of this agreement. So because of that, attempting to read in the spirit of the contract or the ideas of it is beyond the scope. And I'll scroll down, Your Honor, when it is a fully integrated contract as the parties agreed per section 18. Now, from there, Your Honor, since sections 4 and 7 operate for extensions of time for restoration work and therefore inoperable, and because this is a fully integrated contract, and because it has been conceded over the course of trial, that despite all this discussion about things being extensions and delays because of hemp crops and wet weather and all these things, despite all that, the plaintiff has conceded that there were no suspensions called by Mr. Boggs at any point. So we, and throughout the course of the trial, we've heard repeatedly about the expertise, experience, and sophistication of the experts put forth by the plaintiff. Well, similarly, Your Honor, we have sophisticated logging professionals, and I have a 75-year-old grandmother of 15, clearly not of the same level of sophistication. Accordingly, plaintiffs, if the plaintiff seeks to rest upon the expertise and experience of these parties, then at the same time, these parties must be held accountable to the plain text and agreement that was entered into. So for those reasons, it's clear that the contract was lapsed. Now, you've heard testimony from Ms. Jackson that her agent told her there has been an extension. It was, there you go, it's been done. And then subsequently it was discovered that no such extension was completed between Fox, the plaintiff, and Mr. Boggs. Now, there's these references to, to this May 31st email between Mr. Boggs and Ms. Jackson, but no writing has been produced between the plaintiff and Mr. Boggs as required by the contract and those provisions. And even if one had been produced, Your Honor, as we discussed, going line by line with them, those contracts refer to additional time to complete restoration work only. So while Mr. Boggs is Ms. Jackson's agent, and any ambiguity should be construed against the drafting party, those terms are unambiguous. Mr. Boggs even circled around and clarified what was meant by restoration. So it's clear that by the plain text of the contract, there was no extension. But moving on from there, assuming that this honorable court finds that there was an extension through client's good defense overt action or some other exception, then we have to talk about that a little bit briefly. Looking at it, on the first turn here, let's see. Now, this is a case cited by the plaintiffs in their brief. That's the Rogers case, Your Honor. And here we'll go down as a general matter. Punitive damages are not available in a breach of contract case. They may be awarded in such a case under certain circumstances. However, an award of punitive damages is limited to, quote, the most egregious cases. as proper only where there is clear and convincing proof the defendant acted either intentionally, fraudulently, maliciously, or recklessly. And there's a citation. Your Honor. Your Honor, punitive damages wouldn't be appropriate here. Clearly, you've heard from the testimony. There's now a dispute about how long the Mr. Jarman was allowed to stay on the property after cutting was terminated. And you've heard the admonishments that Ms. Jackson should have waited to speak with her agent, Mr. Boggs. And clearly, my elderly client and grandmother of 15 was concerned, when she saw trees coming down all over the place and everything else, and right there next to her home and all that going on. Clearly, she was worried. You heard her testimony, Your Honor. She didn't just decide, well, I'm going to throw everyone off. While she testified that she called Mr. Boggs and was unable to get a hold of him. Now, it's a question for the court whether or not she should have waited, held off, but that doesn't show this intentional, reckless fly-by-night. She made that effort beforehand. Was unable to get a hold of him, and then went forward and made the call. Additionally, though, there's been this now dispute about how long Mr. Jarman was on the property afterwards. Well, the testimony is clear, whether it was a day, 2 days, 3 days, what have you. Ms. Jackson, after saying, I want to terminate this, she hadn't got a chance to speak with Mr. Boggs. After that, all the equipment, and Mr. Jarman testified about extensive equipment, was retrieved from the property. And as the proof showed, roughly 50% of the trees that were marked for harvest were harvested, and those logs were collected. And so, whether that was collected in 1 day or what have you, the client allowed access for that because the purpose was just to prevent, as she testified, any further damage. Now, after that, clearly the parties and efforts to resolve this broke down as happens. But a world where she threw everyone off and then tried to hold on to their property or resell these trees or anything like that, that would be different, Your Honor. But my client is, again, an elderly grandmother who tried to contact her agent, couldn't get a hold of him, and then gave the parties access to get what was already cut because her concern was preventing any further damage until she could hear what was going to happen and she could discuss it with her agent. So for that reason, based upon that, the rule enunciated by a case from the plaintiff's pretrial brief, clearly punitive damages wouldn't be accurate here. Now, assuming that this honorable court holds that contract was enforced either in law or in equity, then we get to a question of damages computation. I'll be here for a second. Move back here. So I'll be going back and forth between slides, Your Honor. Firstly, we get into a question about computation damages. Your Honor, while cross-examining Mr. Fox, you heard the testimony where there were some issues with the estimate and exactly how his estimates were derived. Turning now to the Rogers v. Lewis the Wagner case. This similarly is another case that is cited by the plaintiffs in their pretrial brief, Your Honor. Of significance is this paragraph right here. Expert opinions or estimates of lost expected profits must be based on objective facts, figures, or data from which the amount of lost profits may be reasonably ascertained. Going down. In addition, the expert must employ recognized acceptable methodology and must apply the methodology in a proper manner. If an expert relies on unreliable foundational data, any opinion drawn from that data is likewise unreliable. By the same token, an expert's testimony is unreliable even when the underlying data is sound if the experts employed flawed methodology or applied sound methodology in a flawed way. Turning over here, you remember our testimony, Your Honor. Mr. Fox testified that with his 40 years of experience and experience in the logging industry and his expertise, that the average yield on from milling timber into lumber varies based on various variables, one of which was the species of the tree, whether it's hardwood, softwood. He testified that. But then I asked him about his numbers. mentioning that the board feet of timber divided by board feet of lumber was roughly 7.69%. An easier way to look at that, Your Honor, is this right here. Looking through here, we have a simple Excel spreadsheet where you can see the formulas listed, the board feet of timber listed on the damages estimate, clearly by Mr. Fox, and the board feet of lumber. And you can see, regardless of species, the average, we simply have a multiplier of 130%. All that was done here, regardless of species, across the board, Your Honor, was that they took the board feet of timber and multiplied it by 1.3. Despite his testimony that the yield from milling timber is going to be vary based on all kinds of factors, including the different species employed. That was an issue, Your Honor. Turning back over here, moreover, similarly, we continued our cross-examination, and I asked him about how you could get more board feet of lumber without, then you start with original timber. And his answer, I asked it many times in different ways. His answer was that, well, very intelligent people have figured out how to make things more efficient, and that's just how it is, and that's just, where it's gotten that, people have just figured it out. And that's critical, Your Honor, because Mr. Fox was unable to enunciate how we get to this number. And his explanation was that other people had figured something out, which means that he was unable to testify from his own experience. And as such, he should be disqualified as an expert witness and that testimony disregarded because he was unable to explain his methodology or how it happened, simply relied that other people did it and was unable to explain it to the court. Additionally, as we continue down, Your Honor, he had his logging.
Referring to him testifying about why he can obtain more lumber or more boards out of that. You understood that what he's saying is that if you had, most people use a thicker saw and it creates more sawdust. His method went to a thinner saw that created less sawdust and therefore they got more boards. It is a simple procedure, a simple idea, but you have to have a great deal of volume for it to show any sort of difference in the recovery. That's the way I understood it. Is that not the way you understood it?
No, Your Honor, particularly when I circled around on recross and I asked him, well, to simplify, could we explain the average yield? So what percentage of a log becomes lumber? And he said he was unable to do it. And and that was critical. That was one of the last questions I asked. And I specifically used the word that I didn't require scientific precision. Didn't require precision. He could give me a rough estimate. And he said he was unable to estimate the utilization rate on a log. And that's critical for Your Honor's consideration as well, because if he's unable to give us the utilization rate, conversion rate, what percentage, even roughly, even an estimate of timber gets converted to a log, then how can we rely on these numbers? They're unreliable, and based upon the Wagner case, should be disregarded. And just additionally, moving on, Your Honor, briefly, also we had testimony here that the logging was 220, he estimated at $220 per 1,000 board feet, which comes out to 22 cents per board feet. And this was after Mr. Jarman immediately testified before him. That was the witness that he called before him, that Mr. Jarman was compensated at a rate of 26 cents per board foot. Now, as a percentage, that's tremendous. Again, it would be very simple to look at that. And so clearly that doesn't line up with Mr. Jarman's testimony. This was just a ballpark. And again, the logging estimated cost is the same for every species, despite his testimony about variable costs depending on species. And again, lastly, Your Honor, sawing, similar situation. We have one number across the board, despite his testimony, that that there is variation, whether something's a hardwood, softwood, different species. Clearly, this does not meet the requirements promulgated by the Wagner case that was cited by the plaintiffs in their brief. As such, during his testimony, I asked, to the question of whether or not the estimate from Mr. Boggs as to the fair market value of the timber, the $33,000, the question is whether or not he thought that was an accurate estimate for the timber. He agreed. Based upon that, clearly, Your Honor, with all these issues and with his estimate failing to meet the standard enunciated by the Wagner case, his estimate should be disregarded, leaving us with the only remaining estimate that we have, which he testified he thought was a fair estimate. That's the timber value estimate promulgated by Mr. Boggs. Now that estimate here, let's see, I could pull that just as a reminder for the court. That was right there. Now, Mr. Boggs, we clarified that he had included this 6,600 at the request of Fox Hardwood, but his estimate for the fair market value of the timber was at $33,184.66. So, with the numerous issues with Mr. Fox's damage estimate, Your Honor, and his testimony that his belief this was a fair estimate of the value of timber, we're left with this. But wait, the goal is to make the party whole. So if the contract, this honorable court finds that the contract was in full force and effect, and my client was liable for the remainder, then we take the $33,000. However, we simultaneously have to take into account the variable costs that were avoided, though. And based upon this, from Mr. Jarman's testimony, that we had that he was to be compensated at 26 cents per board foot, the same estimate provided by Mr. Boggs, I'll slide back to that real quick. The same estimate by Mr. Boggs listed a remaining board footage of 73,743. Is that right there, Your Honor? So we have that sliding over here. So the cost to timber, to cut this timber, if we have the 33,000, that we would have to deduct the cost to collect it, though, that Mr. Fox would have incurred. And 73,743 board feet times 26 cents per board foot comes to $19,173.18. Therefore, if this honorable court finds that the contract was still in full force and effect, then the appropriate measure of damages would be the fair market value of the remaining timber as estimated by Mr. Boggs, less the total cutting cost of there. So it'd be $33,184.66 less the $19,173.18 in cutting costs that were avoided due to the breach, resulting in net damages of $14,011.48. Based upon the foregoing, Your Honor, I respectfully request that this honorable court find in favor of the defendant, Ms. Jackson, and hold that the contract was either lapsed as of March 6, 2019, or in the alternative, that the testimony by Mr. Boggs, by Mr. Fox fails to meet the Wagner standard, and therefore, with the only remaining credible sources for damages estimation, that the damages owed are $14,011.48. Thank you, Judge.
No rebuttal, Your Honor.
Folks, I don't really intend to take this under advisement. I'd like to take some time to go through the exhibits, and then I'll give you my opinion. It may take me a little while, but hopefully I can resolve this before lunch. So we're going to stand in recess until I can come back and give you my opinion.
All rise.
Whenever the court makes a decision as a trier of fact, I'm reminded of the instructions we give our jurors that we're not required to set aside our life experiences and can use our own common sense and our own life experiences in reaching a decision. That's what jurors do, and as a trier of fact, that's what's required. Court is required to do, and I say that only because, as the owner of a farm here in Dixon County I've had timber cut on my property, I'm well familiar with the effect that cutting timber has on the property. And there's simply no way that you can cut timber without having some damage to the property. It's just a matter of how it goes about. Some people do it in a different way than others, but in any event, first issue that deciding this case that I'm required to look at is whether or not this contract was enforceable at the time of the commencement of the cutting, or whether or not in the pleadings that the defendant has filed, they allege that the contract had expired and that there was not a proper extension of the contract because it was not in writing. First and foremost, I would state that Ms. Jackson desired to sell her timber on the property. I understand she says now that her idea was to clean it up and make it easily accessible for her children, but that would have required a completely different kind of a situation than what she entered into. What she entered into was a sale of timber of a substantial number of trees in her property. She was not an expert by her own admission in logging, and as an expert, as not being an expert, she did what a lot of people don't do, but was a wise thing to do. She engaged an expert forester, Mr. Boggs, to assist her in marketing her timber. Now, it's this court's opinion that listening to her testimony, she probably had an unrealistic idea of what effect this select cut timber cutting on her property would have on the property as a whole. But in any event, she hired Mr. Boggs as her agent, and that's important for the entire consideration of this court in this case. Mr. Boggs went out, inspected the property, marked the trees. He had questions about the survey on the back, or the line on the back side of the property, so he did, on her behalf, engage a surveyor to come out and run that line so that they would be sure that they were complying with the proper survey. The timber line, or I'm sorry, the property line when they were cutting the timber. And then he prepared a statement to her that basically indicated what he thought the property was worth. Gave her an email that she may or may not have looked at, but in any event, he emailed her to tell her what he thought it was, and he put it out for bidding for that purpose. And in doing so, the bid that he put out clearly showed what the terms and conditions were of that. And under Section 8, it had of that property, of that bid, rather, the offer to bid the property for sale. It's the Diane Jackson Timber Sale Notice is what I'm referring to, what's been marked as Exhibit 3, and it gives a great detailed explanation of it and so forth. Prior to that, what he sent to Mrs. Jackson, Mr. Boggs, indicated that he thought there was about 564 trees that could be sold. So there was a substantial number of trees that we were talking about, not just a few here and there to clear out place for her grandchildren, but rather a significant number of trees were going to be sold as a part of this agreement. And it was going to result in a significant payment to her. He had estimated in his original statement to her around $50,000 for the value of the tree. In any event, the Exhibit 3 that was introduced was the bid notice, and it showed on the terms and conditions of sale certain conditions, and those conditions included that upon number 6, upon completion of all logging operations or assumed thereof as conditions permit, the purchaser shall smooth ruts created by the purchaser out of all existing and newly created skid and truck roads, and the log landings must be cleared of all debris related to the logging operation, smoothed and seeded. The purchaser agrees to install water diversion in accordance with Tennessee's best management practices suggestion to prevent erosion and water quality issues. Details about restoration will be outlined in the timber sale contract. Nowhere in that bid notice does it say that tree tops will be removed and that there will be an opening of the forest to where it would just be an open area. It basically says that they'll remove them from the tree, from the roads and from the property lines and so forth, but it doesn't say anything about cleaning it up beyond that. In the contract, which was again drawn by her agent, after the sale went to Fox Hardwood as the plaintiff and they were the high bidder, Mr. Boggs, as her agent, prepared this contract. That contract's been marked as Exhibit 7, and it provides all of the timber and so forth. It also provides, I think, the purchase price of it, which is some $63,000, if I recall correctly, total, but, and required a $2,500 performance bond to be posted. Of that, Ms. Jackson was paid $55,000, according to the proof in this case. She received $55,311.60 under that contract for the sale of the timber. Mr. Boggs, as Arbor Springs Forestry, got $7,812.40, reflecting his 10% commission plus a $1,500 survey reimbursement. Arbor Springs Escrow was given a check for $2,500, which is one of the issues that we still have to deal with. Now, again, looking to the contract, what are the requirements for the condition of the logging and what kind of damage can be permitted to it? There's nothing in the contract drawn by her agent that says anything about damage to the property other than paragraph 8, which states, similar to what the bid notice was, upon completion of all logging operations or as soon thereafter as conditions permit, the purchaser shall smooth ruts created by the purchaser out of all existing and newly created skid and truck roads, as well as have all tops and logging debris cleared from the skid trails and field areas. Log landings must be cleared of all debris related to the logging operation, smoothed and seeded. Purchaser agrees to install water diversion in accordance with Tennessee best management practices, suggestions to prevent erosion and water quality issues. Refer to Guide to Forestry Best Management Practices in Tennessee. Purchaser agrees to restore any truck or skid road to as good or better condition as existed prior to entry by the purchaser upon the premises. Purchaser agrees to repair all logging damage to roads, ditches, trails, or other improvements to as good or better condition as existed prior to entry of the purchaser upon the premises. All tops and logging debris will be left at a reasonable height from ground and no trees left hanging or lodged in residual trees upon completion of logging activity. The haul roads will be in existing pasture and must be smoothed and seeded upon completion of their operation. Purchaser shall notify the seller or seller's agent of the purchaser's intention to complete the restoration work as described in paragraph at least 48 hours prior to completion of such restoration. So, nothing in here that indicates that there was anything other than the normal or best practices, best management practices that was going to be adhered to in the logging. As a result of that, that is what the plaintiff in this case was operating under, the best management practices of the state of Tennessee as set forth in that manual that's been made an exhibit in this case. The contract provided for a term of 1 year. So when we look at the contract's terms, the defendant has argued that there had to be an extension in writing, and that because it was not an extension in writing, it was already elapsed at the time that the logging began. I disagree with that analysis. The term of agreement is in paragraph 4, and it states it'll be in full force and effect for a period of 12 months, beginning 3/6 of 18 and ending 3/6 of 19. An additional 6 months may be granted if seller's agent is notified in writing within 30 days of expiration date. There's nothing that says that the actual extension has to be in writing. The contract only required that the notice be in writing. And as was pointed out, our case law clearly states that the agent for the plaintiff in this, or for the defendant in this case, Mr. Boggs, had the full power and authority to waive the requirement of a written notice of request for an extension, that he had that right, and the proof has been clearly established that Mr. Boggs was the person who probably first sought the first extension over the hemp product, hemp that was being grown in that particular time of year, and that that was the first reason for the extension, and that the second extension was agreed upon because of the weather delay. And there's no question the proof is established that we had an extremely wet winter, and therefore it would have been substantial damage to the property. As clearly was established by Mrs. Jackson's testimony, damage to the property was a major concern to her. That was why she stopped the logging, because she believed it was damaging the property. And as a result, if that was her concern, then clearly having ruts and trucks miring up and destroying her fields and destroying the property would have been even more damage than what was created by the actual logging itself. So proof is that there was an extension given to her by her agent to Fox Hardwood for the completion of at least a 6-month extension. And as a result of that, when the commencement of the logging in June began, it was maybe past the expiration of the first original term, but it was clearly within the extension that had been granted and had been consented to by Ms. Jackson by the proof in this case. She allowed the logging to commence in June, and after only a couple of days, stopped the logging, but it began within the period of time that was within the extension that was granted by her agent and consented to by her. So therefore, I find that the contract was in full force and effect as of the date of the commencement of the logging. So I do not find that the defendant's argument that the contract had expired and that there was no valid extension, as I started to say, and I may not have completed, our Tennessee law does provide that in such cases, some provision of a contract regarding written notice can be waived in the appropriate situation. And clearly that was waived and was consented to both by her testimony and by her actions in allowing the commencement of logging after that original 12-month period. So after that point, and as to that point, rather, the court finds that pursuant to the terms of the contract in June of 2019, when the logging commenced, the contract was in full force and effect, and that the timber that was standing there that had been marked belonged to Fox Hardwood. Again, this is there's two ways you can do it. You can basically say to a logging company, come in and you go in there and you pick the trees, you cut them, you take them, you market them, and then you write me a check. That's typically how sometimes smaller operations will operate. Not many operations, smaller operations have the financial ability to write a substantial check on the front end, which is what happened in this case. So as a result, when they wrote her the check for the entire purchase price of all of those trees, they belonged to Fox Hardwood. Ms. Jackson stopped the logging on the second or third day because she became concerned about damage to her property. Again, I believe that was, well, her testimony. They were taking out a huge number of trees and a huge machine that was in there doing it. There's no way they couldn't be damaging the property. She had no prior experience. She was not an expert. She had no knowledge of what the effect of clear cutting timber would have on that property. And under the terms of the bid and supplied by her agent and the terms of the contract specified what the logger's obligations were to comply with the best management practices. And every expert that testified in this case, including her own agent, Mr. Boggs, testified that the logging that was done at the time she stopped it had been done in compliance with all of the best management practices, that it was done in an acceptable manner. In fact, I believe it was described as being excellently done. And as a result of that, the court finds that there was no justification for Ms. Jackson in stopping the logging operation. By doing so, she breached the contract. As far as the tops across the creek, the court's finding is that it was not necessarily a standing or a constant or perennial creek, as we might call it. It was, by the report of the Tennessee Department of Agriculture, not even a intermittent creek or what we call a wet weather creek. It was just a low area that did collect water from time to time. But in any event, the proof in this court that this court finds is that the treetops that were placed across that ditch, if you want to call it that, or creek, whatever you may want to call it, there by Mr. Jarman, the logger, would have been removed by him had he been permitted to, but the proof is he was not given that opportunity to remove the property, to remove that and clean up the property. So clearly, therefore, and as a result of that, also the court finds that the Department of Agriculture's report that was initiated by Mrs. Jackson herself finds that there was no damage to the property. So it becomes then incumbent upon the court to find that Ms. Jackson has breached the contract, and we move to the issue of damages. Mr. Massengill has argued that Mr. Boggs, her agent, prepared an estimate of the value of the remaining timber, and then he shows that we should have taken the cost given by Mr. Jarman for cutting the trees to reduce the damages down to $19,000. By doing so, I think if you accepted, even if I accepted what Mr. Boggs says, this was done in an idea back in September of 2019 to try to buy back the remaining trees. And that's a different classification. The effort to buy back the remaining trees from her and leave them standing is a different matter than what the plaintiff in this case had envisioned by entering into the contract, and that is to make a profit off of the milling of those trees. The $39,821.59 that Mr. Boggs estimated included a 20% incurred for interest, loss of work days for logger, and a profit margin. But again, that is Mr. Boggs's estimate of the value to buy back the trees, and is not the same as what the damages that the plaintiff is seeking in this case. And those damages were set forth in Exhibit 14. And according to this court's finding, Mr. Fox, I've observed all of the witnesses testify very carefully, and we have 3 different experts that testified. But Mr. Fox testified as to his experience in the logging industry, and I was impressed and informed by a lot of what he had to say, and it makes perfect sense to me about the way that he can increase the margin of production for timber, or rather boards out of timber. And based upon everything that I have observed in this case, it is my opinion that Mr. Fox and his testimony is compelling regarding the actual loss to the plaintiffs in this case. And the fact of the matter is that those damages were established at $48,838.57 by the Exhibit 14 in this case. So that is the measure of compensatory damages that the court finds. Second thing is that under the Tennessee law, because this was a breach of contract, that I found that Mrs. Jackson was not entitled to breach, was not justified in her breach, then the prejudgment interest of 10% is required to be applied. Then I moved to the issue of punitive damages, and as Mr. Massengill has correctly pointed out, there is a much higher standard in a contract case for the application of punitive damages. Ms. Jackson acted, in my opinion, more out of lack of knowledge and experience in her concerns regarding the damage to this property, rather than out of malice or out of intent or out of recklessness. It can be argued she acted recklessly, but she said she tried to contact Mr. Boggs, but she wanted to stop it. Folks in the country don't always know the best way to do things to stop something from happening if they're objecting to it, or implying or contacting the sheriff's department. May not have been the best practice, but I don't find that to be malicious. And in my opinion, this is not an appropriate case for the application of punitive damages. So therefore, the court declines to award punitive damages. The award of judgment against in favor of the plaintiff against the defendant is $48,838.57 plus 10% prejudgment interest. Anything further?
Your Honor, the return of the bond.
The $2,500. Thank you. The $2,500 performance bond will be returned to the plaintiffs.
And then the date of the prejudgment interest, would that be June 24th of 2019?
I'm sorry.
The date from which we should run the prejudgment interest, would that be the date of the breach?
Yes.
Okay. Let me just check.
June 20th, 2019.
June 24th, I think, was the date she stopped logging. That's it, Your Honor. Thank you.
Down below, you'll draw the order submitted to Mr. Massengill for his approval, please.
Yes, Your Honor. Thank you.
I take no pleasure in doing this. I understand Ms. Jackson's grandmother of 15 grandchildren, and I know this is an economic bombshell to her to have this happen. But Mr. Fox correctly pointed out, if we don't enforce contracts, if we don't honor the obligations that people have entered into, then our courts mean nothing, our laws mean nothing. So it is this court's opinion that I've done the only thing I can. I regret that it may cause problems, but again, it's no more unfair than having Mrs. Jackson receive the entire $55,000 and retain the timber and keep Fox Hardwood from being able to get the trees that they have purchased. So that is my ruling, the best I can do for you folks, and now am adjourning court.
All rise. Court's adjourned.